Good morning and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us. You can tell it's a Monday when our disclaimer is not on course. So thank you guys for joining us. We're continuing our coverage of Suni Bell. All right, let me turn down my audio here a little bit. That seems a little hot. Yeah, boy, my audio is really hot. Let me turn my audio down a little bit. Let's try this. All right, let's go with that. How's that? That seems to be a little bit better. Let's try that. All right. All right, so we're continuing our coverage of the Suni Bell shooting trial. Why is my audio so hot? Holy smokes. All right, let me go with that. Is that any better? We're continuing our coverage of Suni Bell trial. All right. Boy, my audio is like hot. All right, I think that's a little bit better. Let's do a little testing. Let me go with that. Is that any better? We're continuing our coverage of... All right, I think that's a little bit better. All right, blowing out your speakers here in the first morning. Talisha, you're from Hillsborough County. Thank you for covering this trial. No problem, Talisha. Thank you for joining us. Superstar, good to see you. Thank you for joining us. Barry, good morning to you. Sam's stream the other night was so educational as to the process. I encourage all the chat to check it out. Edward, good morning to you. Richard in the kitchen, good morning. Good to see you. Tammy, good to see you. Thank you for joining us. Selena K, good to see you. Phyllis, good morning to you. Alicia, the armchair detective, good morning to you. Brenda, good morning. Woke's joke, I hope it finds you doing well today. Brett saying good morning. Let's see. All right, I think that's... that covers just about everybody so far. So before we get started, where is Sherry? Sherry, are you in our chat here? I thought I saw Sherry. There you are. You're going to shower, get ready to watch. Okay, so Sherry sent us some barbecue sauce over, and we received it over the weekend. One was with bacon and one was without. And Sherry, we've already gone through like half of it. I put it on some tofu yesterday. Aaron put it on some chicken. I actually put it on some salad, which, trust me, it makes a really good salad dressing too. So Sherry, just wanted to give you a shout out for the barbecue sauce that you sent over. Really, really very tasty. So thank you for that. All right, Let's get over here because they usually start pretty much close to on time at 8:30. We're expecting an 8:30 start. We're expecting an 8:30 start. Vivith, good morning to you. Daisy Jane, it's a nice fall day in North Georgia. I'm sure it is. Tim Pace, good to see you. Thank you for joining us. Aussie Gardner, hello to you. Be sure you hit the like button on your way in, please, and thank you. Oh, let me put myself on screen here. Where am I? There I'm. Put myself on screen. So, the state rested, and the defense is going to present their trial today, or their case in chief, I should say. So, when we left, we were going, Zavante Sampson was considering testifying. We weren't sure if he was going to testify or not, so he's still perhaps could testify. And then Quandarius, so Zavante was the driver of car one, and then Quandarius was in his car. So he said he was going to depend on what Zavante does, if he was going to testify or not. So, and then there was also a Miss Boyd. There was a crime scene technician, Boyd, that was going to possibly testify. So there's a lot of things up in the air. The state rested. They went through 22 witnesses, with the ME was the last one. Beat Killa, good to see you. Prayers for baby girl Sunny. Absolutely. Deviant, good to see you. Thank you for joining us. Red Snap, good morning to you. So we're still waiting to see if Zavante is going to testify. We're still waiting to see if Zavante is going to testify today. That's really the big question. Will he testify? So we're waiting to hear. And it was Danny Rodriguez, his lawyer, that was going to let us know. And also, they were going to bring a crime scene technician. Boyd was her last name. I didn't catch her first name. I think he just said crime scene technician Boyd. Yep. So crime scene technician Boyd will be Monday or it will be never. So they're going to be resting. If Zavante doesn't testify, then they're going to rest. And each side's going to get an hour and a half for closing. Now, several of the defense says that they won't need the entire hour and a half, but obviously 5 defendants, each one gets an hour and a half. It's like 7 or 8 hours. So the judge and the state gets an hour and a half too, but they're going to split it. So it looks like we got a feed. What's up? How you doing, Beat? Good to see you. Hope you had a good weekend. Hope it was peaceful and restful. Lazy boys, did they do the VOA? You're talking about the JOA, the judgment of acquittal. They did that. Yes, they did that on Friday. So it's up. It's the defense now. Everything. The judgment of acquittal was done outside the presence of the jury, but the state rested in the presence of the jury, and now we're just waiting to see if the defense puts on a case. Interesting captures. Good morning to you. Thank you for joining us. Alice saying good morning. Hope you guys had a good weekend. All right, we've got a seal. Let me get in here. Hold on a sec. All right, so it's the thing today is, will Zavante testify? That's the big question. He said he might, and then also Quandarius. So Zavante was car one driver, or the driver of car one, and Quandarius was his passenger. And if you remember, they went over all the groupings on Friday. The state went through all the groupings and where all the casings were. Nicola, good to see you. Good morning. Trixie saying hello. Yeah, okay. Or is it just yeah, okay. Good morning to you. Yeah, there's no just yeah, okay. Richard in the kitchen, everybody's team won. Oh, yeah, your Cowboys nearly gave you a heart attack. Didn't they win in overtime or something? I saw that. It looks like we got some audio here. Hold on. All right, let's see if we can listen in. Sounds like maybe just hot mic moments. Sounds like they're talking weather. All right, so yeah, the big question is going to be, will Zavante testify, and then will Quandarius, and if they both testify, it's not going to be over. This will definitely be going into tomorrow. The only way I see this going to the jury today is if nobody testifies and they just go straight into jury instructions and then closing. Hello, Amanda. Good to see you. Trixie saying good morning to everybody. Yes, we love a hot mic. Sounds like they were talking weather. So let's see. Yeah, state rested. We're just waiting for the defense to decide or tell us. Is Zavante going to testify? And then Quandarius says it's up to Zavante, or he's going to wait and see what Zavante does. And then the defense was mentioned a crime scene tech, Miss Boyd, and that was Brian Gonzalez, who represents Zavante. So we're going to see. Closings will take most of the day. This is what the judge says. Wouldn't want to push it if it's after lunch. Have them come back Tuesday. If by 10 the defense has testified, then we'll have an early lunch. And the state is going to go an hour and a half, and the judge will give an hour and a half for each defendant. But they said, their representative said, we're not going to need an hour and a half. Their openings were not an hour and a half. Their openings were maybe 15 minutes, 20 minutes. Their openings were not long. So I don't know, maybe their closings will be a half hour or so. I think usually closings are a little bit longer than openings, usually. Amanda, hello there. Hope you, Aaron, and the kiddies had a good weekend. We did. We streamed UFOs. We did the congressional hearings over the weekend on Saturday. If you guys are wanting to watch something completely different, there was 3 congressional hearings, 23, 24, and 25. So we showed all 3 of them. The most recent one was just last week, like last Tuesday, I think. So we showed that, and then Sunday we were just relaxing. Cindy, hello and congratulations to the Saturday chat crew on a successful mission and safe return. Beat says, right, and that's a hangout spot. They act like they were there to plot a murder, and that's not the case. Well, the state is you're right. The state is saying they hunted Willie and Mary and Sonny down. So Beat, it's up to the defense. Defense has to bring it. Defense has to just get one person just to say no, reasonable doubt, and there is room for it. The 2 things I think, Beat, that are going against the guys right now is that all their phones except Andrew's pinged like right in the area. Andrew was at least on I-4, so he was a little bit away. And then James's 2 casings, his 2mm casings were found. So that's not good if you're for the defense. Those 2 things, I think, that's not good. So for the state, they're going to hammer that home. They're going to hammer home, hey, these guys got in the car. We saw them get into the car. They admitted getting into the car. James sold his 9mm. But all their cell phones pinged except Andrew's. Andrew is the only one. His cell phone didn't ping in the immediate area. It was a little bit away, but still close enough. I think James and his 2 casings, that's going to be tough. That's going to be tough. Because how can you argue? I mean, that was his number 1 carry, his words to the detective. That was his number 1 carry. He never loaned it to anybody because he said people do stupid things. And so that one's going to be a tough one. But the defense they got to get reasonable doubt. Coast only counts in horseshoes and hand grenades. Yep, Lizzie says. Amanda, I'm still erring on reasonable doubt at the moment. I'm not sure the state has a solid case. Little Lulu saying good morning. Beat saying like a link-up spot before we go to the club or casino or whatever the entertainment is. Sure. Yeah, I mean, we did the same. Outsiders looking, don't know nothing, so I'm let people assume. Well, no, I appreciate you telling us from the inside, Beat. Keep dropping knowledge. We appreciate it. Jim says good morning to everybody. Aussie, yeah, we all meet where we would meet our mates. Yeah, I mean, it's either at somebody's house or it's at a school or it's at a parking lot or wherever it is, depending on where you are. But, yeah, I agree. Let's see, we took some polls. Let me see, what did our polls show us on Friday? Which side does the confusion this trial raised work better for? I'm too confused to answer, was 45% of us. 34% said that helps the defense, and 20% says the confusion helps the state. Let me see, what other polls did we take? We can take some more today after closings. Who should take the stand for the defense? All of the defendants, 65% said. None of the defendants, 20%. The passengers / alleged shooters would be 9%, and the drivers, 5%. Good morning, Kathy. Good to see you. Yeah, I mean, if they all 5 got on the stand and said, you know, whatever it is they said, meaning that guy was shooting at us, he was bad news, but then that would admit that they went after him. So I guess if they go on the stand, they'd have to say, no, we just took off. You know, he was bad news and we just took off. You know what I'm saying? Amanda says she appreciates your comments, Pete. So yeah, so it's state is going to hammer home. The boys went after, they hunted down Suni, and then the defense has to say, hey, they weren't anywhere near. They just kept driving. So, Phyllis, I watched the recaps and videos. Apparently the second car was accidentally destroyed and the occupants haven't yet been identified. Yes and no. They have identified 2 of them. I think it was Jalen's brother, Maxwell, I think that was his name. He was the driver of car 2, and then somebody else got in. They only mentioned his name once, so I don't remember his name right now. But it was Detective Saleha said they didn't have enough evidence to charge him. So they didn't have enough evidence to charge them. Hey, Joni, good morning to you. I see Pammy is in our chat. Good morning, Pammy. Pammy, I feel like I was going to say, how was your weekend? But I already know. I already know. So if they were to take the stand and they all had the same story of like, yeah, this guy was bad news. He came into our space, our hood, our area, whatever you want to call it, our meetup. He was there. We saw him. He just was bad news. So we took off. We just didn't wanted to have anything to do with him, and we just took off. That's one thing. The only thing is James's his 2 casings. That's what's getting me. You know what I'm saying? That's what's getting me. Spicy Kitten saying good morning, and Iowa Backyard, good morning to you. Like, I just keep going back to James's 2 casings. That one's going to be tough. But all that being said, there were 4 separate 9mm casings found, 4 separate ones. So they're saying Quandarius had 1, James had 1. So where are those other 2? Where were those other 2? They must have been in car 2. Pammy, you're much better this morning. Good. And then Andrew, they're saying had the assault rifle. So it's a confusing trial, and that I think will help the defense. I think that will help the defense, because the state has to really, make it clear and concise. And they will. They're going to do the best that they're going to say. These guys got in the car, they hunted down Suni, they shot, all that stuff. And then the defense has to be like, well, yeah, they admit getting in the car, but you can't prove anything past that. Terry H., good morning to you. Aussie will be back in a minute. No problem. Saudi Girl, good morning. Just want to thank you for the alien space effects and vlog connection. I didn't know he has a channel too. Yep, I hope it's okay to say that on your channel. No problem. No problem. Yep, we like Alien. He's good. He's a cool dude. Also, Iowa Backyard has a channel as well if you guys want to watch backyard cams of squirrels and deer and sunsets. So that's a cool place. Beat says if it helps the case, they should. It's always dicey when a defendant takes the stand, Beat. You know what I'm saying? That's always like, we always want to see it, but it's always, because on cross, they just get hammered. They just get hammered. Sherry says, I might have missed it, but do we know the age approximately? Yeah, I think they're in their 30s to 40s. That's what I heard. I heard they were in their 30s to 40s, but we'll have to get, we can, we can confirm that later. And birds, lots of birds, yes. Squirrels, raccoons, deer, sunsets, and birds. Lots of birds. Amanda, confusion will definitely make solid verdicts very difficult for the jury, leaving reasonable doubt. Absolutely. Joanne Jedi Platypus, good morning to you. I hope you are feeling well today. Trixie, our cats love the outdoor cam videos. Nice. So usually they start, excuse me, usually they start pretty close to 8:30, so a lot of activity. So I wonder what's up. And this was supposed to be a 10-day trial. That's what they were shooting for, a 10-day trial. Clearly that's not going to be the case. So who passed away in jail? Who passed away in jail? Beat saying he passed. Did you say somebody passed away in jail? Who's that? Oh, Maxwell? His brother passed away in jail? Wow. It was Maxwell, right? Is that his name? Maxwell Bedward, wow. Car 2 could be Maxwell Bedward, Devin Sampson, Kamani Bedward, and Cedric Brown. Holy smokes. He couldn't have been that old, right? How old was he? That's terrible. Sorry to hear that. How old was he, Pete? And Joanne, good, you're feeling better. Good. Glad to hear that. Prayers for Max. So card 2 could be Maxwell Bedward, Devin Sampson, who is Zavante's brother, Kamani Bedward, again, another brother, and then Cedric Brown. That's exactly what he did. So how old was he? Pete, how old was Max? Passing away from a heart attack just sounds like, right? Because isn't Zavante's like 30? So car 2 couldn't obtain sufficient identification to charge them. There wasn't enough evidence for car 2, even though they think they know the people. They know Max was driving, and then Devin Sampson, Kamani Bedward, also another brother, and then Cedric Brown. Saudi Girls saying, Iowa Backyard, I think I subscribed to your channel. Are you Iowa Backyard Farmer? Sorry, didn't mean to pull that up. Cindy, musical tidbit. 43 years ago, Queen played their final U.S. Concert with Freddie Mercury. God, 43 years ago. Sally Starr, good morning from Sacramento. Thank you for joining us. Appreciate it. Iowa Backyard Cam. If you guys want to go check Iowa Backyard Cam out. If you need to get away from trials, it's always a nice place to go. And you have tons of shorts as well. Cool. They didn't hunt down Sonny. They were after Willie. Yeah, I mean, who's going to hunt down a 4-year-old? You know what I'm saying? No 4-year-old is going to deserve, is going to do anything to make you upset like that, you know? So, but that's not what the state's going to say. That's, you know, well, at least that's in the openings. That's what we heard. The state's like, they hunted her down, you know. That's what they're going to do. They're going to play on the emotions of the jury. You know, that's their angle. As much as it's you know, tough to hear, that's what they're going to say, because they're going to play on the emotions of the jury. Jenny, good morning to you. Good to see you. Thank you for joining us. Whoa, how about them Bills? Richard, Max is 32. He was born in 93. Okay, thank you for that. So he had a heart attack at 32. Huh. Right? That's just, that just seems odd. Oh, you know what, you guys? I wanted to also thank you for helping us get to 15,000. We're at 15,020 subscribers, so really appreciate that. We hit that on Sunday, right? Saturday? Yes. Sunday, yeah. Sunday we hit 15,000, so appreciate the support. Thank you, guys. Really appreciate it. And Sherry, I don't know if you heard earlier, but we used your, guys, Sherry made some barbecue sauce for us. And one was bacon and one was without. So Aaron used the bacon. Yeah, Aaron put the bacon one on some chicken. And then I put the other one on, the non-bacon one on some tofu. And then I put it on some salad. And it was really good as a salad dressing too. None of you guys are 40. You guys are young. 35 and under, yeah. That's crazy though, man. That's a heart attack. I'm always suspicious of that. Heart attack in jail at 32, right? That's when it's like that. All of a sudden, my you know, my suspicious radar goes up. Theodora, I think the jury will either take a long time to deliberate given the number of defendants or come back in 30 minutes. Why did they combine the 5 defendants into one trial? A lot of that had to do with, I think, just the economy of it all, meaning it would have cost the taxpayers, you know, that much times 5, whatever it is now, it would be 5 times more expensive. And then just to streamline it, finding a jury 5 times over, you know, I think it was just more the economy of streamlining it. But we can talk about that after the trial's over. We can definitely talk more about that. Let's see. I'm taking your questions and I'm putting them into. We can definitely talk about all your questions, you know, in more depth afterwards. Phyllis, anyone know about the Florida versus Soto Escalera? Yes, we're going to cover that, Phyllis. We're going to cover that. So Tanya Wise got stabbed. She had an 8.5-month-old baby by Jose, and she was found in a ditch. We are definitely in Port St. Lucie. We're going to cover that. We're going to at least do opening statements today. Depending on what happens today, if they go home early, we'll just pick right up on Soto Escalera. So don't worry. We will definitely be covering that case. We're going to do at least opening statements today. Joanne, Jedi Platypus, 15,000. Congratulations. Spidey senses, right? Oh, Maybe we got some action here. Dwayne saying hello. Good to see you. Sherry, I appreciate the shout out. I love making it. Glad to see smiles on the faces of those who try. Sherry, it was phenomenal. We were just tasting it. We're just like, we're already halfway through. All right, here we go.
We currently have a number, a couple of dozen depositions set during the months of November and December of 2025, and in an effort to give the court an update as to where we are in that process after those depositions, I'm going to ask the court for a January disposition date, maybe middle of, if that's available.
Let's see here.
How about the January 19th at 8:30? Is that good? All right.
And I do believe, I think that they could set that for contact.
All right. If you could let Megan know I did that, so she doesn't bite my head off.
So Beaton, Devontae born in the same year. Dwayne, I don't like this attorney. He needlessly said that Sonny was not in a car seat in his opening, right? As if that makes any difference. Is a car seat made of armor? Is it a bubble? I know, I hear you. Escalera is the DP. Yep. He stabbed Tanya, I think her first name is Wise. And she was 8 8.5 months pregnant. Apparently that was his mistress. So that one's going to be a really interesting case. So we are absolutely going to pick up on that. We'll at least do opening statements, depending on how late they go today. Because the judge said on Friday he's not going to let them start if it's too late. He wants all the closings to be on the same day. So we may just get through one witness and they may leave by like noon. So then we can absolutely pick up on Soto Escalera. Sherry, Brian got stabbed in jail last week. Did you hear? He's recovering and back in. Brian Walsh. I'm not really following it, Sherry, so I didn't hear that. Talisha says, I love this judge. He's covered another DP case here in Florida. Yeah, we looked him up. He was, and same with the state. Terry, is that his name? John Terry, yeah. He was also a prosecutor in another case with the judge.
Did you see what I sent you? What she said? I mean, first what you said.
Kelly, you with us? There you are. Kelly, yeah. Any fumes hanging on? Poor Pammy. Poor Pammy. Amanda, all your children were born in the 80s? Pammy, I could still smell it in my nostrils, but I think this morning scrubbed it out, finally got it out. Poor Pammy. If you guys don't know, Pammy was on her trike and the gas line blew or something, and she was covered in gasoline. She had to walk home. Cindy, yeah, I saw the story on Walsh being stabbed. He's in October, I believe, right? Isn't he like October 20th or something like that? I think that's when he started. Winnaboo, don't know this case. Is it worth rewatching? I think so. I think so. Member for 4 months. Thank you, Winnaboo. Yeah, it's 5 defendants. A little 4-year-old girl was shot. We're trying to figure out if it was these guys or not. That's what it's boiling down to. Beat, you're all 90s babies? And most are fathers?
Send it that way.
Dude, I'm not even going to tell you what I was doing in the 90s.
Once it's ready to go back, we'll also be going right now like that.
But that's what happens, right? Life marches on. As much as we don't want it to sometimes.
Yeah. Yeah, I did.
Joanne Jedi Platypus, thank you for the one Trial TV Live gifted membership. And Jean Murphy got one. Amanda, yes, I'm a great grandma now. Right? Carol, good morning. Back from your trip to Miramar. Nice. Winnaboo, haven't been able to catch any. Been busy. No worries. Woke says, I want this channel to grow to 50,000, but let's not forget about the first few hundred. That appreciates Chris, Aaron, and the mods. Always. Trust me, we always remember the people that have been with us all the way. Iowa says, thank you to all who have subscribed and liked my stuff. I'm not in any competition with any other creators. Who are the white females in the gallery? Don't know them. I can tell you the other ones from Friday looked like journalists because they all had their laptops and they were all like typing. They were looking down and typing. So to me, they were journalists or some kind of news, something like that. Brett says, my wife and I got married at the beginning of the 90s. G. Stewie, hey guys, been busy working. We'll be in and out today. Hope you all okay. Thank you, G. Stewie. We love rocker stories. Lazy Boys, 50K. I hope this goes to 200 million so that Chris has to give away an island. Right? October 20th, Cindy. Yeah, that's what I thought. That's what stuck in my mind. So thank you for that. All right.
Count 5 reads that all defendants, apologize, Your Honor, did wantonly and maliciously shoot at into a certain vehicle, the silver 2007 Infiniti G35. Your Honor, I would argue that a jury could believe that both Mr. Sampson and Mr. Bedward did in fact shoot into the vehicle within count 5. This is contrary though to counts 1, 2, and 3, which is not alleged that they shot into the vehicle at all. I've asked the court to consider special interrogatories on count 5. However, that would open the door to an inconsistent verdict. So I think the only solution would be to dismiss count 5, Your Honor.
Have you talked to the state about this?
I did. They're relying on that theory of principle. However, that's not really expressed with any indictment. And again, relying on the indictment as it reads, Your Honor, I think that would confuse the jury.
Well, I don't think it does. I think the jury knows that the principle of the theory applies to all 5 defendants and all of the conduct conducted during the alleged incident, so I'll deny the request.
You did not talk to me about Detective Evans?
Anything else? The jury's ready.
When do you want to address the jury instruction?
Well, let me ask this question. Let's do that. First of all, has anything changed since Friday regarding defense testimony?
Your Honor, as it relates to Devontae Sampson, he will not be making himself a witness.
Okay.
This morning.
And sir, let me raise your right hand. You swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth? All right, so we went over it last week, your rights to testify or not to testify, and you chose at that time to testify, but always with the option of changing your mind. So this morning it appears you've decided you do not want to testify. Did you make that freely and voluntarily after speaking to your attorney? And no one forced you to make that decision? Okay, thank you.
Judge, I will, for the record, state that Mr. Sampson and I spent a significant amount of time yesterday discussing the case in its entirety, all of the potential ramifications, good, bad, and otherwise, with regard to becoming a witness. And I feel confident that his decision has not been made lightly and after significant consideration.
Okay. Do any of the other four defendants to change their stance from not wanting to testify to testifying?
No, Your Honor.
No, as to Mr. Denson.
No, Your Honor.
No, as to Mr. Hammond.
All right, and there are no other defense witnesses that any party intends on calling?
Not on behalf of Mr. Sampson.
No, Your Honor.
All right.
No, sir.
No, Your Honor. No.
None on behalf of Mr. Hammond.
All right, so why don't we take another quick look at the jury instructions. What I anticipate is we'll bring the jury in, the state having rested. If you wanted to rest now and make your arguments to the court, renewing judgments of acquittal and things like that, we could do that now, bring the jury in. I could ask if the defense has any witnesses. Each of you would respectively rest, and then we could go into the closing arguments. So we can go over the jury instructions before we bring them out and do all that. That sound like logistically feasible?
Yes, sir.
Okay. So I've gone over the jury instructions, just cursory, since they were handed to me this morning. And I wanted to know if any of the attorneys have any comments or questions on the instructions as they were handed to them today.
Judge, there were several areas where my client's name was misspelled, and so I alerted the state, and I believe that they're correcting that.
Okay.
That's correct, Judge. We're fixing.
All right.
I believe under 3.9, we can eliminate number 7. And we can also eliminate the defendant, in this case, who's become a witness on the following page.
On the following page, what number?
No number, Judge, the second paragraph.
I see. So we have 3.9A, which stays in. The out-of-court statement stays in. And then we take out the defendant, in this case has become a witness. Talking about number 7, correct?
Talking about 3.9.
Yeah, take out number 7. Okay, anything else?
Judge, on the 6.1 instruction, the introduction to attempted homicide, in the first paragraph, there's some areas that need to be filled out where it says victim by defendant, and there's some areas on the bottom paragraph that need to be fixed.
What do you need to change? I'm sorry. We just got 6.1. What did you say, Jim?
6.1 in the first paragraph, it says if you find that there was an attempted homicide of parentheses victim by parentheses defendant. And then at the bottom, it says I now instruct you on the circumstances that must be proved before parentheses defendant may be found guilty of, and it has those all in parentheses.
This is correcting.
Sylvia said if there's any changes, you can send them to her and she can print them. Judge Bellis, J.A.
You want to just vote on these? Yeah, I'm not comfort with Jeff. I didn't do these. Which ones are related to?
Jen, with the 6.1 on the bottom paragraph, is that what you're saying that needs to be changed? What needs to be changed?
And how does it work with that?
Yeah, we're taking the parentheses out. Other than that,
It says, an instruction on the circumstances must be proven before, parentheses, defendant. Did you want to make that defendant or put in the names of the individuals?
Any or all?
we put before any or all of the defendants.
See, mine just says,
Yeah, we're fixing it here.
Okay, you're
So
fixing it.
It'll say before any or all of the defendants being
Okay.
found guilty of, and then we took out all the little brackets that separate everything.
and then you're going to put the name of the victim in the first paragraph?
Yeah, it's been put in there.
All right, so those are the changes that were requested.
Those were requested by Ms. Butler, yes.
All right, so those are being made. All right, any others?
Okay.
Brad, is there anything else that you noticed? If that's it, we're just going to send all the changes.
On the verdict form, I wasn't sure why in the numbering 2 and 3 are indented further than 1 on the question.
Yeah, I just emailed a PDF version because whenever it was merged with the original version, it updated, so I sent a PDF. If you want to take a look at that, and we sent that to everybody in the court so that the alignment doesn't get messed up.
And Judge, on behalf of Mr. Hannon, we're still requesting the independent act instruction based on the court's denial to reject the instruction of the court.
We adopted on behalf of Mr. Henry Thompson, Your Honor. We requested that instruction.
Same request, Your Honor, on behalf of Mr.
Same on behalf of Mr. Jenkins, Your Honor.
And same ruling as previous. Anything else? All right. So for the record,
Sorry.
go ahead, I'm sorry.
Just timing-wise, is it your intention to go through and have all the closings done, or are you going to break at a certain point and allow them to have lunch?
Well, I would imagine after 2.5 hours of closings, the appropriate point, we would take a 10-minute recess, unless there's any objections to that. And then, at the appropriate, if we're not through with closings by 12:30, it's the appropriate time, take an hour for lunch. I mean, each of you would be entitled to the same amount of time as the state uses collectively. I'm not going to put any restrictions on any of that, so we can't just have everybody sit here for 5 or 6 hours if that's how long it takes. All right, so, for the record, the state having arrested Mr. Fischetti, or Mr. Gonzalez, you may call your first witness, or if you have any.
Your Honor, Mr. Sampson rests.
All right, Mr. Fischetti,
There are no witnesses for Mr. Dennis.
you resting?
Yes.
Mr. Hernandez?
Resting, Your Honor, and renewing all pre-trial.
We'll go into those again for more depth. Mr. Sonardi?
Yeah, Mr. Thompson and rest again, and obviously realize all the pre-trial motions that
Ms. Bradley?
On behalf of Mr. Hammond, we will rest and renew all of our previous motions.
All right.
Judge, I did rest on behalf of Mr. Sampson, but I did not indicate to the court that I would be renewing all my previous objections and all the rulings on previous motions.
All right. Does anyone want to make any further argument while we have the opportunity, or just rely on your previous arguments?
Judge, very briefly, on behalf of Mr. Sampson, we would renew our motion for judgment of acquittal. After the close of all the state's evidence, we would just renew that argument or renew the arguments previously made.
Mr. Fischetti, same.
Same, sir. Thank you.
Mr. Hernandez? Mr. Sonardi?
Your Honor, we renew all previous arguments previously fought for a judgment of acquittal, and also urge the court to consider dismissing the conspiracy count in light of the fact that there is no evidence to substantiate even a prima facie case of conspiracy.
All right, I'll deny those requests. All right, having said that, let me get these instructions in order.
Judge, if the only other thing is if the entire instructions go back, including the 1.1,
I send all instructions that have been read.
okay, then on the 2.1 preliminary instruction, in the second to last paragraph, where it says give it defendant request, I just asked for that to be taken out.
Okay, hang on, let me get this done before I think about that. Hold on.
Second page. And of course, just to be clear, I think Ms. Bradley's only asking that give the defendant requested be removed. Certainly not paramount.
So you're talking about 2.1, I have that now in front of me, what's up?
It's the third page, next to last paragraph, right above, it just gives the instruction of give the defendant request. I just want that portion of the instruction itself to remain.
All right, so if you could remove the italics to give it defendant requests.
Correct.
Okay. All right.
Yeah. I'm gonna take that from John Page. Yeah, take that. This one's from people that can do it. Just take it.
All of this. The same thing.
The verdict form that was just sent to me, is that the one we're going to be using?
That's the one,
Yes.
That's not the one that was handed to me?
that is not the one that was handed to you.
All right.
I don't know what's happened. This one. I didn't go through all of the, I didn't do a lot, I'm sorry. Just need to. Right? Let me know if you have heard.
And that was the only, and you're going to be sending me the other ones too?
We're sending.
Yes, Judge, I'm resending to everyone the updated jury instructions in a PDF.
The complete packet?
The complete packet, is that okay? With the changes that were just made? Do you not wish to have?
Well, they're not in the order that I think they should be in. So like in my packet, the jury instructions were in the middle, the verdict form was in the middle. And I can read what I have, and it really doesn't matter, I guess. Because whatever you're printing me is going back with the jury.
Right.
I'm going to read mine to the jury, the corrections made on mine.
But I think she's going to give you a complete package, so you don't have to piecemeal.
Right, I'm just saying that I'll bet they're not in order, though. They may be.
And my only request for the verdict form is just that there's a count that's at the bottom of the page, and there's a rule on the page.
And if you send those to me, I can forward them to Ms. Novia.
Before we cut everyone in front of us. Good.
Before we send these and have them printed, can we just confirm with everybody that they're satisfied with the instructions as they are now?
You sign them on?
Well, you got, yeah, you sent you the copy now. Ms. Bradley, can you tell us again what it is about the verdict form you said you wanted to change? I can't figure out what you're talking about.
The one, at least the way it looked to me when I opened it up, it would say at the bottom, like, the count, and then all the selections on the following page. Yeah, like that.
We just want to.
Just to move it to the next page. But it's not just yeah, just want you to this one?
Are you going to resend them again?
The final jury instructions were just sent in a PDF format. I am sending the final verdict form in PDF format as well.
Okay.
Mr. Terry, I'm weighing the evidence, number 6. Looks like there's just a little bit of that got omitted. It says, it starts with, make a statement that is inconsistent. There's no beginning of the sentencing, give the witness.
Which,
3.96.
All right.
number 6.
In the amended one on page 5, it still has that given as a reflect.
First things first.
Number 6, reviewing the evidence. What are you saying, John? Which count? Which?
Page 5.
Well. Are you looking at the most updated one? Because we have it out. It's not in this one.
Looking at the one that was just emailed.
Here, we just sent another one that's literally, with this time, 927, so that's the latest one. See if it still has what you're.
So the 928 one's the most recent.
The title of the document should say 9:27 a.m. on jury instructions, Your Honor. If you received both Word documents on one email, should be the most updated version.
Well, I have,
It'll say 9:27 a.m. That's the most updated one. That one should.
I got it.
Should have.
I have the verdict form and the final instructions. Okay? All right, I'm going to send this back there, and I'm going to go back there and make sure that it's being printed. All right, court will be in recess for a couple of minutes.
All right, so judge is going into recess for a couple of minutes. So it sounds like, well, not sounds like, the defense is going to rest. Defense rested, actually. So they renewed their judgment of acquittal. Of course, it was denied. And judge is going to bring in the jury, and he's going to ask the defense if there's any witnesses. They're going to say no. So they're basically going to do what they just did, but they're going to do it in front of the jury. So now we're going to get into closing arguments and then verdict watch. So each one is allowed to take up to, sorry, I got something in my eye. Each attorney is allowed to take up an hour and a half, but the judge said he's not going to hold them, specifically to that. If they need to go longer, they will. I don't think they're going to go longer than an hour and a half. I think they're going to go maybe a half an hour. They only went, their openings were not that long. Sure Life, I think this is going to be difficult for the jury. It's not clear cut. It's really not a clear cut case, which definitely bodes well for the defense. So we'll have to see. We'll have to see what comes back. Joke, either they're all going down or all getting off. That's what the state is saying. It's they're all a part of this. So if you follow the state's theory that they're all a part of this, they're all principals, and it's not just one person. It's not just two people. They're either all going down or. Although we'll have to hear the jury instructions. We'll have to hear the jury instructions. Richard, I thought I heard one of the attorneys said yes, he had a witness. I may be wrong. That would have been Brian Gonzalez with the crime scene tech, but I thought the defense, they all rested. I thought they all rested, but I could be wrong. Beat Killa, very well for the defense. Hellrider, good morning to you. Happy Monday. Good to see you. Beat says, time has to be done. Yeah, but I just pray they all get out to taste freedom again. I think they're all up for life. Right? I think the first degree, I don't think they're... I think it would be life without parole. I don't have that in my notes, but I think first degree is going to be... Yeah, first degree is going to be life without parole. Yeah, nobody, because Suni wasn't intended, of course not. Of course not. Nobody intended it. But you got to look at shooting into a car is never going to end well. You know what I'm saying? That's just, when you shoot into a car, it just is just never going to end well. All right, so I've got to get my graphics ready here because we're going to have a verdict watch and then possible verdict. Possible verdict. Let's see. I got to change something here real quick, you guys. Just working on my graphics. Because we may have a verdict. We may have a verdict today. We may have a verdict today. So I don't think, right now, if I had to guess, I don't think that the defense is going to take an hour and a half each. I'm just basing that on the, what do you call it, their openings. Their openings were not I don't think they were more than a half hour, to be quite honest. And actually, Miss Jennifer Spradley only took, she said she was going to reserve her argument for closing arguments. She only took like 5 minutes. So she didn't even take that long. So I don't think they're going to be an hour and a half each. But still, even if they're a half hour each, that's 2.5 hours for them, and then state's going to be another hour and a half, so you're looking at 3.5, 4 hours. You're probably looking at it, and then jury instructions. Sorry, I'm trying to get my chair sorted out. You're looking at least 4 to 5 hours before the jury even gets to deliberate. So if they're starting, say, at 10, 11, 12, they'll break for lunch. That's 2 hours. Come back at 1:15, 1:30, 2:30, 3:30. Yeah, jury might get it like around 3:30 or 4. Beat sending prayers up to Sonny's family. All right, Lily, have a good morning yourself. If they can't prove who shot the bullet that ended Sonny, how can they convict anyone? Hellwriter says bullets have no names. Woke, I would say, well, I'm sure we'll hear the arguments, right? We're going to hear the arguments. But I would say that James's two casings, the two casings that were found belonging to any one of them, go back to James. So that, and he says that firearm was his number one carry. That he never lent that out. Nobody ever had that. And then the cell phone data. So those two bits of information, I think, those two pieces of evidence, and then of course they all got in the car. So those 2 to 3 bits of information are probably what the state is going to really hammer home. Pete has a song expressing how I wished she wasn't there that day. Yeah. You wrote it? Mallory, giving love to Sonny. Treeway here with us? Where are you? I didn't see you come in. Oh. I'm sorry. People are calling you by your last name. I gotcha. Yep. Sorry. I see you. Nicola says, would you say that about your gun if you were guilty? That it was your main carry? Right. And that you never handed out to anybody? But then how do you explain this casings? How do you explain 2 casings? There were 4 individual 9mm firearms identified. There were 15 casings? No. There's 25. There's 25 9mm. 2 of them belong to James. So how do you get away from that? How do you get away from that? Not a full song dedicated, but you can feel my pain towards the situation. I gotcha. Do you think it's possible that only 1 out of the 5 will be convicted? At this point, well, see, that's what the state is saying. The state's saying if you find James guilty, then you have to find all of them because they were all part of the commission. They were all part of it. So the state's going to say, if you go rob a bank and you're the driver and somebody robs the bank and you're the getaway driver, you're just as guilty. And then if somebody gets shot during the commission of that crime, you're even more, it's the same thing. It's the same thing. So Hey, Mike, how you doing? Legal doctrine, also known as the doctrine of complicity, means that an accomplice can be held equally guilty for the consequences of the crime as the person who directly committed it. Yep, that's exactly what we're talking about. So if you find one guilty, then all five are going to be guilty. Even though right now, the only one that they can pin to me with evidence, direct evidence, is James's 2 casings from his 9mm. And then the cell phone data shows them all there, except Andrew. He's close, but he's not. The other 4 guys are like right there. So based on those 2 bits of information, I would say it's, in my opinion, it's not looking good for them. I would, if I was a juror and I was arguing, I'd be like, how can you say they're not guilty? You know, that's the tough part. That's the tough one. You know, if James's casings weren't there, then you might have a little bit more wiggle room, because then it would just be the cell phone data. But with the cell phone data and the 2 casings, that's tough. But then on the other side of the argument, it's going to be there were 4 9mm casings that were found, and only 2 of them match a gun. What happened to the other 3 weapons, and then the other 23 casings were found? Where are those guys? Where are they? You know? Hellwriter saying, in your opinion, they all are gone. Sherry, no way they're going to get off. It's right now, the state has at least proven that the cell phone data shows they were there, and that James's 2 casings from his firearm were there. That's what they've proved, you know, before, beyond a reasonable doubt for me, at least those 2 aspects. Mallory, the gas station video for me is very compelling. Beat says, especially when you know both parties. Yeah, I'm sure. It's got to be tearing you up. Trixie, if they are found guilty, I feel like having them all together as defendants is good for their appeal. Oh, yeah, they will definitely appeal, for sure. They will definitely appeal this. No question about that. I only know Sonny's mom and dad, though, Beat says. In other words, they're all guilty. Yeah. Well, that's what the state's going to hammer home. They're going to say if you find one guilty, you have to find all of them. Woke says, then if you splatter a car with 40 bullets and you're found in the other car with the shooter, you're guilty. Yeah, because at one point, because that's what they were arguing, Zavante could have very easily said, what do you put the gun away, what are you doing? Or, Zavante's the one that the state is saying sped up and then slowed down, right as they caught the car. So that's why they're saying he has, like, what did he think was going to happen? That's what the state is saying. Beat says, good people, they're a rock solid couple. Trixie sending prayers to Sonny's family. Yeah. That's always the worst part of it, is Sonny. Psychosaurus, remind me, did they associate any of the bullets that hit Sweet Sonny with anyone? They did not. Psychosaurus, they did not. They couldn't identify, and it was one through and through, unfortunately. Tim, how old was Sonny anyway? She was 4. I don't know. When is her? Do you know her birthday? When is Sonny's birthday? Do we have that information? Do we know when Sonny's birthday is? Anybody? Let me see if I can find it as well. See if I can find it. But Beat, if you know, do you know when her birthday was? Oh, here's her obituary. Did it say when she was born?
Any changes while I was getting all this put together? We all good? All right. What's up?
On page 43.
All right, so we found that Suni was born April 26th of 2017.
Okay. Well, let me ask you this. The order, I'm going to read these in before we get to that change. Introduction, so statement of the charge, introduction to homicide, murder in the first degree, and then what do you want to follow? The other primary charges, or you want me to go into to read the lesser included and then do the shooting at her within later, at the end of the lesser included? Does that matter to anyone?
It doesn't matter to me.
I don't think it matters.
Or Savante Simpson's name, so I know I didn't put back in there.
And that's 6-1?
6.4. It's on page
43, they're not
There's two 6.4s.
correct. It's the one with Willie Brown as the victim.
Okay.
It should say Quandarius Hammond and/or Savante Simpson. It says Quandarius Hammond and/or. It doesn't have the names of
All right, so you just, that one, go ahead and print that.
Printing that one, or we're sending that one to be printed.
All right,
That's the only one that needs to be switched out.
all right, I'll go get that one.
Christian? Which area is that? It's obviously. Christina Novia, N-O-V-I.
All right, so they're just hammering out their jury instructions, and the judge was asking if they had any final arguments, who's going to testify, all that stuff. So, all right, I have to read what Psychosaurus Rex posted. Hold on, where is it? Psychosaurus Rex, I ate so many s'mores during PISAM stream the other night, I was finding chocolate smears in random places all the next day. Oh, Rex, that's why we love you. That's why we love you.
Well, it was kind of the same thing for me with the barbecue sauce. I kept finding it on my forehead yesterday.
Do you want me to tell people that? Oh,
you are telling.
So Aaron said that was the same thing with Sherry's barbecue sauce, that she was finding Sherry's barbecue sauce on her forehead.
Yeah. I don't know why.
So,
It's just funny.
It's either s'mores or barbecue sauce. God knows what happens on a Saturday night. All right. Good morning, Joe. Joe had a great stream yesterday talking about London Valdez. I hope you guys caught that, and if you haven't, please go check it out. He interviewed London's mother yesterday at 4. It was a great interview. Beat says your dad did 12 for shooting a man in the back of the head. Judge Fuson said a 6.4. Yeah, I'm not sure. I didn't catch that. Woke, I'm making chocolate croissants for lunch because I've been craving them since Friday. Nice. Amanda, I could definitely not put guilty of first degree on any of them as they cannot say which bullet was responsible. Mallory, when my kids have bonfires, I find chocolate and melted marshmallow stickiness for days after. It's funny. Mike Morrow, Joe Schmo, the man, the myth, the legend. Kathy says, great song called Take Him Home, Lord. And Dwayne, yep, the cheeseburger in your lap when you fell asleep at the table. That was a good one, too. Beat says the dude was also wanted. So it was kind of a justified, if you will. Psychosaurus, wonderful stream yesterday for Joe. I mean, obviously sad and frustrating, but wonderful to hear from the family and give them a voice. Yeah, very, it was good. It was powerful. It was good interview. Defense has no defense. Doesn't seem like it, Kathy. Doesn't seem like they're going to put on a defense. They're going to go straight into closing arguments. So that probably helped your dad, Beat says. Yeah. Psychosaurus, I'm like 90% sure I had mallow in your hair, but could have just been a wicked little tangle. I didn't investigate. Oh, you're too funny. Mike says, hold on, HR wants to see me in the office.
You sent it to Judge, did you get those showed them too? You got both of them, right? Yep. Those are
Should put them in the right places. Take 6s out. From Willie Brown. And 6-4 is out for Willie Brown. All right, we should be good to go. Anything else before we bring the jury in? I'll bring the jury in and ask you, each attorney respectively, you may proceed, and you can rest, and then we'll go into closings.
All rise for the jurors.
Jury's back. All may be seated. Thank you, ladies and gentlemen. Welcome back. I take it there were no issues with the court's instructions. Very good. The state having rested their case, Mr. Gonzalez, what say you?
Your Honor, Mr. Sampson was rest.
Mr. Hernandez?
Your Honor, at this time, the defendant was rested.
Mr. Fischetti?
Your Honor, the defendant, Mr. Benson, rests.
Mr. Sonardi?
Andrew Thompson, Rush, Your Honor.
And Ms. Bradley?
On behalf of Mr. Hamlin, we'll renew all our previous motions of objection.
All right, very good. All right. Ladies and gentlemen, both the state and the defense have rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments that are intended to aid you in the understanding of the case. Each side will have equal time, but the state is entitled to divide its time between an opening argument and a rebuttal argument after the defense has given its closing. State, whenever you're ready.
May it please the court, Your Honor? Two minutes and 6 seconds is what it took to end the life of an innocent child and change the life of her family forever. 2 minutes and 6 seconds is what it took for the defendants seated before you, each and every one of them, to play a role in this case in the murder of Suni Bell and in the attempted murder of her mother and of her uncle on Hillsborough Avenue on August 22nd of 2021. 2 minutes. The defendants, for 2 minutes before that, lie in wait, arm themselves with firearms, put on masks, wave each other on to enter the vehicles before jumping in to all of the cars depicted in the video that you've seen and chasing down the victims. They're charged with first-degree murder. They're charged with conspiracy to commit murder. The court will read to you the jury instructions that are applicable to the charges, each and every charge that you need to look at the instructions for, to determine whether the state has met its burden in proving to you that each of these defendants, regardless of who pulled the trigger, have blood on their hands in the death of Suni Bell. Throughout this trial, we've seen a lot of evidence. It's our job as the state to hold the burden to put that evidence together for you. We've presented to you experts. We've presented to you the testimony of the medical examiner to establish that Suni Bell was the person killed. But we have not had an opportunity to actually introduce to you 4-year-old Suni Bell. Just starting school.
Objection, improper argument.
Overruled.
She was the backseat passenger while her family was attending a celebration of life. But they made a mistake. They violated the rules. According to these defendants, you can't get lost around their neighborhood. You can't drive too slowly near them. You can't stop to look for directions, and you certainly cannot be lost. Because for the less than 2 minutes that Willie Brown was parked in that field, waiting, trying to reach his cousin, the defendants prepared. They got masked up, they got armored up, and they got ready to go to war. Unfortunately, their common enemy was an innocent child and her innocent family members. Each of the defendants is charged in this case, and each of the defendants is guilty. each played a role in the crime that was committed, in shooting repeatedly into this vehicle. You do not discharge a firearm one time at another human being with the expectation that things will be fine, with the expectation that that person would live. You do it to kill. In looking at the surveillance footage from the gas station, the utter excitement experienced by everyone running around, picking up guns to hunt down this car and shoot at it, is indicative of their plan to kill the occupants inside. The number of shots fired at this same individual car is indicative of their intent to kill. It is not the state's job, obligation, burden to jump into the minds of any defendant. It's impossible. We talk about motive to say, what is the motive? Why isn't it an element of a crime that we have to prove? Because we can't 100% ever tell anyone what is in the mind of that person when they commit this act. We heard in jury selection from a juror in the back who was working as a receptionist of some kind, and a man came in and kind of destroyed the place a bit. His intent was to destroy the place. Walked in, threw, items all over the floor, destroyed the inside of the reception area at her business. None of us will know the motive. Was he upset with an employee there? Did he have a mental health issue? That is the difference between motive and intent. We don't know what your motivating factor is in committing this crime. But you don't shoot into a vehicle this many times with the intent that anyone lives. Starting first with the passenger of vehicle number 1 that we see on these videos. This is Quandarius Hammond. He's the only occupant that you see enter the vehicle with Zavante Sampson. The photo in the center here is what we showed you from Mr. Hammond's social media. He likes to match these items or pair these items together. On either side are the same outfit that he was wearing on the night of the homicide. This is Quandarius Hammond. Quandarius Hammond is the person who walks to the white fence line and crouches down there for just under 2 minutes waiting for James Denson to come back from his lookout point across the street. Just after the victim's silver vehicle passes, he exits the frame and then re-enters, crouching down in that same spot. When you watch the video of him getting up from that crouched position, what do you know? The firearm that you have in your cell phone evidence, depicted in the image on the right, photographed the day before, is in Mr. Hammond's hands. Here's Mr. Hammond. There's no point that the state will concede that there is audio to what the defendant's actions were from this video from the gas station. But what the state does assert to you is that it is plain as day what their intentions are. Mr. Hammond is pointing. Mr. Hammond is clearly communicating with the others nearby. And Mr. Hammond is clearly waiting to ambush. At least at this time, fortunately enough for the victims, they don't come back down Giddens on the other side of these defendants. They head to Hillsborough because we heard from Willie Brown he saw the defendants pointing at him and decided not to stay there. Everyone in the videos you see walking around with guns, some masked, some not. The driver of the vehicle that Mr. Hammond gets into is Zavante Sampson. You have to watch him in the video independently. In the video that we showed to you all, which depicts each of the defendants zoomed in on them, has been admitted as an exhibit if you wish to watch it. Because there was a lot of evidence in this case, and it is difficult to ascertain when you watch this. I mean, I watched the video dozens and dozens and dozens.
Sustained.
It's difficult to ascertain who is doing what. So an exhibit that has been admitted for your consideration is that which depicts each of the defendants follows them through the frame so that you are also able to focus on what did this person do in the parking lot? Why has the state charged them as a co-conspirator? Why has the state charged them as a principal to all of the crimes charged? You'll see Mr. Sampson pointing, you'll see him talking with others, and you'll see him lead the charge when they exit that gas station. Here's Mr. Sampson with the gentleman in red, who the detective testified was Mr. Sampson's brother, Devin Sampson. Devin Sampson's pointing towards the direction of the vehicles that were passing behind the gas station, their targets. There goes Devontae Sampson pointing towards those same individuals, and the moment that Jalen Bedward enters and trips. Quindarius Hammond enters his position to crouch down and hide, lying in wait. And Devontae Sampson returns to his vehicle. In the video, which follows Devontae Sampson, you'll see while he's at the video, while others are trying to track the car and locate the car, he's pointing, he is waving them on to get into the vehicle, and he takes off. How do we know that Devontae Sampson knew of the common scheme of all of the others? Because he is driving the first shooter. Because all three vehicles target the same victim, the same car. At this exact timestamp, you'll see from some further slides, the victim's vehicle is crossing the boundary of the chevron on Hillsborough Avenue. Looking now to Andrew Thompson.
Your Honor, may I get close, briefly?
Yes. Continue.
Andrew Thompson, who by the end of the videos you see entering the passenger seat of the Chrysler 300 with Mr. Bedward as the driver. Now, we all know that all of the defendants have admitted or identified themselves from the video surveillance from the night of the offense. They've identified themselves as drivers of the vehicles, etc. But what's interesting about Mr. Thompson is that the minute that Jalen Bedward trips over that rebar and gets back to the vehicle, he rips his shirt off and ties it around his face like a mask. I don't know what they're saying to each other. I won't assert to you that I know what they're saying to each other, but I get the gist. How does Devontae Sampson tie into what Mr. Thompson and Mr. Hammond are doing at the bottom left of the screen? Well, Mr. Bedward and his brother go out into the field to watch the car ride by, and right in the middle of the frame, Mr. Sampson makes some kind of hand gesture to Mr. Thompson and Mr. Hammond, at which time they return to their vehicles and arm themselves with firearms. Mr. Thompson has repositioned himself behind the dumpster. Watching, waiting. Mr. Bedward, gone to the vehicle, changed from a handgun now to his AR. Mr. Thompson returns to Mr. Sampson's vehicle. We have footage that Mr. Thompson enters the passenger seat of the Chrysler 300. When we get to the timelines, you'll see there was no opportunity for anyone other than Mr. Thompson to be in the passenger seat of that Chrysler 300. Jalen Bedward identifies himself as the driver of the Chrysler 300 that night. He's there in the frame, standing just behind on the left-hand side here, his brother, person who at least brings their attention to somebody driving on the back road. Mr. Bedward, after changing from a handgun to an assault rifle, pointing out to the others from behind the dumpster there, right in line with our timeline of the victims driving up 43rd to head on to Hillsborough. Giving directions to everyone else as to where their target is. All because at the start of this video, the victims depicted in the top right here drive on the road that, according to these defendants, they're not allowed to ride on. As you play back these videos, you'll see the victim's headlights just opposite the street of Giddens, which is the street that they're just nearest to, having turned down the other road to come up and park into the field. We know Jalen Bedward has admitted to possessing this AR, and we know that there is an empty box in the trunk associated to an AR-15 that was not recovered in this investigation, belonging to Mr. Bedward. I've told you that the first time he passes after he trips on the rebar, he switches out his weapon. Mr. Bedward has a handgun when he runs back to his vehicle. And when he comes out of that same vehicle after his exchange with Mr. Thompson, he now has an assault rifle. Now, James Denson, also identifying himself in the footage, does the same as Mr. Bedward and Mr. Bedward's brother, watching the vehicle. If you look very closely, you can actually see the vehicle turning right onto this roadway before it turns right again, coming back the opposite direction. Mr. Denson actually runs across the street, disappearing from view for 2 minutes, before running back to join Mr. Hammond and Mr. Thompson at the cache of guns right behind the dumpster. And before they leave, in his excitement, he is sprinting to the back seat of that Chrysler 300. Everything starts out as normal until he joins all of the others. But Mr. Denson's role, at least preliminarily, is to stay across the street for an extra 2 minutes before he runs back over and gives updates. just before the vehicles depart the gas station, Mr. Bedward enters the driver's side of his vehicle. Vehicle 1 leaves. Vehicle 2 leaving just behind them. And here comes James Denson. He doesn't want to miss out. Everyone's jumping, running to get to the cars because they don't want to be left out. Here is the exhibit that we've also admitted into evidence for you all, because I certainly understand, given the volume of evidence, how difficult it would have been to document each of the witnesses' statements regarding how far off the videos were from real time. So this is an exhibit that you will be able to have with you back in the jury room. It is a summary of the timestamps and their accuracy, fast, slow, etc. For purposes of this presentation I'm giving to you, I have adjusted the timestamps according to this summary I've provided to you to reflect exactly when we see the vehicles on the videos. Starting first with the victim's vehicle passing the chevron, which occurs at 9:03:26. The defendants are running in the top left corner to enter the vehicles to drive out after the victims. 9:03:48. Vehicle number 2 exits, 9:04. Vehicle number 3, 9:04:09. Now, the focus is vehicle number 1 and vehicle number 3. Because as you've heard testimony of, the state must have proof beyond a reasonable doubt in bringing charges. And at this time, there are not sufficient charges against the occupants of vehicle number 2. Because for us, we have evidence that vehicles number 1 and 3 discharged their firearms towards the victims. What that means, though, is you must consider the evidence of the crimes we have against these defendants. There is no law which indicates you don't have enough defendants. There were too many shooters. There was too much evidence of ballistics at the scene. You don't get away with murder because you had too many accomplices. There's no law which supports that these defendants would not be held responsible because everyone responsible was not also tried with them. Now, we know from the video surveillance that the defendants all leave the Chevron gas station with this red arrow in the center of your screen. They head up just past Power Electric Services, heading east on Hillsborough Avenue, and immediately make that U-turn. The first camera that we pick up is that Power Electric Service camera that gives us audio from both shooting vantage points. So you hear one round of shots, a break, you see vehicles number 2 and 3 passing, and you hear yet another round of shots. So I'm going to give you timestamps because when we play it all together for you out of context, it gets pretty convoluted. You don't know which videos are overlapping with which. But ultimately, from this diagram, the yellow spot is where the vehicle first stops and Willie Brown jumps out and runs north towards Mr. Coberly's residence, where we catch him on camera with all the cobwebs around it. You still hear ballistics. You still hear shots ringing out as he's running. You barely see him on the footage because he's a blip, he's running so fast, but that's the first stopping point for that vehicle. There goes the victim's vehicle, and vehicle number 1 just after it. Before vehicle numbers 2 or 3 at the Power Electric location So we're looking at video from the location all the way to the right on your map, the red pin, all the way to the right. Before vehicles number 2 or 3 even pass that camera, shots ring out from vehicle number 1. Vehicle number 2. And finally, the 300, vehicle number 3. So we first see on this vantage point the victim's vehicle at 9:04:27 p.m. It has driven past the chevron coming east and made a U-turn and is now headed west back the other direction. 1 second later, we see Zavante Sampson's vehicle with Mr. Sampson as the driver passing this camera angle. Quandarius Hammond is the passenger of this vehicle, 1 second after the victims. Timing-wise, given they've made a U-turn from the location that's also depicted of the chevron just up the road, there's no opportunity with a 1 second gap in the manner with which they caught up to have changed a thing. The defendants exit the gas station, and as Willie Brown testified, got right behind him before the U-turn. He did not think anything of it at that time. Zavante Sampson admits to being the driver of that vehicle, and Quandarius Hammond has given a version of events, which is that he was let out. You heard a jail call between he and his girlfriend, during which he's trying to convince her, essentially, to say she picked him up, and she says she can't. She already told the police she's in St. Pete. You see at the end of this frame, all the way down the roadway, the brake lights coming onto Zavante Sampson's vehicle as he's catching up with the victim's vehicle. The gunshots begin at 9:04:38. In lieu of leading you with the following vehicles after this, I'm going to keep you with vehicle number 1, driven by Zavante Sampson and occupied by Quandarius Hammond, at the next view of the camera. That's your first round of shots. They go off before vehicles number 2 and 3 into the frame. And as a result of those shots at the exact same timestamp on the Lorenzo's garage video camera, you see the victim's vehicle coming to a halt. The screenshots from the Lorenzo's garage camera reveal at the same exact second that the shots start, according to the last video we saw from Power Electric. The victim's vehicle is coming to a stop in the far right lane, and the defendant's vehicle is shooting into it, consistent with the audio we hear from Power Electric. Michael Coverley's residence, before it actually depicts the victim, Willie Brown, running onto screen, also captures those shots. And at 9:04:38, you actually hear a gap in between the first round of shots and the second. And it's so hard to see, but as you take this video back with you, you can actually see Willie Brown sprinting to this door. We heard from Mr. Coverly, whose home this camera is attached to, that he ran to his house, that he said someone's trying to kill him. He's running house to house to try to get help. You heard from the law enforcement officer who made contact with him, who he said the exact same thing to. We know that the ballistics evidence from Mr. Kwong also indicates that group number 1, firearm number 1, is the only gun whose casings are between 45th, which is where Lorenzo's garage is. So a vehicle moving at any rate of speed, discharging a firearm out of the window, drops casings from 45th up to the marker of 12. The only gun with casings which are limited to the first half of the roadway. All of the other guns go beyond 43rd Street. And we know from the DeLand trucking video that Zavante Sampson and Quandarius Hammond turn left onto 43rd Street. All of the other guns have a casings beyond 43rd. Gun number 1 belongs to Quandarius Hammond. Because when that vehicle turns onto 43rd Street, there's no other mechanism for shots to have been fired. In fact, the fact that the vehicle stops at Lorenzo's garage and the casings stop halfway down the roadway are indicative of the fact that Quandarius Hammond thought he was successful. The vehicle stopped. But unfortunately for Mary Bree Harrison, when she got into the driver's seat in an attempt to save her life and her child's life and stepped on the gas, the vehicle starts to move again and the shots also start back up. When you look at the key provided with all of the shots divided by color, again, those in red are limited to vehicle number 1. All of the other two vehicles pass 43rd Street. We know that the defendant, Zavante Sampson, turns left onto 43rd Street because the vehicle is tracked on DeLand trucking video, turning left onto 43rd, driving around another vehicle in the opposite lane of traffic, turning back left on Frierson again, and turning up 44th to make it back to the Chevron gas station. At the time they finished shooting, the vehicle was left at Lorenzo's garage and Miss Harrison's getting ready to jump into the driver's seat and drive it away. Power Electric Services, all the way to the right of the screen though, also captures a few seconds later vehicles 2 and 3 entering the frame. And vehicle 3, the Chrysler 300, is occupied by Jalen Bedward, Andrew Thompson, and James Denson. Andrew Thompson is your front seat passenger in the Chrysler 300, Jalen Bedward is your driver, and James Denson is the back seat passenger. That vehicle passes into the frame at 9:04:49 p.m. Here comes the Chrysler 300. And we have Bay City Cabinets footage, which also captures that second round of shots at 9:05:05, just across the street from those school buses. It's so very fast, but when you watch back at a slower speed, you see the victim's vehicle entering the frame. Here in the center, followed closely behind by vehicle 2, and then the Chrysler 300. So we did what we spoke about with many of our witnesses, which is slow down that video and try and watch it frame by frame. What happens when that Chrysler 300 actually passes through frame by frame? Victim, vehicle 2 on her left, and vehicle number 3, the Chrysler 300. We're looking now at the driver's side of the Chrysler 300, but even then we can see the power of that muzzle flash. Wasn't enough that the vehicle was already stopped the first time. It wasn't enough. They kept shooting at the vehicle. Looking now, 2 seconds later, at the auto upgrade, just across the street. So we've passed Bay City Cabinets. It took 2 seconds for that vehicle to discharge on this roadway and keep discharging until we intercept auto upgrade and Principal Auto Sales. The crash location, the pole with which Miss Harrison crashed into, is right here. We know auto upgrade doesn't capture the actual crash location, only the vehicle's approaching, but it does assist us because it actually captures 43rd. Then Principal Auto Sales has 2 views, one facing northeast and one facing northwest. For auto upgrade, 2 seconds after the Bay City Cabinets shots, we see the Chrysler 300 enter the frame again. On Principal Auto Sales, 1 second later, so just as the Chrysler 300 passes through that intersection as described for us by Detective Alverson, this is the same intersection as this, from the opposite side of the roadway. And there's the Chrysler 300 continuing to shoot into the vehicle. The victim's vehicle that is ready to crash into the pole. The victim's vehicle that ultimately does. More shots. From this angle, you see even after the vehicle has crashed into the pole, there are shots coming out of Jalen Bedward's vehicle. The vehicle in which James Denson and Andrew Thompson are also riding. The vehicle which we know James Denson doesn't have an assault rifle because he shot his own 9. The same one he pawned a month later for whatever reason. While the vehicle's crashing into a pole, vehicle number 1 is returning to the Chevron gas station because you can't leave your bag of guns at the gas station. You have to go back and pick them up. So Zavante Sampson returns with Quandarius Hammond, Their windows are down, they're talking, they're hanging out. They arrive back. You have the videos where their vehicle's returning to the Chevron. Quandarius Hammond, his specific video, we've already seen, has him going behind the dumpster and then walking back to the houses in the back to meet back up with Mr. Sampson. Impossible that they would have shot rounds other than the red grouping number 1 because they turned left onto 43rd. We see those screen grabs from after 43rd where the vehicle crashes into the pole, which is again the black, either rectangle or the rectangle with a triangle on top, whatever it is, but the circular area never changes across any of these scene diagrams. The only vehicles that passed the victim crashed there in that vehicle. The only vehicles that passed 43rd are those occupied in vehicle 2 and Jalen Bedward's vehicle with Mr. Denson and Mr. Thompson inside. These are the charges that you will all be asked to make a decision as to the guilt of these defendants. The state has proved that the defendants acted with a premeditated design in the killing of Suni Bell and attempted to murder Ms. Harrison and Mr. Brown when they shot into that vehicle. They're all charged in count 4 with conspiracy to commit murder. That means they all came together, combined, confederated, conspired. They all came together in some way, by word, by act, with the same goal in mind, which was shoot as many times as humanly possible into this silver infinity. The judge will instruct you you're permitted to use your common sense. 40 shell casings collected, at least that many rounds going off into the same target vehicle. They're also charged as principals to shooting at, within, or into a vehicle. You have to determine whether they acted together to commit what was the ultimate goal, shooting into this car. And lastly, discharge of a firearm from a vehicle. Only the person that has been charged with actually pulling the trigger or pulling a trigger has counts of discharge of a firearm from a vehicle. So we'll go through those so that it makes more sense as to who is charged with what. All of the defendants are charged with first-degree premeditated murder. You say to yourself, how, when there's nothing, no evidence to support that they even knew Suni Bell or Mr. Brown or Miss Harrison? None. How are they charged with premeditated murder of someone they don't know? Unlike what we might see on Dateline or, the news stories that are really, really salacious, your typical murder doesn't occur by sitting down at the dining room table and writing out a contract to do it. That's not what's required by premeditation. That's not what's required by the law. You don't even need to know the victim's identity. Remember, Mr. Terry spoke about what happens in a mass shooting, for example. You're in the car and you make sure you have all the weapons and you're going to go into a mall. You don't know the name or identity of your victims, but you planned to do an action. You had a forethought to commit the act that you committed. Each of the defendants, by act, by word, in that parking lot, acted in a manner consistent with them all being on the same page. Principles by act, conspiracies by act. You don't need to know what they said to know they had a common scheme or plan to commit this crime. It's not, did they plan to kill a 4-year-old child? It is, did they plan to open fire on a vehicle in the middle of the road over and over and over and over again?
Objection, proper argument.
Overruled.
And each of these 5 defendants achieved that goal, regardless of whether they pulled the trigger. I will give you specific examples because only Mr. Hammond, Thompson, and Denson have firearm discharge language, and actually no one is charged with shooting the bullet that actually kills Suni Bell. Because with a through-and-through wound, it's impossible to tell whose bullet did it. But it would not have been accomplished without the actions of every single person depicted here. In count 1, these are what your instructions will have. Suni Bell is deceased. That death was caused by the criminal act of the defendants, and there was a defendant or defendants, and there was a premeditated killing of Suni Bell. So we saw an instruction from Ms. Bradley about multiple defendants and considering them independently. You do need to look to each defendant to say what is the evidence against this person. But you have the benefit of having a principal instruction that you carry with you through all of your counts, right? So this is a charge, premeditated murder. Principal to a crime is an instruction that you are given based on the facts that you look to say, if this person didn't pull a trigger, did this person aid, assist in this goal being accomplished? You'll have instructions on premeditation, and you'll have to consider what was the conscious intent of the defendants as they gathered, as they prepared in that parking lot. The court will give you a significant amount of instructions. You will also have a paper copy of those to refer back to because there's a lot of legal language included therein. But this principal instruction, did the defendant intend for the crime to occur? Did the defendant do some act, say something that intended to help the others? Encourage them, aid them in committing this crime? They don't need to know, in being a principal to a murder with a firearm, whether any of their other defendants were armed. In this case, they're all in the parking lot with several individuals running around with assault rifles and handguns. I do not assert to you that they didn't know that, but that's not even what's required. Was the common goal to go after these victims, after this vehicle, that of which the defendants had before they started shooting? You'll have specific instructions as it relates to principal to murder as well. So principal is just the instruction you carry with you through the charges, and there are specifics as to the murder itself. This is what the verdict form that you will receive from the court will look like as to each one of the defendants. So you will have a section which indicates count 1, murder in the first degree. And as to each of the defendants, you will have to make a finding. We've charged 3 total defendants with the possession of a firearm during the commission of this crime and the discharge of a firearm during the commission of this crime. No one is charged with shooting the bullet that actually killed Suni Bell, causing her death, because it was a through-and-through wound. So your findings must be, or are limited to, did Quandarius Hammond, did Anthony Thompson, and did James Denson, under these instructions, actually carry, display, use, threaten, or attempt to use a firearm? It seems duplicative, but did he actually possess a firearm? And during the commission of this offense, did he discharge his firearm? When we talk specifically as to whether the defendants have this firearm discharge language, you will see this type of wording underneath, for example, count 1 as to Quandarius Hammond, the passenger of the vehicle number 1 driven by Zavante Sampson. Did he have a firearm? Did he discharge the firearm? When it relates to the remaining defendants not charged with actual possession of a firearm during the commission of the offense, so Zavante Sampson, the driver of vehicle number 1, he doesn't have those special findings underneath his counts because he hasn't been charged by information with possessing a firearm during the commission of the murder. He's charged as a principal, as an aider to ensuring it happened, as the driver during the course of the murder, as encouraging the other defendants, telling them before they jump into the vehicles and chase after the victim's car that's just passed by the chevron. He doesn't have special findings, but he has the same result. He's guilty of murder just as are his co-defendants. We talked about motive versus intent. Motive is not what needs to be established. There are counts for which the intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Somebody shot me.
Take him out.
Somebody shot me. Somebody shot me. It's simply that. Oh, she picked this thing down. Somebody knew that shit's gonna happen. Somebody shot. I feel sorry for that little girl, but somebody shot her. It's the truth. Y'all can't be quiet.
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues. We'll be back when we can.
All rise for the jurors.
Yeah, that's not a good look, though. That's not a good look. So Zavante was Devante was saying, having some words. They shot first. Yeah, you can't do that.
Do you need to step up for a minute? I'm sorry? Well, I was going to talk to you folks about some remedies.
Looks like the gallery might be cleared as well. Devante was saying something. Was he saying they shot first, or I wasn't shooting? Weren't shooting at a little girl? I didn't quite hear it all. Let me see if I can rewind that, and we'll bump up the audio. All right, I'm going to bump up the audio.
Did the defendant help another person?
Somebody shot at me, somebody shot at me.
Take him out.
Somebody shot at me, somebody shot at me. It's a good thing. Oh. This thing, man. Somebody know that shit gonna happen. Somebody shot. I feel sorry for that little girl, but somebody shot at her. It's the truth. Y'all can't be quiet.
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues. We'll be back when we can.
All rise for the jurors.
All right, so it sounded like, yeah, is Devante saying somebody shot at us first? Somebody shot at us first. I could have testified. I heard, but somebody shot at us. He said they shot first. He said I could have testified. Definitely the truth. Okay, well, may not have been willing. He did say he felt sorry for this little girl. Sorry for the little girl. They shot first. It's the truth. I heard somebody shot at us first. Should have taken the stand. His attorney should have advised him to cut the dreads before trial. He should have testified. It's pissing him off. That's why he walked off. I know. It's not a good look, though. That's not how you win cases. You don't win cases like that. You don't win over the hearts of a jury by doing that. They'll make them think, I guess, a little bit, but ultimately that's not gonna. Yeah, it looks really bad. He had an opportunity to tell his side. He said the word testify, one of the first things he said. You can't appeal on that. Now what? This could be a mistrial. I don't blame him for being overcome. That makes him look so bad. Well, as outbursts go, that wasn't like, horrific. We can say that at least. We've seen some other outbursts. It wasn't, as outbursts go, that was pretty chill. All things considered, as outbursts go, that was a pretty chill outburst. Pammy, yes, he wanted to speak out. He should testify. We all want to hear it. I agree. Let's see. Understood, but they have to understand too. But they don't because they've never been in these type of situations. But see, that's up to their lawyer. That's up to the lawyer to be like, it's up to the lawyer. Not a good look. Missy, I'll be hanging in chat. My plan to take your husband failed. He survived the 26.1 mile obstacle course in 2 days. That's funny. Yeah, remember Daryl Brooks, right? Psychosaurus, it's interesting because the defense cannot cause their own mistrial, but when there's 4 other defendants, maybe he could cause mistrials for them, but not himself. Kathy, they should be tried 2 at a time. Mallory, then he should have testified. Yeah. The lawyers don't understand either. I would hope they all seem like they've been around for a while, right? They don't seem like they're kids. I mean, they all seem like they're in their 40s, 50s even. Alan, but seriously, Chad, if you want to testify, can your lawyer block you from doing that? No, it's your call. It's up to your lawyer to tell you the ramifications. It's up to the lawyer to say, if you do this, then this may happen. So it's up to your lawyer to explain everything. That's where the lawyer comes in. And then you have to trust them that they're making the right decision for you. So it's up to your lawyer to give you the best advice possible, and then you have to be able to trust them. Kalia says the lawyers don't understand the neighborhood. Hellrider should have got on the stand to tell his side. Right. Little Lulu, is his lawyer the one that shouts? Yeah. Brian Gonzalez is his name. Brian Gonzalez. Let me just make sure we're up to date here. Yeah. All right. Yeah, Brian Gonzalez is Avante's lawyer. Cross-examination, maybe he wanted to testify but was advised against it. Probably. Well, don't forget Friday. It was up in the air. On Friday, we thought he would. Well, he on Friday we thought that he would. On Friday, we thought that he might, and that he was going to have the weekend to think about it. And then they came in and they said no. Let's see. Ellen says, then he missed his chance. Psychosaurus, you missed the s'mores story. I'm positive it would have given you a solid cackle. It gave me a pretty good cackle. Woke's joke, gut feeling, this won't end well for the state. Oh yeah, the leaper, the judge leaper. Diablo Redden, yeah, Diablo Redden. He attacked Judge Mary Kay Holthus in Las Vegas, January 3rd of 2024. Diablo Redden. Brad says, nothing he said is evidence, but the jury can't unhear it. Joanne, he had his chance to tell his side of the story. It's all about choices. Cross-examination says, I thought he was one of the ones that wanted to testify but wasn't sure. Yep, he was. Yeah, he was the only one. And then Quandaria says, depending on what Zavante does, then he'll testify. That all was on Friday. The other 3 said no. So car 1, Zavante was the driver. Quandarius is the alleged shooter. They wanted to testify, or they were debating, weighing it, were they going to or not. They wanted to. And then car 3, they said, nope, we're not testifying. Ellen, can we have the charges up again for a moment? They're in the description. But we can throw it up here real quick. First degree, attempted first degree, conspiracy, and then shooting into a vehicle. But they're in the description as well. So not all of them have the same charges, but all of them. Oh, and then Hammond and Sampson are also charged for. So I guess. Okay, then it's also discharging a firearm from a vehicle. So then there's that. So those are that's James, Andrew, and Quandarius. So you have the drivers. So everybody has the same thing. And then you have the alleged shooters, James, Andrew, and Quandarius, for discharging a firearm on top of it. Kelly says, it's got to be hard to sit there and listen to the state. He may not trust his attorney to respond. Of course it is, yeah. I mean, you're listening every time we've seen closing arguments. We're always like, the state is just going to hammer, hammer, hammer. Oh, shoot, I was keeping track of the time. When did this happen? 9 minutes ago. I'll say, wait a minute. Say 15 minutes ago. So she started at 10. I'll say she got interrupted at... How you doing, buddy? Hi. What's up? You need a little purr machine? My little purr machine? What's up, buddy? No, that's my water. You can't have that. Hi. Little squeakers? My little squeakers? That's a little Fed that's making all the noise right now. All the purrs and squeaks. What's up, buddy? Nope, this is my water.
So, Mr. Sampson, my understanding is you don't want to be here anymore? You don't want to participate in this trial?
No, sir.
You have a right to be here and go through the whole thing, and I would prefer you did that, and I'm sure your attorney would. But if you don't want to, we're going to put you in a holding cell. We're going to set up a TV out there so you can watch if you want. You understand that? But if you're going to stay in here, you can't be doing what you did. And if you did it, and if I did allow you to stay, and you did it again, then I would have you exit it again and not allow you to come back. You'd have to watch it on TV. But if you don't want to come back right now, that's fine. They're setting up the TV right now as we speak. Is that what you want to do? That's a yes?
Yes, sir.
All right.
Judge, can I put some things on the
Yes, sir.
record, please? I had an opportunity to speak with Mr. Sampson and certainly underscored, his due process rights during the course of a proceeding and a trial, certainly one so meaningful. I expressed my desire to have him join us for the rest of the process, understanding that he would keep his emotions intact. He has indicated to me that he does not want to return. I certainly do not think that that's in his best interest, but in the same respect, if his emotions are going to get the best of him, that certainly is not in his best interest as well.
I understand.
He did also...
It's not going to get the best of him. I'm just tired of him.
You're just tired?
I won't figure out anymore, but I'm tired of him.
Judge, I guess what Mr. Sampson is saying is just he's weary and tired of the process and he doesn't want to be present.
I understand. All right. Well, we'll accommodate him by putting that TV up for you so you can watch it if you want. You don't have to watch it if you don't want. Thank you, sir. So, one of two things. One, I can just tell the bailiff to tell the jury that we're going to be in recess for an hour, or I can bring them in and I can put it on the record.
the court's preference. I actually didn't realize we weren't on the record.
No, I sent them out for like a 10-minute break to see what we were going to do, and it's going to take an hour to set that TV up.
Oh,
So, and they're starting it already, so.
Judge, the state is, I understand the court's ruling is not going to allow us to introduce this as convictions. However, I would request a curative instruction.
All right, so I'm going to bring them in, give them a curative instruction, and then release them till, then it's lunchtime.
Can we discuss what the curative instruction will be?
Well, we'll get to that, for sure. But, so why don't I just tell them to come back at 1:15?
From right now, Your Honor?
Right, I mean, because if they come back in an hour, and that's if they get it done right on an hour, it's noon. And then you still have some work to do on your closing.
Yes.
So why don't we just tell them to come back at 1:15?
I'd like them to have a curative instruction before taking a significant...
We are going to do that. So, well, we're going to let them break to 1:15. But before we do that, I'm going to give them a curative instruction that they're not to listen to what the defendant said. What he said is not evidence. You should not consider as any evidence. And what else can I tell them?
But the defendant has elected to abstain from attending the rest of the trial.
I can say that.
At this point, it's an abstention.
And Judge,
At his choice.
If there is no evidence of self-defense and that they will not be receiving any sort of instruction on self-defense whatsoever. Because he basically was screaming out that he was being shot at, and they were just shooting back. There is no evidence of self-defense. There's no evidence of that.
You can make that argument in closing. I'm just going to tell them that what he says is absolutely not evidence and not to be considered as any evidence of such. It's just, and that he has elected to absence himself from the remainder of these proceedings. Anything else?
Judge,
No, I'm not bringing them back in. My mind's not going to change. Yep, so we'll do that. Yes, ma'am?
can I just address one matter on behalf of Mr. Hammond? We would, based on Mr. Sampson's actions and him absenting himself and his outburst in court, we would move for a mistrial. This is a case where we did move to sever all the defendant or ourselves from the other defendants in this case, specifically Mr. Sampson, and the court denied it. That was Judge Rice who did that. Based on this, the events that happened, and the fact that Mr. Hammond is alleged to have been in the car with Mr. Sampson, and anything negative that might be associated with Mr. Sampson would then get also associated with Mr. Hammond based on the association in this case. We would move for a mistrial.
All right.
On behalf of Andrew Johnson, we'd also move for a mistrial.
Same with, I would also join in, Your Honor, on behalf of Jalen Denver.
I understand. I'm going to deny that request for each defendant, the request for a mistrial. There's a jury instruction in here that I'm going to be reading to the jury where that talks about, if you find one person guilty, you have to find them guilty and you have to decide for each one individually. And I think that...
which is the instruction that's already in the packet.
Right. So, and they'll be reminded of that. So I'll deny the request for mistrials.
Thank you.
Anything else? All right, I'm going to bring the jury back in, give them the curative instruction, and dismiss them to 1:15. Whenever they're ready. I want to caution the other folks, you all have been conducting yourselves like gentlemen during this time. I hope that continues. Otherwise, as you see, it's not going to result in anything except you making a fool out of yourself in front of the jury and having to sit in a holding cell and watching the rest on TV and not participating in your defense, which I think is very important that you continue to work with your attorneys as you have been. And I thank you for your conduct up to this point, and I hope it continues. 1:15. Well, actually, since they're going out, I'll just say 1 o'clock. That way everything will be done.
All rise. Here's entering.
Chairs back, y'all may be seated. Welcome back, ladies and gentlemen. I take it there were no issues with the court's instructions. All right, ladies and gentlemen, Mr. Sampson has chosen to absent himself from the rest of this proceeding, so we will continue in his absence, and there are some matters that we need to arrange for that to be done. That'll take about an hour. So I'm going to release you until 1 o'clock so you can have lunch. But before you go, I want to tell you to disregard everything that he said during that outburst in court. Nothing that he said is evidence, and you are absolutely not to consider it as any sort of evidence whatsoever. All right? Having said that, I will now dismiss you until 1 o'clock. Thank you.
All rise. Here's the exit.
Court will be in recess till 1 o'clock. Those left, y'all may be seated or enjoy your break.
Unrelated. The January 19th thing that you gave, Tom Holland. So she said it's maybe 20.
See? You have one opportunity.
Is this what you're looking for?
All right, so interesting. Let me put up our scroller and then we'll get to what just happened. So till 1 o'clock. Let me just get my scroller going. So court is at break until 1 o'clock. So yes, it may take them an hour to set up, but think about it. He's going to be in a holding cell. So who knows? Obviously, it's not just a situation where they can just take a TV and plug it in. Who knows? I don't know. So that's why it's taking them an hour. All right, well, let's get to what we heard so far. So at the beginning of all of this, they asked all of them if they wanted to testify, and they all said no. And Savante swore to take an oath, or he was sworn in, and judge asked him if he wanted to testify. He said no. So then the state started their closing at 10, so she starts off with 2:06 is what it took for the defendants to play a role in the murder of Suni Bell. 2 minutes and 6 seconds. She said that often. Suni was the backseat passenger while her family was attending a celebration of life, but they violated the rules, meaning they came onto a street that was close to where the defendants were hanging out. So they violated the rules according to these defendants. The defendants got masked up and armed up, and they went to war. Each played a role in the shooting repeatedly. You don't shoot that much and expect people to survive. She says the utter excitement you see in the video is indicative of their intent to kill. It's not the state's job to jump in the minds of people. We can't prove what the motive is because it's impossible for us to get into the minds. No one will know the motives, but you don't shoot into a vehicle this many times with the intent for them to live. Then she shows the photo of Quandarius, the photo of him with his 9mm. Willie Brown says he saw the defendants pointing at him and he decided not to stay in the field. Savante Sampson is the driver. You'll see him point, and he leads the charge as they leave the gas station. You see them pointing at the cars behind the gas station. We do know Savante is, or how do we know Savante is a part of the scheme? So she starts with Savante and she works her way down. Because he was driving the car with the first shooter and all 3 cars targeted the same car. Then she goes, let's go to Andrew Thompson. Defense asked to approach. The moment Jalen trips over the rebar, Andrew takes off his shirt and ties it around his face. You see Savante make hand movements before Jalen comes back from the field. Andrew changes from a handgun to his AR. Jalen has a handgun and talks to Andrew and now has an assault rifle. James sprints to the back seat of the Chrysler 300. Jalen stays in the field for a few minutes and then runs back to the group. James doesn't want to be left out. Everyone is jumping and doesn't want to be left out. At 9:03:26, we see the victim's car pass the chevron. At 9:03:48, car 1 leaves, followed by the other 2 cars. She talks about there's not sufficient evidence to charge car 2. She says, we have evidence car 1 and car 3 discharged their firearms. She says you don't get away with shooting at somebody and taking them out because you have too many accomplices. I thought that was a really good point because we're like, what about car 2? What about car 2? There was 4 9mm casings found. What about car 2? What if they were the ones that shot the bullet? Well, it doesn't matter because everybody was involved. So you don't get away with it because you have too many accomplices. So there was 1 round of shots in the break. This was helpful because I hadn't heard this before. So car 2 and 3, before cars 2 and 3 even pass the camera, you hear shots from car 1. So you hear 10 rounds. Boom, 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 boom. So 10 rounds. I counted 10 rounds, and I listened to that a couple times. Quandarius Quandarius does call his girlfriend, trying to get her to tell law enforcement. She picked him up already, but she had already told law enforcement that she was in St. Pete, and that's the jailhouse call. You see the brake lights from car 1 as it catches up to the victim's car. The victim car comes to a halt at 9:04:38 in front of Lorenzo's car, and car 1 is shooting into it. Those are the 10 rounds. Michael Corberly's home camera also picks up the shots. Group 1, all other casings go past 43rd Street. Car 1 turns left onto 43rd. So, I don't know why she said that. I don't think that's true. They're between 45th and 43rd. All right. Gun 1 belongs to Quandarius. She says Mary gets the car going again and shots start back up. Car 3 enters the frame at 9:04:04. Then you hear round 2 of shots at 9:05. 9:05:08, car 3 continues to shoot into the victim's car as it's about to crash, and even after it does crash. She says James didn't shoot the AR because he had his own 9. Car 1 returns to the chevron. Windows are down. They all conspired with words and actions, which was shoot as many times as you can into the victim's car. They found 40 casings. She said there could have been more, but 40 is what we found. So then she gets into the charges. So all are charged with count 1. First degree is premeditated, specifically for Suni. How if they don't know them? Let's see. How can we charge them if they don't know them? Well, it's the same. Okay, my notes are a little confusing there for myself. How can we charge them if the defendants didn't know the people they were shooting at? She says, well, it's the same as a mass shooter going into a mall. You don't need to know your victims, right? You don't need to know what they said. She says it's not if they planned to take out a 4-year-old child. It's they opened fire and shot over and over again. So they're trying to say, the state's saying, hey, look, we know that they didn't plan to do this, meaning shoot and take out a 4-year-old child, but we do know that they shot over and over and over and over again into a vehicle. No, they didn't know she was in there, but their actions caused her to die. No one is charged with shooting the bullet that actually took out Suni because it was a through and through wound, so they don't know. What was the conscious intent of the defendants as they gathered in the parking lot? That's what the state is saying you need to pay attention to. Did they discharge their firearms? Did he have one, and did he discharge it? That's what they have to ask. And then this is where Zavante, he's making comments about, they were shot at first. Judge says, do you want to stay and participate? He says, no, I don't. Judge says, okay, we'll put you up in another room. Defense says, I had an opportunity to speak and underscore his due process rights. He doesn't want to return, but if his emotions are going to get the best of him, then that's not in his best interest. Zavante says, I'm just tired. So it'll take an hour to set up the TV. State says there's no evidence of self-defense, and he's just screaming out that he was getting shot at. Quandarius, they also asked for a mistrial. That's Jennifer Spradley. She's like, we wanted to sever ourselves, and we were denied by Judge Rice. So anything negative will now be associated with Quandarius. That's a good point, right? Because if the jury's like now, making any kind of, oh, well, Zavante, if they're being negative towards him, hey, Quandarius was in the car with him, so that's why they're like, we want a mistrial. Of course, Andrew, Jalen, they all asked as well. Judge denied the request. And then after that, the judge says, all you gentlemen have conducted yourself well, and unless you want to act like a fool in front of the jury, we're going to put you in a room as well with a TV. So the jury comes back, and judge says Zavante has decided to absence himself, and nothing he said is evidence, and you are to disregard everything that he said. Whew. So it's so hard for a jury to be like, oh, okay, sure, I'll just disregard that. I mean, they can. I think ultimately they will, but now they have to be thinking, wow, he's saying that they shot at us. They shot at us. 3, 2, 1, relax. Been listening with y'all while working, but just had to chime in. Whoa. Thanks for all you do. Thank you, 3, 2, 1. Appreciate that. Yeah, it's amazing. Michelle, have they got to go buy a TV? Seems like a long time to set up, even to close circuit to the courtroom. I don't know, other than it's a holding cell, so who knows? They may not even have power run to it. There may be no outlet. Maybe they got to drill a hole maybe they got to run cable. Clearly they're not prepared to do this, so that's why it's going to take them an hour. There could be no outlet. There could be no power. There could be no TV. There could be nothing. So, Ellen, fantastic recap. Thank you. Did we hear Willie's testimony? No, that was day one, Amanda. We did opening statements, and Mary and Willie and the neighbor, they all testified. We have reached out to a source, and we're trying to see if we can get that. So we can play it for you guys. So we haven't heard back yet. Mallory, if they were getting shot at from the field, any of the defense teams could have introduced that into evidence, and they didn't. Yeah, that's what I thought. They were going to bring a crime scene tech in today. Brian Gonzalez, who is Zavante's lawyer, he talked about this crime scene tech Boyd, and if she had come in and said, yes, there were bullet holes found, that would have been game changing for sure. Cross-examination, did any of the defendants disclose to the lawyers about being shot at first? I don't think a defense lawyer would ignore that. I don't know. Do not know that. Sherry, can the defense during closings bring up the fact that they were shot at first? What they say is not evidence. They could bring it up, I guess. It'll probably be objected to. They might say facts not in evidence. So they could say it. Well, we'll see. We'll see what happens. We'll see what happens. All right, Ellen, we need a poll, a complicated poll on which counts are they guilty and who, right? Well, I only have 4 fields. I only have 4 fields, so that's going to be difficult. You would think it would be established permanently for these situations. Maybe now they will. Maybe now they will. Maybe now they'll consider it moving forward, right? I mean, jails are not meant to be for comfort, right? They're just not. So they're not built for comfort. Christine, sure, you can go ahead and stream it, and thank you for asking. Appreciate that. Yes, go ahead. JMS, I thought I read the police said there was no evidence of them being fired on from the car. The car that was recovered, the Chrysler 300, there was no evidence. So I don't know. I mean, yeah. Theodora should have separated the defendants in separate trials. My opinion based on the outburst from the defendant. They tried, Theodora. They tried. The defense tried to have sever. That's twice we've heard that they wanted to be severed. That's twice that we've heard that. We heard that on Friday and we heard that today. And Judge Rice denied it. Cross-examnesia. Court employees mad they have no TV in their break room now. Right. You're in your break room eating and all having coffee or whatever, and all of a sudden the TV gets rolled out. That's funny. Well, we've been spoiled lately. I don't think either the prosecution or defense has been all that impressive this time. 321. He was looking to his attorney to object, then he just went off in the most chill, calm manner. Yeah, that was one of the more chill ways to throw a tantrum, if you will, or to get upset. Oh yeah, Aaron says also probably trying to figure out how the TV won't become a weapon. Then there's that. Yeah, I mean Zavante could use it. He seems like a pretty chill guy, but you never know. He could. You just never know. So somebody could be sitting in there with him to make sure that he doesn't try to hurt himself, hurt somebody else. And then there's that. I would assume he's going to be tied up. We're going to cover this. Soto Escalera that's happening right now out of southeast Florida. We're going to do at least opening statements today, and then we're going to pick up on that. It's he stabbed his mistress. She had an 8.5-month-old baby, pregnant. She was pregnant, and he stabbed her. So we're going to cover that one next. That's happening right now. So we're going to cover that one. We're going to at least get to opening statements today, and depending on how soon this one ends, we're going to cover that one. So it's Jose Soto Escalera and Jamie Weiss, I believe her name is. I got to get her name. I think her name is Jamie Weiss. Oh, Tanya Weiss. So that's the next one, and it's a DP one. So we're going to cover that one next. Callie, is this not a RICO trial because they aren't members of a gang? I don't know the answer to that. Bolt the TV to the wall, JMS says. Well, that's why it's going to take an hour for them to do this. That's probably why they're going to. Yes, Christine, you can go ahead and stream it. Yes, you can. You can go ahead and stream it. Here, I'll even tag you. Okay. You can go ahead and stream it. Yeah, that one is going to be sad. Yep. Jose Soto Escalera. RICO has to include racketeering. JMS, I think I've heard of that case. Yeah, it's down in Port St. Lucie, which is close to West Palm, which is where Aaron and I used to be. And then Fort Lauderdale. So, yeah, we've heard a lot about RICO. What exactly are RICO charges? I always put it up to, RICO stems from Racketeer Influence Corruption Organizations Act. It's federal law that targets organized criminal enterprises. So that's how, watching The Sopranos, that's what I just always heard of RICO. I just always associated them with organized crime. So it's Racketeer Influenced Corrupt Organizations. Now that sheriff that was investigating Stefan Stearns, I think he was brought up on RICO charges because of the gambling, that thing that he was running, that gambling operation. Let's see. Government must show that an individual or organization engaged in a pattern of racketeering activities, which is fraud, extortion, or drug trafficking, is part of a criminal enterprise. So I don't think these charges are serious. I don't think it would have applied to these guys. It passed in 1970. It requires proving that a group or enterprise exists to commit certain crimes repeatedly. So yeah, okay, so it's repeated crimes. So I don't think it refers to engaging in two or more underlying crimes from a specific list within a 10-year period. So that's what racketeering. So it's Callie, it's not necessarily organized. It's just an organization. I always associate it with because of The Sopranos, right? That's just me. But no, it's any kind of organization, or so it could be a group or an enterprise that commits crimes within a 10-year period, and you have to do it over and over again. It's not just one crime. So I don't see how that would apply here. I don't think that would apply here. Daisy, you were busy this morning. When did an outburst happen? Around 10:45, so 45 minutes or so ago. It's a racket. There you go. That's an easy way to remember it. Hey, Mel, good to see you. Thank you for joining us. Let's see. JMS, I think RICO has been used a lot on a lot of cases, not really related to what the intent of it was originally. Waste management should be brought up on RICO charges. Hey, C. Gilmore. Went to the BC Interior, British Columbia, I'm assuming? British Columbia Interior? Namarata? I don't know any of those. Ed says, arguably, if they had a drug business, that should be enough. Well, they weren't, that didn't come up. So that didn't come up. So that would be, if that was on the table, then I guess they'd be talking about that, but they're not. Wasn't RICO established specifically to prosecute the mob? That's what I'm thinking. It started in 1970, so I don't know if it was specific to go after organized crime. Well, it was to go after organized crime, but I'm not sure. Let's see. RICO charges from the archives of the U.S. Department of Justice. It was passed by Congress with declared purpose of seeking to eradicate organized crime in the United States. Rosello versus United States versus Turquette. So it was specific to go after organized crime, which in 1970, I guess, was probably what we all know of organized crime to be, which would have been the families, in New York, Chicago, etc. But it has since expanded. Ed, they don't know why they did it. The state doesn't have to prove, as she was talking about. Miss Bonte, Catherine Bonte, she doesn't have to prove, she was saying we don't have to prove the motive, we just have to prove the intent. So she was saying they don't have to prove why, they just have to prove, she's like, it's the same as a mass shooter going to the mall. You don't need to know their victims. You don't need to know what they said. If they plan to take out a 4-year-old, it's that they opened fire and shot over and over and over again. So you don't have to prove the motive, you just have to prove their intent. And the intent was they shot into a car, a moving vehicle, going relatively high speeds on a busy street. They shot, and anybody could have been hit. Not just the car. It could have been any random drive-by. The car could have flipped, taken out another 2, 3, 4, 5 cars, could have exploded. Anything could have happened. So that's what you don't have to prove motive, you just have to prove intent. Alicia, you watching the pregnant lover mistress one? Yeah. We're going to pick up on that. Ellen, did Bonte prove who was shooting specifically? Nope. Well, yes. We know the driver was Zavante and Jalen. So we know the shooters were Andrew, James, and Quandarius. So that's... have they proved that? Well, they proved that they got into the cars, and they proved that there were muzzle flashes. So they proved that. They also proved James's 2 casings that belonged to James's gun were found. So they've proved that. We have not yet, JMS. Nobody's heard any news of Wendy or Harvey. Hellrider, why I want to hear a motive. I would love to as well, but according to Zavante, they got shot at. That's what Zavante said, but we can't put that into evidence. So, JMS, prosecution doesn't have to prove motive, but I believe most juries like to hear one. Yeah, absolutely, as do we. 100% you want to know why. You always want to know, but why? Why would you do that? You always want to hear the motive. I agree with that. Phyllis, prosecutor said the victims weren't allowed on the street. Sounds like motive. Did any of the defendants say that in an interview? Not that we heard of. Nothing that came into evidence. Everything we're hearing is like speculation, or Zavante saying something. People in chat have been saying it. Ellen, looks like there will be a slightly controversial verdict. Yeah. Yep, I agree. There's always going to be a side that's not happy with the verdict, no matter what happens, right? There's always going to be a group that is not happy with the verdict. All right. We have until 1 o'clock. We have until 1 o'clock. So here's the thing now. This is going to get interesting because the judge said he did not want to split this into 2 days. He didn't want closing to be split into 2 days. So he's allowing the state to have an hour and a half, and that's split between the two of them, and he's allowing each party to have an hour and a half. But he says you guys can go longer if you need to. So, and the defense said we're not going to, nobody thought that they would use the entire hour and a half. So even if they go a half an hour, so that being said, judge does want this to be split, was not anticipating any of this. So because they started basically at 10 o'clock, they could have gotten in everything in one day. Now, with this interruption, the state still needs to finish their closing. And then we're going to have at least 2 hours of defense closing, I would think, between the 5 of them. And then you have jury instructions, which could take another half hour. So you're still looking at like another 2.5, maybe even 3 hours. So if they come back, they come back at 1. Yeah, I guess the jury could get into, it could go to the jury to deliberate by 4 o'clock. So it still could be. Brad says, I still can't fathom pawning the weapon. Creating paperwork associating your thumbprint with the pew-pew was just bizarre. No amount of money from the pawn shop could possibly be worth it. He said he was down on his luck. He said, James said he was down on his luck. This is what he told Detective, I think it was Saleha, or it was another detective, I forget. But he told detectives that he was down on his luck. So, who knows? JMS, I wonder if we hear one guilty verdict means they will all be found guilty. If a driver is found guilty, then I would say it doesn't bode well. Like if Devante's the first one up, because he's car one, he might be the first one up. If they find him guilty, I would say it's probably not going to bode well for the other guys, I would think. Mallory, you're still upset about the Ollie case? Hellrider, yes, he said he was shot at, but you would thought that would have come out in Discovery. Yeah, exactly. I don't know why they didn't pursue that. Lorene says, is this the guy who asked his girlfriend to lie for him? That was Quandarius, the guy on the far left there. That was him. Zavante, no, it was Quandarius on the far left there of this photo. He made his own luck. Phyllis, something tells me the jury will struggle with letting little Suni's death be in vain by not convicting. Then there's that, Some people, you just gotta be like, oh man, it's there. I mean, the evidence I think the evidence is strong enough. There's some doubt, but you're right. That doubt may be erased by we gotta find some kind of justice for Sonny. That very, very well could happen. Charmaine, good to see you. Just thinking out loud, what if the uncle who ran did shoot at them and ran to hide his own weapon? Sure. It's entirely possible. Anything is possible, Charmaine. That's not that far out of the realm of possibilities, He could have very easily shot at them. Ellen, was there any evidence that the victims had weapons? Nothing that came in. Pammy, because he just now came up with it. Well, Pammy, there have been people in chat that have been saying that a couple days ago. So I was hoping the defense would bring something in on that, but Jennifer, good day, everybody. So happy to be here. Thanks for having me. Thank you for joining us, Jennifer. Appreciate you joining us. Unfortunately, they're going to be at lunch for another hour and 20 minutes. But I'll play some kitties. Let's see. Yeah, okay. Where are the casings if Uncle did shoot? They'd be on the street, right? They'd be on that back street behind the Chevron. Did they ever check there? Who knows? Did the state ever check there? We don't know. Let's see. Sherry says, if I was a juror, I might say, I don't think they meant to unalive a child, but they definitely meant to shoot. Therefore, I would vote guilty. Well, as the state said, as Ms. Bonte just said, she did say pretty much those words. She said, it's not as if they planned to, take out a 4-year-old child. It's that they opened fire and shot over and over again. So pretty much the same sentiment. Yeah. Hellrider, I think these dudes ran the block and Willie was in the wrong place at the wrong time. Yeah. Well, don't forget, Willie had a cousin who had a salon. So Willie must have known the area. You guys that know the area, you tell us. Willie's cousin had a salon like a couple blocks away, right? So he must have known the area, right? Jennifer, oh, that's right. That's quite all right. I love the kitty so much. Everyone make sure to boop the like while we wait. Mallory, hearing, day one, audio, the sound was so bad. we reached out to a source, so we're hoping that we can get day one. We're really hoping we can get day one. We're really hoping we can get day one. Yeah, we just played opening statements, and then that was the morning, and then the afternoon, the audio was just not. We're hoping that we can get day one still. All right, you guys, I am going to take a break. We have it's almost 12. It's 11:45. They're coming back at 1. So we're going to go ahead and we're going to feed the kitties. We'll get them set up here. Let's see, Hellrider. I would seem if they had a. Let's move fast. I would see if they had a beef with Willie, it would have come out by now. Yeah, I agree. Cross-examnesia, or in the field between the car park and the gas station, like someone in chat had said, Willie fired at them across the field. Rounds could be there. Was that area searched? We don't, not that I know of. I don't think so. I don't think the state didn't search there. They didn't say if they did or not. So, all right. Let's get some kitty action going here for you guys. I'll set up kitty cam. Let's see here. We'll get some kitty cam going for you. Well, lunch is at trial is at lunch. All right. I'll see you guys in about an hour. Florida PI Sam, thank you for joining us. Hope you guys had a good break. Let's get to some comments. Florida PI Sam, aren't you sad you weren't here to bear witness to the crazy? Yes. Alexis, hello, chat. Squeegee, the kitties are looking particularly fur-tastic today. Yes, they are. They're growing up so fast. They're growing up so fast. Widespread panic. Good to see you. You're afraid of height. I don't need to go scaring myself on purpose. Elizabeth, thank you for joining us. Florida saying, good afternoon from a spicy day in court. What can you tell us without divulging too much? Florida PI Sam, what can you tell us? I'll leave that up to you. Oop, just had a cat flop. Widespread, just walked into the kitchen and my cat was licking the bananas. That boy ain't right. Was he licking the inside or the outside of the bananas? Inside or outside? Yes, JMS, of course the kitties love the thing they love the most is just some paper. Just some paper. Barry saying hello to PI Sam. Well, we don't want anything to happen. I mean, this has already been weird, potentially mistrial area, so we don't want anything more to happen. Widespread, the outside of the banana is sitting on the counter. Weirdo. That's pretty funny. All right, so before we broke, Zavante had a moment there. He said they shot at me first, or I wanted to testify. It was an interesting moment there. He was let out of court. Jury sent out. The gallery was clear. Judge asked him if he wanted to stay and participate. Let me see here. Ford asking Barry, were you here on Saturday? Missed you in chat. I don't think so. I don't remember seeing you. Sorry if we missed you. All right, here, let me play this again. We can back up and we can play what happened right before. Let's go back and show what happened that led us to an early break. Okay, let me go back.
He's charged as a principal, as an aider to ensuring it happened, as the driver during the course of the murder, as encouraging the other defendants, telling them before they jump into the vehicles and chase after the victim's car that's just passed by the Chevron. He doesn't have special findings, but he has the same result. He's guilty of murder, just as are his co-defendants. We talked about motive versus intent. Motive is not what needs to be established. There are counts for which...
Yeah, you see him look over. He looked over at Mr. Gonzalez there. So she's talking about Zavante making movements and motions with his arm, and he looks over, Zavante looks over at Mr. Gonzalez.
The intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Somebody shot at me, somebody shot at me.
Take him.
Somebody shot at me, somebody shot at me. It's as simple as that. Oh, she picked this thing down. Somebody knew that shit gonna happen. Somebody shot. I feel sorry for that little girl, but somebody shot at her. It's the truth.
I feel sorry for that little girl, but somebody shot at us. That's the truth. That's what I heard.
Somebody shot me and somebody shot that. It's simply that. Oh, she picked this thing down. Somebody knew that shit gonna happen. Somebody shot. I feel sorry for that little girl, but somebody shot her. It's the truth. Y'all, hey, be quiet. I don't know
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues.
So I feel sorry for that little girl, but they shot at us first. Or somebody shot at us. And then let me go to, then he comes back.
Right to be here. Mr. Sampson, my understanding is you don't want to be here anymore? You don't want to participate in this trial?
No, sir.
You know, you have a right to be here and go through the whole thing, and I would prefer you did that, and I'm sure your attorney would. But if you don't want to, we're going to put you in a holding cell, and we're going to set up a TV out there so you can watch if you want. You understand that? But if you're going to stay in here, you can't be doing what you did. And if you did it, and if I did allow you to stay, and you did it again, then I would have you exit it again and not allow you to come back. You'd have to watch it on TV. But if you don't want to come back right now, that's fine. They're setting up the TV right now as we speak. Is that what you want to do? That's a yes?
Yes, sir.
All right.
Judge, can I put some things on the
Yes, sir.
record, please? I had an opportunity to speak with Mr. Sampson and certainly underscored, his due process rights during the course of a proceeding and a trial, certainly one so meaningful. I expressed my desire to have him join us for the rest of the process, understanding that he would keep his emotions intact. He has indicated to me that he does not want to return. I certainly do not think that that's in his best interest, but in the same respect, if his emotions are going to get the best of him, that certainly is not in his best interest as well.
I understand.
He did also...
It's not going to get the best from this time.
You're just tired?
I won't figure out no more, but I'm tired.
Judge, I guess what Mr. Sampson is saying is just he's weary and tired of the process and he doesn't want to be present.
I understand. All right. Well, we'll accommodate him by putting that TV up for you so you can watch it if you want. You don't have to watch it if you don't want. Thank you, sir.
Okay.
So, one of two things. One, I can just tell the bailiff to tell the jury that we're going to be in recess.
All right, so that was that was around 10:45 to 11 o'clock. So Ms. Bonte was talking. She started at 10, and this was around 10:45. Zavante interrupted her around 10:45. So then ultimately,
That's for an hour.
Ultimately, he decided to watch in a holding cell. So it's going to take them an hour to get. It's going to take AV an hour to get set up. So. Let's see. Florida PI Sam says, Shirley, I'm sitting right behind him. Never seen so many bailiffs move so fast. Nomad coming in late. Thanks for showing this again. Sure, no problem. Does he want to snitch now? Hasn't said anything. Didn't say anything that didn't indicate it. He just said he's tired. Just says he's tired. Just that he's tired. Widespread says, I'm theorizing, don't know for sure, that a car that looked like Willie's car was the one that they shot at them, mistaken identity with tragic results. Shay Lee, thank you for joining us. The videos of the Chevron didn't show them running and ducking. No, it just showed them running around, and as Ms. Bonte was saying, they were excited. They were in an excited state. That's what she was describing it, as that they were in an excited state. So she didn't say, and I really wish the defense had said something like that, you know? It's a bummer that there's going to be nothing to refute that, to say, you know, or to confirm that, yeah, we found some casings, you know. Amy's saying hello. Barry, Sam, if you're stuck in the courtroom waiting for attorneys to set up or finish a conference, is that time billable when you have to play hurry up and wait? So I guess it's official now. Florida PI Sam has outed. Oh, kitty in the fireplace. Hold on, I'll be back. All right. Shirley, thanks for showing that. Yeah, no problem. Yeah, we have 10 more minutes. Let's see. BLP 2002 says he's not tired, he's disrespectful. Florida says, I'm here in court in a suit at the defense table. Kalia says, we think they're building the TV that takes an hour to set up. I'm just thinking that they're not, it's a holding cell, right? You know, so there's probably, it's like just a room with maybe a chair, if that, you know, or a bench, a stool. So there's probably no electricity, there's probably, or, you know, no power outlets, there's no TV outlets. Maybe they can figure that out in the future. But yeah, I don't think it's like, you know, when you're in school where they roll in the TV and they just, you know, plug it in and Bob's your uncle. Amy, got to figure out your lunch? No problemo. Widespread. No, there was Houdini. But last week there was like 2 or 3 of them in there. There was 2 or 3 of them in there. Alexa said, Trial TV Live exclusive. Reveal of Florida PI Sam. I don't want to be the one that causes any kind of weirdness for Sam or this trial. So I'm gonna keep it cool. I'm going to keep it cool. All right, we're going to have difference of opinions in this chat, so I just ask that you guys, you know, be respectful of each other. That's all. We're going to have difference of opinions, so just ask that we be respectful. It's Wendy's TV, Ed says. Yeah. Where's Jeffrey Lacasse? What? Now what? There. Barry says, I think everyone on both sides in the courtroom is holding their own when keeping it weird. They don't need our help. Right? Good point. Yeah, usually outbursts like that are not the best look. Clearly, Zavante's emotions got the best of him, so he's not a good look. But he'll have time to think about it. All right, Florida PI Sam, have a good afternoon to you, and good luck. Good luck in the courtroom. Appreciate you guys jumping in. Appreciate you coming in and saying hello to us and giving us some in the court insight. Beat says, I didn't know being tired was disrespectful. I think it's just the outburst, I think it's just him talking out of turn. You just can't do that. Unfortunately, you just can't do that. That's why you have attorneys. You gotta just not do that, unfortunately. That's why you have attorneys, All right, you're not going outside. I know you want to, but you're not. All right. Barry, any defense attorneys in chat to lend insight into what's on the table realistic as to strategy from here? I don't even know if they were in chat they'd be able to say that, Barry, as much as we want them to. Maybe afterwards we can get some to come on. Beat, talking out of turn, understood. Yeah, it's like I said, that's like the most chill outburst I think I've ever seen compared to some others that we've seen. That was pretty chill, but you can't do that. It's a court of law, and you have to respect the process. As much as you may not want to, you have to respect the process. That's why you have lawyers. You let them, they are your mouthpiece. You gotta let them do the talking for you. You have to sit there and take it. Absolutely. Beat says, but disrespectful, use a different term. Understood, yeah. I mean, sometimes I think with Lori's, when Trina was going off on Lori, or sometimes, these prosecutors, these state will just, that's their job. Their job is to make these people, whether it's Lori or Donna or, anybody up there, it's their job to make them out to be the worst of the worst of the worst. That's their job. They're trying to get a conviction. So they're not going to get up there and sugarcoat it. They're going to get up there and they're going to use words that are going to be impactful for the jury to be, pull on the heartstrings and all that stuff. Hopefully followed with evidence. That's ultimately what you want them to do, is present evidence. Barry, oh yeah, not their attorneys, just someone who might have some courtroom experience and might indicate what kinds of motions we can see coming back from lunch. I gotcha. Alexa's Trial TV Live has been here covering every moment of the trial and is doing an awesome job. The chat has been well balanced and respectful on all sides. Truly a monumental feat. Well done, Squeegee. Thank you, Alexis. Appreciate that. Barry, we won't have to wait long anyway to find out what happens. That's true. They're supposed to come back at 1. Now, don't forget, Judge wanted to have all the closings in one day. He didn't want to split closings. So now don't forget, the state is like only 45 minutes into an hour and a half. She wasn't done yet. Miss Bonte wasn't done yet. So she still probably has at least 15 minutes, I would think, to finish her closings, if not more. So then he's giving each party an hour and a half each. So I don't think each party is going to take an hour and a half. I think maybe half an hour, but still that's another 2.5, 3 hours. And then the state has to come back. So then we have jury instructions. So we're looking at like 4. Maybe this will go to the jury by 4:30. So, and then there's all, like Barry's bringing up, there could be motions, there could be all kinds of other things that are going on. So if the jury will get this, I think, but it'll be late. It'll be like 4:30, maybe even 5. We'll see. We'll see how long the defense goes. I mean, if they only get up for 15 minutes, then it'll go shorter, obviously. But and Alexis, yeah, Barry, they did make motions for mistrial, all of them, and it was denied. Alexis is correct in that. Widespread. I love the chat in this group, and it's all Chris and Aaron. Aw. They set the rules that everyone has to be respectful to everyone, and it makes a huge difference. Thank you, Widespread. And Chase says, yep, judge still has to read instructions. Yeah, we still have to do jury instructions on top of it all. All right, I'm going to grab some water real quick. All right, where is Aussie? Aussie is, let's see. Aussie is taking a moment. Aussie is taking a moment today. So Aussie is off today. Yep. So Ellen, Aussie is off. Oh, there. Joanne says, yep, Aussie is sleeping. Let's see, Psychosaurus. Didn't Attorney Zelli call it the audience for Donna Sue's trial? It was the Peanut Gallery. That's where the Peanut Gallery came from. Why was the audience in a gallery? Yes, it's called the gallery. Oh, there. Okay, the gallery. He called it the Peanut Gallery. Ellen says, I can vouch for the weird hours. 7:02 there. Alice, yeah, he's scratching like crazy. That's little Fed wants to go out, but I don't let him out without me being out there, so they're going to have to wait till after we're finished. They're still a little too young to go out by themselves. Psychosaurus, yes, the genesis of the Peanut title. It looks like we've got some action here.
There's been no evidence that there was any shooting coming from the vehicle driven by Willie Brown. There's been no testimony from anyone that there has. The only people that are talking about what happened there was Willie Brown and Mary, and neither one of them indicated anyone had a gun in their car. So there's absolutely zero evidence to show anyone from that vehicle shot at any time. And if they suggest that or argue that, we are going to be objecting because there is no evidence to support that whatsoever.
Judge, let's just hash it out right now.
Right.
There's picture in evidence with Willie Brown holding an object in his hand. There's a 45th Street Coverly video where it appears that Willie Brown has something in his hand. The state introduced a photograph, a couple of photographs of something on Willie Brown's wrist. Okay, the fact that Mr. Sampson had an Apple
What, like a wristwatch?
Yes, an Apple Watch.
Okay.
So the point being is that my argument doesn't need to be buttressed on self-defense. Okay, first of all, my client was the driver of this car. I don't even know if he had standing for self-defense, but that's not the point. There's no instruction for self-defense. I'm not suggesting there was self-defense. I'm suggesting that the evidence and the jury can consider whatever it is that is in Mr. Brown's hand. And if the state wants to argue it, and the state...
I don't know how you talk about what's in his hand without any evidence that it was any self-defense.
Judge, I'm not suggesting it's self-defense. I'm suggesting that the jury can make a determination based on what's in evidence. The videos and the picture that's in evidence okay?
Well, what are you going to argue that it is?
I'm going to argue that it's up to them to determine what it is.
Are you going to make any suggestions to what it is?
No, I'm not going to.
Okay.
I'm going to argue that the law enforcement did a search out there on one small area of a backyard of a single residence on 45th Street without doing a complete and total search.
But if he had shot his firearm in the area where he was running to the homes, it would have showed up audibly on the sound.
No, Judge, we're not talking, first of all, there was audible.
I'm not going to allow any arguments about self-defense. Then what are we arguing about?
I'm not arguing about self-defense.
Okay.
I'm asking the jury to make a determination as to what they believe and what they think could be in Willie Brown's hand.
And what would that matter? What's the relevance of that?
The relevance is because we don't know what occurred. We don't know whether or not...
And you want them to infer that all these guys shot all these guns at this moving car in self-defense.
You're missing the point, Judge.
I might be, so enlighten me. Because I don't want the jury to be misled, so I need you to enlighten me.
Judge, the fact that all of these guys allegedly shot guns is not the basis for allowing the jury. Why can't the jury believe, or why can't the jury determine whether or not something caused those gunshots, the first set of gunshots, to be...
Because there's no evidence that anything caused those gunshots.
He's got something in his hand.
That's not evidence.
The car.
What you say is not evidence.
Judge, it's in evidence.
Let me see it.
It's in evidence without objection.
There's no instruction for what the end goal.
You're going to say there's something in his hand? I can't even see a human being in that circle.
Well, Judge, it's not for you to decide what it's in his hand. It's the jury.
It's not for you to decide what's in his hand.
It's in evidence.
There's nothing in his hand that I can see.
Well, Judge,
I don't see anything in his hand.
Judge, you're not the trier of fact.
I have to control what's admissible and what's not admissible as far as what probative versus prejudicial.
Judge, that should have been an argument.
And you can't argue anything.
That should have been an argument made before the entrance.
Did you argue it during your case in chief?
I'm sorry, Judge?
Did you argue that he was holding something in his hand during the trial?
Judge, I didn't put on a defense.
Well, then, I know. So now you can't bring up, there's no evidence for them to consider because what you say is not evidence. And that's not evidence of anything.
Judge, the court cannot make a decision what is evidence. The jury can look at this and the jury can say, I don't see anything.
What if you said, look, there's a flying saucer in there, ladies and gentlemen? There's no flying saucer in this video.
This is a flying saucer. Then the jury would have to determine if it's a flying saucer.
No, I wouldn't allow you to make things up.
Judge, I'm not making it up. It's here.
There's nothing there.
See it.
I can't see it. Does anybody else see it? Mr. Terry, what do you see in that
I don't know. Mr. Terry allowed it in without objection.
It's evidence of other things, not of anything in Willie Brown's hand.
Mr. Terry...
You're not bringing that up.
Judge, Mr. Terry entered into evidence pictures of Mr. Brown.
You can't fabricate in your own imagination what you believe those pictures depict.
Judge,
You could tell the jury, look at this picture and decide, but you can't suggest to them that he's holding something in his hand when I can't even see if there's a human being in that circle.
Judge, is the court telling me you can't tell there's a human being in that circle?
To me, it looks like a picture of Bigfoot.
Judge,
you ever seen that on the internet? That's a Bigfoot representation.
They have already argued that this is Willie Brown running from the car.
All right, but I don't see anything. You see a shape of somebody running from the car.
Yes, Judge.
And what's in his hand?
And the state argued it was a person.
Okay.
He showed a video.
Well, then that's in evidence. But there's nothing in his hand. Was anything argued that it was in his hand?
Yes, Judge.
Let me see it.
It's in evidence.
Again, let me see it.
And I don't believe it's the court's venue to decide what's in his hand. That's the jury's ability to make those determinations. It's in evidence. So you're going to send it back now and you're going to have them have this picture and say, what's this picture in evidence for? If the state didn't believe it was worthy of argument, they wouldn't have put a picture of Willie Brown
fleeing from a car that was being shot at?
No, Judge. A picture of Willie Brown with an Apple Watch on his wrist to suggest that that is what the object is that is shining. They put their own version of this in, anticipating that they were going to argue it.
Did somebody mention an Apple Watch during the case?
Yes.
And just that we had on an Apple Watch?
Yes, sir.
Okay. So that's a better picture of him running from the car? Is that
No,
before
Judge,
or
this is when he's on Coberly, when he's
after?
with
Looking
law
for the,
enforcement.
right.
Okay, which, by the way, if you look at the Coberly video, you will see the same circumstance when he's running across the street. You will see a silver thing near his arm. I think we're invading the province of the jury to determine what...
I think we're going down some dark rabbit hole that invades no one's province.
Judge, it's in evidence. It's in evidence. It's been admitted.
This picture's in evidence. You could argue that he had an accomplice hiding in this car, ladies and gentlemen.
No, Judge.
If you look really close, that looks like there's a person in this car.
No, Judge, this
But why couldn't you argue that? Just as caveatly, why couldn't you just argue that?
Judge, the court indicated that you couldn't even tell if there was a person here.
I can't really tell if there's a
The
person here.
state's already submitted...
Because it looks better on the videotape than it does on that picture.
The state's already admitted that this is Willie Brown running.
Could you argue that he had an AR-15 strapped to his back too?
When we...
I'm asking you a question. Could you?
Could I argue that?
Yes.
No, I wouldn't attempt to argue that.
Okay, but you're going
But
to...
I would argue that there's a silver object or a white object in his hand.
Okay. State?
Again, Judge, especially in light of the testimony from Mr. Sampson, I think that can mislead the jury. There's no evidence as to what that is. It just as easily, that's the reason, so it could just as easily be an Apple Watch.
Then have him argue that.
But in light of that, what Mr. Sampson just did, in light of the fact that self-defense is not a defense in this case, is not being argued as a defense in this case, there wouldn't be any relevance to it whatsoever.
Let me see that picture.
Self-defense does not play a part here, Judge. It is what happened. Okay? It's in evidence. The court can't make a determination as to what the picture shows.
I do remember they brought in the Willie Brown photo of the Apple Watch. I'm like, why on earth would you be showing an Apple Watch? It makes no sense to me at the time, but now I'm kind of understanding. I'll find out which witness that was. So it was a recall. It was Officer Edward Barretto. He located Willie Brown at the scene. He had body cam in. They showed some still photos. Willie had on a watch. So he was a recall from day 4. And I'm like, why on earth do we care that Willie had a watch? I did not understand that at the time. So maybe that's, I mean, now it's kind of, I guess, making sense of it.
Reiterate exactly what your argument in closing will be. You said you wanted to hash it out. What is it?
Judge, the jury's allowed to make reasonable inferences.
Reasonable inferences.
That is a still picture of a video that is in evidence.
Right.
Okay? And there is also another video in evidence on 45th Street near determination as to whether or not there is something in Mr. Brown's hand, and could that something be a weapon? That's their province. If they want to reject that idea, if they want to determine that that's not what that picture shows, or that couldn't possibly be the circumstance, they can choose to do that. It is a picture that's already in evidence without objection. As
you said in your first sentence, it has to be reasonable.
Judge, it's a reasonable inference to look at that picture and look at the video that's already in evidence, okay, and determine whether or not there is some object in Willie Brown's hand and whether it could be a weapon. They have that right.
But there's been no, why would it be relevant if there's no claims of self-defense?
Because Mr. Hammond doesn't have to make a self-defense claim. He's not charged with shooting out of the passenger seat. This is what it is. He is the driver here.
Right.
He speeds away. He goes up to the car. He doesn't discharge a gun. The state certainly is operating under a principles theory here, which the jury also has to determine and make a finding.
I understand that. Let's not get on that part.
So my point, Judge, is that I don't believe anything in the law requires me to make a self-defense argument. I think that is misplaced. I think the jury, in a piece of evidence...
If you're arguing that he had a gun in his hand, he being the person that was in the car when they were shooting it up, why would you bring up the fact that he had a gun in his hand if you didn't want the jury to think that your clients were acting in self-defense?
I believe, well, it's not my client. My client wasn't acting in self-defense. My client happened to be the driver of the car.
How about as a principal?
So the purpose here is to allow the jury to have the full view of what the evidence is. And the evidence that has been accepted, the evidence that has been admitted, okay, part and parcel is that picture, that still picture.
If you want to make that argument, go ahead. Go right ahead. You can argue that that is a gun if you want.
That is defense exhibit number 1.
Has it been admitted?
It has.
Okay, yeah. Anything else along those lines, or before we move on to any other new lines? No? All right. Bring in the jury.
Well, I thought the jury was going to be in right away, taking them a while. So the photo was brought in by, in day 4, a recall witness, Mr. Barretto, Officer Barretto. He located Willie Brown the night of. There was body cam on him, and then they showed a still photo of that, and Willie Brown had a watch on. And I'm like, why on earth are... All right, we'll talk more at the break.
Yeah. Jury's back on, may be seated. Welcome back, ladies and gentlemen. Once again, no issues with the court instructions, I take it. Very good. Is this when you may begin? Or excuse me, you pick up where you left off.
Thank you, Your Honor. Welcome back. I hope you enjoyed your lunch. Very, very briefly, I want to go over this process itself. When you all came for jury selection, we didn't talk a lot about the facts, if at all, of the case. Just told you what the charges were. We didn't go into specifics. We didn't dig into anything, or at least tell you what you were going to see. When you came and you were selected and listened to opening statements on the case, you got essentially a preview or an overview of what we expected the evidence would show to you. But at that point, you come and you see it, and you're not familiar with the facts. You haven't lived with the case up to that point. So then we put on evidence, which is bring in witnesses that legally we are required to bring in to testify, because testimony is considered evidence, or to introduce physical items of evidence, etc. And during that process, it can feel probably overwhelming in that we are just putting exhibits into evidence and maybe they don't come together to make sense. These closing arguments are our opportunity to tell everyone what the state's case and what we've established by introducing all of that evidence to you is. It's our first opportunity to put up the actual evidence, although it's come in droves through different witnesses and, different crime scene techs or different detectives and things like that. And it may not make sense because it doesn't always come in the chronological order in which it happened or in which it was collected. So this is the first time we're putting everything together for you. That means it's the first time we're actually presenting the videos to you to establish that vehicle 1 is 1 second behind the victim's vehicle before those gunshots ring out. It's the first time that we're showing you the videos back to back, which establish before vehicles 2 or 3 even get there. Vehicle 1 with Zavante Sampson and Quandarius Hammond has already opened fire on the victims. It's the first time for us to put that to you. It is a lot of evidence and can be overwhelming to see and experience all of that. But as we go through these jury instructions, it's important for each of you to note, Florida law allows for a self-defense instruction if appropriate. That means, by law, if there's a scintilla of evidence to support such, that would be provided to you in the packet of jury instructions that we're going to read here in a bit, that are very, very long, and it's a lot of legalese, but it's essentially your definitions, what we were going over before we took a break. You will not receive a self-defense instruction in this case for your consideration. Self-defense is not an issue that has been presented to you, and self-defense is not supported by the evidence of this case. There is a lot of evidence that has been provided to you, but self-defense has not become an issue because there is no evidence to support you all receiving that instruction. What there is evidence of is these defendants hunting down the victims and opening fire onto their vehicle. It is on video. It happens seconds apart. It happens over and over again. First with vehicle number 1, and again with vehicles number 2 and 3 after they realize that vehicle isn't stopped for good in front of Lorenzo's garage. That vehicle starts to move again. And it's at that exact moment that, absolutely captured on video, is vehicle number 3 firing into the vehicle now occupied only by Mary Harrison and Suni Bell before it crashes into that pole. There is no evidence that anything else other than that occurred. And we are in a position where we are able to provide to you video surveillance evidence. That's not always the case. So you all will have that video evidence. You all will have the events which have occurred, and you all will be able to see for yourselves through the evidence when you go back. Second by second is accounted for the victims and for the defendants. In fact, you have videos that overlap with each other to ensure you have captured what happens between the defendants and the victims. And the facts are the facts. The victims do not know these people. And the defendants made a choice to excitedly jump into their vehicles armed and gun them down. So the court will give you jury instructions here after the close of all of the closing statements. So where we left off was talking about the principal instruction, because there is no requirement that we establish who's shot a gun and struck Suni Bell, killing her. But this principles to a crime instruction is the instruction that you bring with you. It's the one thing that you take when you look at every single count that you have to consider in this case against the defendants. So when you look at first-degree murder, you say, is the defendant guilty with the elements that I see? Now, considering the principal instruction, is the defendant guilty as a principal for having intended to do the criminal act, shooting into a vehicle? Understanding the potential outcome of shooting into a vehicle, which is the death or expected death of the persons therein. So principle is an instruction that you carry with you. The reason that that's different, did they do or say something to encourage the others? You have the videos as to each defendant, waving each other on, gearing up, using the same bag of guns, jumping into the same vehicles, targeting the same victim. Did they do something to encourage or assist or advise, whether they pulled the trigger directly or drove the persons pulling the trigger? That differs from conspiracy, which we'll see here just in a few minutes. But let's go in order of the counts that you have to consider beyond what we've looked at, which was first-degree premeditated murder on Suni Bell. All of the defendants are charged as principals in the attempted murder of Mary Harrison. She's the passenger of the victim's vehicle. She's the victim's mother at the time that the defendants start following their car. Once Mr. Brown is able to escape the vehicle in front of Lorenzo's garage, she jumps over into the driver's seat. So on the Lorenzo's garage video, you see this pause. And if you're asking what's happening, the vehicle you'll see just at the edge of the video starts to move again. Well, when we pick that vehicle up on the subsequent videos, just across the street from that, it kind of takes off and jumps on the curb and runs into a pole. The attempted premeditated murder of Mrs. Harrison means that did the defendants again intend to or plan to shoot into this vehicle? Were they acting in an organized manner? Did they accomplish the goal that they sought out to do? Why Zavante Sampson and Quandarius Hammond are also charged with the attempted murder of Miss Harrison, even though they are driving off by the time that she subsequently drives away, is twofold. Number one, when they first begin shooting into that vehicle, it's occupied. Mr. Brown is driving and she's in the passenger seat with Suni in the back. At that point, with that first round of shots, there's an attempted murder of Miss Harrison. But also consider, when you're looking at these facts in the principal instruction, without the actions of Quandarius Hammond repeatedly shooting out of the passenger seat to stop the vehicle in front of Lorenzo's garage before Willie gets out, the others aren't caught up. The reason they're stopped there before she has to jump into the driver's seat, before the second rounds of shots keep going again, because now the vehicle's moving again, they're not dead inside. They have disabled it in this location. Vehicles 2 and 3 are then able to catch up to vehicle 1. There is an audible gap when you listen to the audio. First round of shots with vehicle 1 right by the victim's car. Gap. Second rounds of shots. Shots that are fired when Willie's already running down near Coverly's residence. They start the ball rolling. They are the first domino, essentially, to fall, which puts our victims in a vulnerable position of being stopped in a car, Miss Harrison having to jump into the driver's seat and attempt to drive again. But unfortunately, as soon as that vehicle starts moving, as soon as there's a realization that it's going again, it's not stopped, it's not over, the second rounds of shots start up again. You saw the crime scene photos of their vehicle. There are dozens of shots more into the victim's vehicle. I won't ask you to be an expert as you look at those photos, but I will ask you to look at the impacts from the ballistics evidence in that car. There's no evidence of casings in that car or that there was any kind of violence or anything from anyone inside that vehicle. There's no evidence other than that these 5 people came together to attempt to kill the passenger, the driver, and did actually kill the child in the back seat. The third count that you have to consider is going to be the premeditated murder of Willie Brown. You may ask yourself, why in this instance are we looking only at Quandarius Hammond and Zavante Sampson for purposes of this charge? Why isn't this also a principal? The attempted murder of Willie Brown occurs, as we can see from the video footage, before the other 2 vehicles arrive. So while maybe they intended to catch up and also engage with Mr. Brown, he has escaped the vehicle before vehicles 2 and 3 arrive. The only persons that we would charge or could charge with his attempted murder are the individuals who directly can be linked to that shooting. Once he runs from the vehicle, there's no way for us to say beyond a reasonable doubt that the other shots were directed at Mr. Brown only. We present to you cases, we present to you facts which can support the state's position of what the defendants are guilty of. They took fire or fired down on that vehicle alone, vehicle number 1. They started out by themselves. So the attempted murder for Willie Brown, as it relates to that vehicle before the other vehicles caught up, are only as to these 2 defendants. When you look at the verdict form, you'll just see options for these 2 defendants on this count, because by the time Willie is running away, the other 2 vehicles are catching up to Mary and Suni Bell. That's why the occupants in everyone's vehicle are responsible for what happens after Miss Harrison takes off. Looking back to count 4, again in conspiracy, everyone's charged. So when we talk principle, that's the overarching instruction that you get to take with you and you look at all of the others. Look at the elements and say, does this apply as we're reading it, and then does this apply when we add principle? Conspiracy to commit murder is its own charge. The language within the conspiracy count is different. So you'll look at, did they confederate, did they combine, did they work together essentially in committing these acts? Now the conspiracy itself is not the physical act of what you're doing, right? It is the portion of talking about, acting in a manner consistent with, it is conspiring to commit that crime. So when you're looking at this count of count 4, conspiracy to commit murder, you actually are looking at, did they conspire to commit the driver of that vehicle? Did they conspire to commit murder of everyone inside the car? Was it just as to Mr. Brown? Was it just as to Miss Harrison? Was it to everyone? So you'll have an and/or option when you look at that, right? You ask yourself, they don't know each other. So is there a conspiracy to commit murder against whomever the person is that's driving the vehicle? But for this, you are able to consider each of the victims. Was there a conspiracy to commit murder, on an occupant of that vehicle? When we talk about conspiracy, the court's going to give you the same instructions that you'll see here. So the language is a little bit different for conspiracy because it's an actual count. Did they conspire or agree or combine amongst themselves or other diverse persons? That's what we were talking about just a little while ago when I'm asking that you consider the evidence against the defendants here before you. It's not necessary that we present every other person from the gas station, for example. But it could be amongst themselves. It could be that 2 of them have more knowledge about what's going to happen, but that a 3rd has agreed. It could be any combination of the defendants. But did, overall, Some or all of the defendants agree to what would occur. That's why when you're saying let's look individually at each of the defendants, you say, was this an agreement between the two? Was this an act that was committed by a combined group of individuals? When you're looking at each of the defendants, you have to say, did they play a role in this conspiracy? And I assert to you that they each played a role, particularly when you look at the video directed specifically as it relates to each defendant. Looking at shooting at, within, or into a vehicle, this is a count for which we're asking you to bring the principal instruction along with you. We're not asserting to you specifically that all of the defendants discharged firearms from their vehicle, but whether they acted together to accomplish the shooting at, within, or into a vehicle as a group. These are the instructions that you'll be provided, again, as it relates to each of the defendants in determining whether they acted at, shooting at, or within, or into a vehicle, or whether they acted as a principal to the same charge. The court, again, will read all of these to you, so I don't want to spend too much time going through or reading them to you, but essentially we're asking that you apply the principle specifically as it relates to the shooting at, or within, or into a vehicle charge as well. And lastly, count 6. This charge is unique in that it only is applicable to those who did discharge a firearm. So we're not asking you to bring in or take with you the principal instruction as it relates to Mr. Hammond, Mr. Thompson, and Mr. Denson, the 3 that have that firearms discharge language on their verdict form. Because each of them have some piece of evidence supporting the fact that they did actually discharge a firearm from those moving vehicles as they attempted to gun down the victims in this case. Very briefly, I will go through these lesser included offenses. You will receive in your packet what is essentially the primary charge. So take first degree murder, for example. You will receive instructions on what are called lesser included offenses. So when the court's instructing you on these are the instructions, these are the definitions for the charges that you will receive, you'll be sent back and start your deliberations. You could be in this stronghold with someone else who absolutely agrees that we have met all of the elements as it relates to second degree murder in lieu of premeditated first degree murder. So say you're split in that. The court's instruction to you will be that you must return a verdict for the highest count that you all agree on. So if you all agree as it relates to second degree murder, even if several of you indicate that you believe it is in fact first degree murder, there was a sufficient time for that premeditation, then it has to be a returned verdict for the highest count that you all agreed to. It has to be a unanimous verdict as to the count that you believe was satisfied. Specifically about second degree murder, you will be instructed that the victim has died. You will be instructed that that death was caused by the criminal act of a defendant or these defendants acting together, and that there was an unlawful killing of the victim by an act that was imminently dangerous to another person. So was there an imminently dangerous act? There is an instruction for imminently dangerous as well. I have provided it very, very concisely here, but you will also be provided this instruction from the court. When you actually read through this instruction, the part that can get confusing is prong 2. Is this done from ill will, hatred, spite, or an evil intent? The act of shooting a gun at another person is inherently done with ill will, spite, or an evil intent. That is what I will assert to you about this second degree murder definition and instruction included in imminently dangerous to another person. You also, as to the lesser included offenses, will have manslaughter and attempted manslaughter. What happens with these lesser included offenses is, so you say first degree murder, second degree murder, has that been met, or alternatively manslaughter, has that been met. And for manslaughter, that is a lesser included offense as it relates to first and second degree murder. And the only elements therein are that the state has established that the victim is deceased, and that the defendants intentionally committed an act that caused that. It is somewhat different in the attempted manslaughter by act because the person is not deceased. So did the defendants intentionally commit an overt act that would have resulted in the death of the person that they committed the act upon, but they were not successful? This is Suni Bell. This victim was hunted down by the defendants because they wanted to accomplish one goal, and that goal was to kill the occupants of the silver Infiniti they saw driving behind the jet. It was driving too slow. It was parked for 1 minute too long in the field. Whatever their motivation, they targeted this vehicle, this child, this family.
Objection from argument.
Overruled.
The defendants in the video treat the jet, the Chevron gas station, like some kind of a bunker in a war zone. They hunker down, they take cover, they get armed, they put masks on. And the only enemy that they encountered was Suni Bell and her family. There's no excuse for what happened. The defendants acted together with a joint goal, and they've accomplished that goal. At least one person inside of that vehicle was killed, and the other two victims of that attempted murder will never be the same. The evidence supports a finding of guilty as charged as it relates to all of the defendants seated before you. Because you don't need to be the sole person to pull a trigger for this death to be on your hands. Thank you.
Defense?
May it please the court, counsel, ladies and gentlemen.
Do you think you can?
Good afternoon, ladies and gentlemen. I'd like to take a moment to thank you all on behalf of Zavante Sampson for your patience and your attentiveness over the course of this several-day trial. I'd also like to apologize on his behalf as well to you. This, to put it mildly, has been a very emotional process for everyone, and it has taken its toll on Mr. Sampson as well. You know, all of us have our commitments, and all of us have our jobs and our families and our personal obligations, our work. And as we sit here for these days listening to this testimony, the evidence, the admitted documents, the videos, I think that we all understand how important this whole process is. It goes without saying that I strongly disagree with the state's assertion and their view of what's seen in these videos, which are critical pieces of evidence for you to digest. After however many times they're reviewed and what they're alleged to show. It's pure speculation. I urge you to look very closely at all of these videos. They all bring something to the table, but I would suggest that you focus certainly on the Chevron videos, the East Tampa gun and pawn video, which shows the parking lot of the Chevron, the Lorenzo's garage video, specifically as it shows the interaction with Zavante Sampson's car and Willie Brown's vehicle. Because I believe that the evidence has shown you that it contains a great deal of pure speculation. I'd ask you to pay attention to it in its entirety, and certainly you have the option, as I suspect you will, to view this video in slow motion, to view it regarding Mr. Sampson and Mr. Sampson's actions, which I think are important. But when you start talking about what someone thought, what someone said, what someone did, look at it in real time too. Because as the state has indicated to you, and I don't have the numbers, and presumably someone has written it down, this happened in a very, very short period of chaotic time. You can and you should have sympathy. So sympathy is an emotion. Sympathy is sometimes something that you can't just work around. But verdicts in this case must be based on the law, not based on any sympathy for victims under the law, Suni Bell, Willie Brown, Mary Harrison, or based on any anger that you may have toward any one of these defendants, in particular in my circumstance, Zavante Sampson, over the horrible outcome that happened here, or even his outburst in such an emotional state this morning. I told you that much of the week during our jury selection that you would hear the state and many of its witnesses say they did this, they said that, they did this. I asked you and you promised me to separate these defendants and the evidence set forth as it relates to each of them. This would include a determination as to whether or not they are principals, and whether any of them, in particular Mr. Sampson, conspired so that a particular crime would be committed. The judge is going to instruct you on conspiracy, and Ms. Ismer talked to you a bit about that, and I just want to make sure we're all understanding criminal conspiracy. Because in order to find someone to be in a conspiratorial capacity, there has to be two elements. Remember how we talked about elements in jury selection. We talked about some crimes and some theories have two, some have three, some have four. Whatever the case may be, the elements is that the intent of Zavante Sampson was that the offense of murder in the first degree be committed. In order to do that, Mr. Sampson had to agree, conspire, combined and with a confederation among themselves to cause the murder in first degree to be committed. Understand that it's not necessary that this be expressed in a particular word or particular set of words. And those words don't have to pass between conspirators. Be mindful And we're going to talk about principles a little bit later because it's another very, very important theory that we've been discussing throughout. Be mindful of what each lawyer has elicited during the course of this trial from the witnesses, not just myself, and as well in their arguments. Be mindful of the evidence that applies to each of them individually, and whether it shows guilt beyond to the exclusion of a reasonable doubt. Be mindful of the proof, the type of proof, what is the quality of the evidence provided to you by the state for your review. Your deliberation is multifaceted. We talked about that in jury selection. It has to be segmented and it has to be specific as to Zavante Sampson and what he did and how the facts apply to him. The judge is going to instruct you that when you have multiple counts in an indictment and multiple defendants, a separate crime is charged for each defendant in each count of that indictment. And the evidence applicable to him must be considered separately. A finding of guilt or not guilty as to one or some of the defendants must not affect your verdict as to other defendants or other crimes charged. Let's talk for a minute about direct and circumstantial evidence. Direct evidence is evidence that tends to prove a fact directly that is in question in a case without the necessity of reliance on the inference of proof from other facts. Circumstantial evidence, on the other hand, is evidence that first, in and of itself, has to be relevant, and second of all, it has to be of a quality that leads to an inference that an event occurred or didn't occur. The quality of the evidence is important in circumstantial evidence as well. And that circumstantial evidence, in and of itself, needs to be proved beyond a reasonable doubt. Things that lead you to other things are dangerous, and they need to be looked at very, very closely. The state is asking you to rely on circumstantial evidence in a number of ways. Certainly, as we look at the underpinning of this case, and we will talk about it a little bit later, there is the principles theory. And I'm not suggesting that you throw it in the garbage can. I'm suggesting that you look at it very closely as to its application as it relates to each and every one of these crimes. Leap number one, they're asking you to make a determination that Zavante Sampson intended that a killing take place. That Zavante Sampson conspired and had an agreement with other people to do so without any evidence as to what was said at the Chevron during the time that he was hanging out there for those hours, while he was in the parking lot, or while he was in a vehicle with Quandarius Hammond. Leap number two is that the state is again asking you to infer that Zavante Sampson intended the killing of Suni Bell or the attempted killing of Willie Brown and Mary Harrison to occur. And that he did so by intentionally doing some act that incited, caused, encouraged, assisted, or advised someone else to commit the crimes he's charged with. Having said that, I want to talk to you a little bit about the evidence that we heard during the course of the past several days. we weren't there, ladies and gentlemen. We must search for cooperation in order to render a fair and impartial verdict. We heard from Willie Brown. Willie Brown told you that he didn't intend to go to the memorial service at DeSoto Park that day, and he got there late. He talked about the fact that when he got there, he parked in his car a little bit away from what was going on, and he saw Mary Harrison. Mary Harrison is someone that he was going through with it at the time, along with some other family members that appeared to be having some issues. After smoking some marijuana, they set off down East Hillsborough Avenue. Something just doesn't seem right as it relates to his testimony, ladies and gentlemen. He alleged that he didn't know anything about going to the gravesite for a balloon release. Mary Harrison told you that that was the intent. He never had any substantiated conversations with his cousin, Charles Dozier, Squeak, or Corey Brown about this salon after party. But when prompted, what he did tell us is that he buys marijuana from Corey Brown. There's no evidence of any other family members going to Corey Brown's salon or shop. And I'd ask you to consider Willie Brown's real connection to this trip and what he was trying to accomplish. What Willie Brown does say, which is very important as you consider the evidence in this case, is he said that Suni Bell was screaming when he got out of the car after the first set of gunshots are discharged. He told you that the shooting stopped momentarily and that the car continued to drive forward as he got out. It's also important to note that there was only one set of shots prior to him running away, and it was those initial shots that got him out of the car. At this juncture, I ask you to look at Willie Brown a little closer. I'd ask you to look at the object that appears to be in Willie Brown's hand in Defense Exhibit number 1, inside that circle and with the arrow. Take it back, look at it closely, consider it in your deliberations as to what Willie Brown may be doing. He told you that he didn't carry a gun. He told you that he didn't discharge a gun. But to corroborate this object, I urge you to take notes and go look at the 45th Street Coverly video, which is State's Exhibit number 13, and watch it at 21:05:46, and you'll see this same object in Willie Brown's hands as he is crossing the street, crossing the driveway into the roadway. Please look at it. Detective Saleha testified that he didn't see a muzzle flash from Willie Brown's car, but that would have been very difficult to do based on where the camera in Lorenzo's garage was positioned, because it was on the other side of the driver's compartment of that vehicle. It was on the passenger side. Review the Lorenzo's garage video as many times as you feel it necessary. Willie Brown told you that he ran down 45th Street and he continued to hear gunshots and believed that someone was chasing him and shooting. He ultimately located Michael Coberly to contact 911. Ladies and gentlemen, recall that Zavante Sampson was arrested on September 30th, 2021, and Detective Saleha testified that he took Mr. Sampson's statement. After being apprised of his arrest for premeditated first-degree murder and conspiracy to commit first-degree murder, he told you that Zavante Sampson, after originally requesting a lawyer, decided to speak with him. There's no question that Zavante Sampson lied about making the turn on Hillsborough Avenue, the U-turn, following Mr. Brown, Willie Brown's car, and being present when the shooting took place. It's important that he lied, and it's not lost on me in any respect. When considering someone fearing for a wrongful implication, not wanting to put themselves in a place that would have been dangerous for them to be, because Zavante Sampson was not truthful in that respect, doesn't make him guilty of first-degree premeditated murder, doesn't make him guilty of attempted premeditated first-degree murder, and doesn't make him guilty of conspiracy to commit first-degree murder. It might make him the kind of person that you yourself don't want to be. And although it's not a justification, it certainly can be an explanation. Going back to the testimony of witnesses, you also heard from Mary Harrison last week. Her emotional state was certainly understandable and apparent. She told you that she recalled the events of August 22nd, 2021, and was supposed to be going to the gravesite for a balloon release. She never got there. She testified that Willie Brown took her to a field that you saw in States 41, which is adjacent to the Chevron and down Giddens in this area right here. During that time, he turned his engine off, he told you, and his lights, and allegedly made unsuccessful phone calls to Squeak, who was Charles Dozier. And again, I'd point out that the evidence didn't provide you anything to substantiate any party at Corey Brown's salon ever existed. She testified similar to Willie Brown in one important way. Recall that Mary Harrison told you, and she clearly, in no uncertain terms, stated that after the first set of shots, when Willie Brown got out of the car, the shot stopped and it gave her a chance to get away. She told you that in moving from the passenger seat to the driver's seat and starting to drive, she heard Sonny saying, "Mommy, Mommy." She was standing in the back seat. She told you that it was only before she hit that pole that at one point in time she didn't hear Sonny anymore. Why that's critically important to you is that the evidence does not indicate that Suni Bell was killed by those first set of shots. This is apparent for a number of reasons, including what both Willie Brown and Mary Harrison testified to, about Sonny being alive at that time. I'd like you to take the time to look at State's Exhibit 2A1 and 22A3. First, 2A1. This exhibit would indicate to you a certain set of gunshots or projectile strikes that Willie Brown's vehicle absorbed. A3 would give you another look at others. Look at their formations. Decide amongst yourself as you review them what position Willie Brown's car was in when he took these shots, when he took these projectile strikes. In looking at State's 2A 26 to 31, they give you some perspective about the strikes that the back seat and the window were impacted by. You'll have all these pictures when you go back to the room to deliberate. And I'd ask you to consider them when you decide what happened and how Suni Bell was killed. I'd also draw your attention to State's Exhibit 2A4, which is the other side of the car. And look at the consistency in the exit of that projectile out of the window on the passenger's back seat side, as well as the exit out of the lower door panel of that vehicle. The evidence will show you, as you look at State's Exhibit 16, which is the Lorenzo's garage video, that Zavante Sampson's car was ahead of Willie Brown's car when Quandarius Hammonds fired those shots. Review that video to determine the distance between those two vehicles at such time as you see the muzzle flashes and you see the cars in relationship to each other. And you look at the bullet entry strikes in the back seat, the back car door, the window, and then on the driver's side. Some of those strikes appear to be directly into the back portion of that car. Others appear to be at an angle similar to the distance between vehicle number 1 and Willie Brown's vehicle. Further evidence to corroborate that Suni Bell was not killed by the first set of shots would be the location of the 9mm casings located within the first 300 feet of North 45th Street, which is where the gunfire began. This evidence was provided by analyst Kwong, if you remember, and the diagram he provided you indicated that there was 879 feet between 45th Street and where Mr. Brown's vehicle came to rest beyond 43rd. And the concentration of the projectiles attributed to the passenger side window of Mr. Sampson's car are there for your review, 1 through 12. And it's not 1 through 12, it's 1, 4, 5, 6, 7, 8, 9, 12, 52, which is 9 discharges. While discussing analyst Kwong's testimony, recall that he indicated that there were at least 5 different firearms discharged along the stretch of roadway on 45th Street. From 45th Street past 43rd Street where Mr. Brown's vehicle came to rest after hitting that pole. And recall that Zavante Sampson did not carry and did not discharge a firearm. The number of weapons even exceeds the occupants of vehicles 1 and 3. Analyst Kwong also told you 2 other pieces of information, very important. First, he identified casings found on the back end of that particular roadway. To a 9mm Taurus handgun that was associated with James Denson. Secondly, he testified that there was a second set of casings identified to another Taurus 9mm handgun that was seized as a result of a separate and distinct investigation. We'll talk about that a little more later. We also heard from Michael Coberly, who came in contact with Willie Brown outside of his residence on 45th. He indicated to you that he heard gunshots, which is what drew his attention outside that night. Additionally, he provided law enforcement with his video, which you have in evidence, and I would request that you review, that captures the sound of distant gunshots that we know were still taking place on Hillsborough Avenue. And it also showed Willie Brown running through the neighborhood at different places and at different times. I ask you to review that video again as you see for a second time the object in Willie Brown's hand. What Mr. Coberly also tells you is that there's a large warehouse business that fronts Hillsborough Avenue, States 41. Shows that to you here in this area here. He talks about all of the overbrush, all of the overgrowth, all of the trees that exist going down 45th Street. And as you look at that video, you can see it as well, even though it's at night. But that's what he told you, and it's important for your consideration in that Officer Barretto testified last week, and he indicated that he responded to the scene at 45th, and part of his responsibility was to search. And what he did search was simply one small area, the backyard of the neighbor of Mr. Coberly, which was Mr. Church, and he never searched any of the areas associated with Mr. Brown's travel, whether it be before, during, or at the end of his trek down 45th Street. No search of any other property, no search of any other yards, no search of the warehouse, no search of the roof, no search of the backside and the fence line where the warehouse was, And that was especially curious when Officer Barretto indicated that part of the investigation was a determination of anything that they might find associated with Willie Brown. He said that. He testified to that. But he said it, they just didn't do it. Because there was no firearm found does not mean there's no firearm. Detective Saleha also testified last week, and you'll recall that Detective Saleha was the lead detective who conducted the majority of the interviews in this case. He collected a lot of videos, he analyzed them, and he was, as they're called, the lead. Detective Saleha at one point identified individuals to the best of his ability at the Chevron parking lot by way of the East Tampa gun and pawn video, which I believe is in evidence for you in a couple of different ways. Focus on individuals, in slow motion, and in real time. This is a real case, and real time is important. What Detective Saleha cannot do for you, and what I would suggest that the evidence shows that this video absolutely cannot do for you, is tell you what Savante Sampson was saying and what Savante Sampson was doing, and as importantly, what direction he was standing and where he can be seen at certain times. It's not good enough. You can't see it. You can't make determinations and leap to circumstantial evidence inferences by looking at that video. You saw it, but you're going to have an opportunity to review it. But there's danger in doing that, and we're going to get to that. He testified regarding the cars leaving the parking lot, and he told you for the first time there were 3 vehicles involved. First time you heard that. And what he told you was that he believed that the second vehicle was being occupied by Maxwell Bedward, Kimwani Bedward, Devin Sampson, and he believed Cedric Brown. Where was the investigation into these individuals? Where was the investigation into that vehicle? I know he said, well, we can't make the case, so we're going to move on. He told you that individual vehicle number 2 discharged rounds at Willie Brown's car. And note there are a number of casing groupings, if you recall from Analyst Kwong's exhibit, that would certainly be attributable to vehicle 2 and what damage was done and what injuries they might have caused. What Detective Saleha was able to determine is that in addition to the Taurus 9 that we talked about earlier, there was a second Taurus 9 that had fingerprints of a Raheem Bryant on it. When Detective Saleha talked to you about Raheem Bryant, and he was asked to make some attempt to identify Raheem Bryant, he told you, yeah, I looked at the video, I didn't see Raheem Bryant. And his description of Raheem Bryant, as he had his files with him, was that he was a black male. That's not an identification. There's no download of Raheem Bryant's phone. To see if there's any relevant evidence, which there oftentimes is on telephones in 2025. He actually just ignored Raheem Bryant as a suspect to begin with. The forgotten vehicle 2 in this case. the vehicle that rounds were discharged from, per Detective Slaya's testimony, the vehicle where he indicates there was muzzle flash from, the vehicle that left grouping of casings strewn on Hillsborough Avenue during the course of Willie Brown's travel. And how do we know this? Because based on the occupants in cars and the occupants in groupings of casings, the numbers don't work. Detective Salaya then went on through video footage with you during his testimony. During the course of your deliberations, again, please look at Exhibit 16, which is Lorenzo's garage. He tells you that the evidence indicates that a gun was discharged and there were muzzle flashes from the passenger side of Zavante Sampson's car between 21:04:37 and 21:04:38. That's 2 seconds, ladies and gentlemen. 2 seconds. Seconds later, within 10 seconds, Zavante Sampson's car takes a left on 43rd Street. And that happens even before any other vehicle is in camera view, and certainly before the second series of shots takes place. It also indicates to you in another way that the rounds discharged from Quandarius Hammond's from Zavante Sampson's vehicle did not kill Suni Bell. And we'll talk about principles a little later. I would also point out for you another part of Detective Saleha's testimony was communications, or what we call CDRs, cell detail or calls detail records. He testified that there was communication between Zavante Sampson on the day of August 22nd, after the shooting, in relation to him attempting to contact his brother, Devin Sampson, and in the days after the shooting as it relates to some of the other co-defendants, namely Jalen Bedward. After the instantaneous abbreviated minutes within which this chaos occurred, I think the evidence would indicate why wouldn't it make sense that these people were communicating what occurred. There's no record of text messages. There's no record of voicemails. There's no way for you to determine in any way, shape, or form the content of those communications. And that's why you shouldn't be coaxed down the circumstantial road in this particular regard as it relates to that inference, amongst other inferences that you are asked to string together to formulate circumstantial evidence as a means to convict Zavante Sampson. As you deliberate, don't get me wrong with regard to these videos. I'm not pointing out these videos in and of themselves for you to focus solely and completely on them, because each one of the videos plays a certain part in this horrible circumstance, but they may not all have to do with Zavante Sampson. But we'll talk about principles later. When you focus on Zavante Sampson in these videos, I think the evidence indicates that he's not acting in any way, shape, or form as a principal to anybody else's thoughts and actions, and he's certainly not operating in any conspiratorial capacity. As Ms. Ismer showed you, and you will have those instructions to rely upon, because you take the facts in a case like this, and you apply them to the law. And in this particular case, the law is the instructions that are provided to you by Judge Fuson. ask yourself as you look at these videos, what in that video at East Tampa Gun and Pawn and the parking lot, which is the impetus for all of this, tells you without attaching reasonable doubt that Zavante Sampson got in that car with the intent to kill someone? What in that video tells you that he told someone to follow him, or he knew that anyone had a gun? You can take a segment and you can look at a particular person in this video and you can say, okay, yeah, there, he has a gun. But what you have to do in order to bring that to where you have to get to, you have to look at Zavante Sampson. That's why the instructions, and that's why the law says that when you have multiple defendants and you have multiple counts, you cannot just operate in a vacuum. What in that video shows you that he did some act or said something that was intended to, and that did incite, cause, encourage, or assist, or advise anyone to commit a murder? I would suggest to you that that video doesn't give you that answer. And I think that's the answer you would get if you look at this with clarity, if you looked at that video 100 times. What in that video proves to you without reasonable doubt that Zavante Sampson intended the killing of Suni Bell or the attempted murder of Willie Brown or Mary Harrison? The one thing I ask you to lose sight of, and I've stayed on this video thing for a long time because it's prevalent evidence in this case, and I would hope that it dominates your deliberations, quite frankly. Because I don't want you to lose sight when you review these videos in real time and in slow motion, frame by frame, if you choose to do so. Looking at these videos in anything but real time absolutely distorts what Zavante Sampson may have been aware of and what in these circumstances is extremely unreliable. You know, you get the benefit of watching these videos, especially Chevron and East Tampa Gun and Pawn. I say peacefully. I mean that just as an art, in your deliberation room, quietly if you choose, by yourself, with others, as a group, in slow motion, maybe, frame by frame, if you choose. Things can be pointed out at certain points in time when you look at something in a vacuum or in a silhouette. And ladies and gentlemen, that's not how Zavante Sampson was able to view it, to react to it, to handle it, to be exposed to it. Those videos are not what happens in real time, in the span of 2 minutes. When you look at it in real time and you see what's occurring, make a determination as to what Zavante Sampson is capable of being a part of during that time frame. That's what I challenge you to do, and that's what you should do based on the law in order to find somebody guilty of any of these charges, inclusive and especially with regard to the use of principles, which we're going to talk about. Finally, ladies and gentlemen, on Friday, you heard from Dr. Milhan Webb, the Associate Medical Examiner of Hillsborough County. He testified to Suni Bell's wounds, the wound that entered the chest and exited the back, the wound that was fatal because it damaged multiple vital organs. Dr. Webb did tell us, as Detective Saleha told us, that he could not tell what type of projectile killed Suni Bell, in that there were, as you know, 2 calibers of weapons in this particular case, 5.56 rifle rounds and 9mm rounds. Detective Saleha, just joining this thought together, was candid when he indicated to you that he could not tell you what projectile, from what gun, from what car, from what person killed Suni Bell. And we'll talk about principles a little later. Dr. Webb also testified that the injury would be immediately fatal and that Suni Bell had no function after the injury, based on his autopsy and based on the review of the emergency personnel records. Again, based on Willie Brown and Mary Harrison's testimony, based on Mary's interaction with Suni during the course of their both shots, and when she was attempting to get away, tells you that the projectile from Savante Sampson's vehicle did not kill Suni Bell. The physical evidence supports that as well. I understand, as we've probably been leading up to, that the state would suggest that this argument should fall on deaf ears simply because if Savante Sampson was a principal, it doesn't matter. Well, I believe that the evidence shows you that he was not a principal, and it does matter. Ladies and gentlemen, those are the facts that I believe the evidence showed during the course of trial over the last several days. Although I believe that the evidence has shown you that Savante Sampson is not guilty, in considering the totality of the evidence, you should consider the possibility that, as Ms. Isber said, although the evidence may not convince you that he committed the crimes for which he is charged in the indictment and the counts that he is in charge, that he has been charged with in that indictment, which is in this case first-degree premeditated murder, which you will have an instruction on, and you'll be able to review, as you will the rest of the charges and the elements that are required for the state to meet in order for you to find someone guilty, in particular Mr. Sampson, of that particular crime, and every other crime that's alleged, and every other element that goes with it. You can consider other acts that are called lesser included crimes. The law dictates that if you find that the main accusation has not been met, you'll need to decide, and that's beyond to the exclusion of a reasonable doubt, you'll have to decide if he's guilty of a lesser crime. And without going into those instructions of those individual cases, or individual lesser included crimes, what you do need to know is that the lesser included crime to first degree premeditated murder is second degree murder and manslaughter. And the lesser included crimes in the definition of attempted first degree premeditated murder are attempted second degree murder and manslaughter. You'll have those instructions for your review. As I come to the conclusion of my argument, remember that if you believe Mr. Sampson might be guilty, it's not enough. If you believe he's possibly guilty, That's not enough. If you're pretty sure or almost positive that he's guilty, then the state hasn't met its burden. This case is premised on the theory of principles. We've talked about it in jury selection. Ms. Isber's talked about it. I've talked about it to you again because that's how critical it is. And although I believe that you will do everything required of you during the course of your deliberations, I would ask you to pay particular close attention to the principal's instruction. And we are going to talk about this one at length. If Savante Sampson helped another person or persons commit or attempt to commit a crime, Savante Sampson is a principal and must be treated if he had done all of the things the other person or persons did if the state proves beyond a reasonable doubt the defendant intended the crime to occur. And there's not an or there for a reason. And the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. Again, dovetail that into the East Gun and Pawn video and look at it in real time and ask yourself whether you can apply that definition to anything that Savante Sampson did in that span of time. For first-degree premeditated murder and attempted first-degree premeditated murder, remember, because it's very important, that the state must prove that the defendant intended that the killing of Suni Bell or the attempted killing of Willie Brown and Mary Harrison to occur. He intended a killing to occur. It talks about what would happen as regards to the lessers. Read that because that's important as well. And as it relates to shooting into a vehicle. In conclusion, with regard to the instruction, it's not necessary for a principal to know every detail of how a murder or an attempted murder or shooting into a vehicle would be committed, as long as the principal, Savante Sampson, intended the murder or attempted murder or shooting at or into a vehicle to occur and did some act, said something that was intended to help or did help the murder or attempted murder or shooting into a vehicle to occur. To be found guilty of those crimes, it's not necessary for the state to prove that he knew another participant of the murder or attempted murder would be armed. Remember that you are 12 individual people and not merely a group of 12. You'll go back into that jury room to deliberate as 12 individuals together. You've over certainly a lengthy trial period like this, had the opportunity to spend a great deal of time with each other. You ate together, at least some of you might, on certain days, all of you, who knows? But what you know about the people next to you and the people behind you certainly is far greater than you did as strangers before this. You may think that this is a group decision. Well, it's not a group decision. It's an individual decision for each of you. And when you do that, each of you has to determine and has to make sure that the state of Florida has proven every single element of every charge that exists as it relates to Savante Sampson. You told me, and this all has to be done to the exclusion of a reasonable doubt. You told me in jury selection you'd remain true to that belief no matter what the circumstances are, despite the fact that you may be in a minority, despite the fact that you might be alone in whatever that conviction may be. I'd like to thank you again on behalf of Zavante Sampson. I'd like to apologize again on behalf of Zavante Sampson. You have a very extremely difficult task to begin as soon as these arguments are over. Thank you for your close attention. Thank you for your attentiveness. When I'm going to sit down now, the rest of the lawyers are going to have their opportunity to address you in closing argument, and then Mr. Terry or Ms. Ismer or Ms. Bonte will be doing what we call rebuttal for the state. I won't have an opportunity to speak to you again, and I'm certain that after your deliberations and after you reviewing all the evidence, in particular those things I asked you and implore you to look at length in your deliberations, that you will find that the state has not met its burden as it relates to convicting Zavante Sampson for premeditated first-degree murder, attempted premeditated first-degree murder. There was no conspiratorial act committed by Zavante Sampson that would warrant his conviction for conspiracy to commit first-degree murder, nor shooting into a vehicle. He's not a principal to these crimes, ladies and gentlemen, and he shouldn't be penalized in the worst way that our system knows for the acts of someone else, those acts that he's not responsible for. It's pure speculation. Thank you.
Mr. Hernandez.
Counsel.
Whenever you're ready.
Thank you. Ladies and gentlemen, I also want to thank you very much again for your time, your attention, and your consideration of this so very important case. Please understand, just like the opening statements, everything that was said today by the state and by the defense attorney is not evidence. You have seen and heard all the evidence in the case, and your decision has got to be based on what you've already seen and heard. But this is our opportunity to summarize what we believe the evidence has shown or not shown. And as Mr. Gonzalez just made a reference to, this is our last opportunity. Each attorney has one chance to address you for the defense. The state will always have that opportunity to address you one more time after all the defense attorneys have sat down. Obviously, every attorney wants to have the last word, but what I want you to be very aware is that if the state in their rebuttal says something, and I don't want anyone to please think, well, how come the defense didn't come back and address what the state just said? And the reason is that they have the burden of proof, and as a result of that burden of proof, they get the last chance to address you. Now, my client is charged with counts 1, murder in the first degree as a principal. Count 2, attempted murder in the first degree as a principal. Count 4, conspiracy to commit murder in the first degree, also as a principal. And finally, in indictment, he's charged with shooting at or within or into a vehicle. Please keep in mind that all these charges against my client, he's being accused as a principal. He is not charged with count 6, which is actually discharging a firearm. Now, if we could start before we get into what was actually presented in this case, I'd like to go back and go over some of the important principles that must be followed by the jury in determining whether or not the state has met their heavy burden of proving their case beyond a reasonable doubt. And as we go through the evidence, please understand we're all taking notes. There is absolutely no effort to misstate anything. If I say something that you remember differently, please rely on your collective memories and your collective notes. But as we go through what was actually the evidence against my client, it's important to always keep in mind the things that you've already heard. The fact that the defense has absolutely no burden of proof. Every bit of the burden is on the state of Florida. And because of having no burden, and as you will be told again by Judge Fuson, is that the fact that the defense did not present any evidence or the defendant did not testify is not in any way to be considered by you against the defendant. And as we talked about, and Mr. Gonzalez just made reference to this, is that the burden of reasonable doubt is very, very heavy. The judge will define to you exactly what reasonable doubt means. And I paraphrased it once, and I'll try to paraphrase it again, is that if you have carefully considered all of the evidence, carefully and weighed it, and have an abiding conviction of guilt, then you are instructed to find the defendant guilty. But if you do not have that abiding conviction of guilt, or even if you do have a conviction of guilt, but it wavers and vacillates, you determine it's not stable. You say, well, maybe he's guilty, but yes, but what about this and what about that? If your feelings, it wavers and vacillates, and that's part of the definition of reasonable doubt, you are absolutely instructed, without a doubt, to find the defendant not guilty. And we talked about civil and criminal juries. Yes, in a civil case, if you believe a defendant, someone accused of something, being sued for something, if you believe that he's maybe guilty, possibly guilty, or even probably guilty, that's enough to find for the plaintiff. That has absolutely nothing to do with a criminal case. The burden of proving their case beyond a reasonable doubt is a very heavy burden that the state has. And as I said, the judge will give you the full definition, but it's important to talk about these things a little bit now so that we can evaluate what the evidence is or lack of evidence is against my client, Mr. Bedford. Each element has to be proven beyond a reasonable doubt, and you can determine reasonable doubt by the actual evidence that's been presented. You can determine that there's reasonable doubt for lack of evidence. You could say, well, the state presented this or that, but what else is missing? What about this? What else could have been done? Reasonable doubt can come from lack of evidence. Reasonable doubt can also come from conflict in evidence. And as I think I mentioned to you during jury selection, I can argue forever that my client is 100% innocent, but the word innocent never appears on a verdict form. You'll never be asked that question. The verdict form is going to say whether you find the defendant guilty as charged, guilty of a lesser charge, or not guilty. And that makes sense because that is consistent with the ultimate question is that you have for your consideration is whether or not the state has proven their case beyond a reasonable doubt. That's your question. And that's why the word, you'll see the words not guilty, and I suggest that is the appropriate verdict, but you'll never see the word innocent on a verdict form. Also, please remember the fact that the state has filed an indictment and the fact that it's a vehicle, it's a piece of paper that must be filed in order to get to this point. But the fact that he is charged with this document is not evidence, and that we do, even though you have 5 defendants being tried together, you have 5 separate trials. My client is Jalen Bedford, and of course I'll be trying to focus specifically on the case against Mr. Bedford. I know it's been mentioned several times, but I implore you that sympathy cannot be part of your consideration. We have a tragic situation of a beautiful 4-year-old girl who was shot and killed as a result of what happened on this day. But somehow you're being asked, it's part of your obligation as a jury to decide this case on the evidence, not on the obvious emotional sympathy that one would feel for any fatality, but specifically with someone so young and so much love and life to give. I also would ask you to, as we go through this evidence, is to, and in your evaluation of the case against my client, not to speculate. Your decision has to be on the evidence that was actually presented. You can't fill in the blanks. If you find blanks, you can't fill in the blanks that the state has left you. Now, as I said, Mr. Bedford is not charged with discharging a firearm in this case. The state's theory of prosecution against Mr. Bedford is that he was a principal. They have accused him of being a co-conspirator. I suggest to you that what you have seen in this case against Mr. Bedford, there is no direct evidence that the defendant was a principal or co-conspirator in this case. There is no direct evidence of premeditation. There's nothing, no statements, no text, nothing in this case. Now, there's plenty of direct evidence that there was a shooting. You've seen the videos. That is direct evidence. You've seen certainly the testimony and photographs of the testimony of the medical examiners to cause of death and manner of death. There's a lot of direct evidence. But my suggestion to you is you've got to keep that separate, because there's no direct evidence to the crucial issue in this case regarding Mr. Bedford. Did, in fact, he have any knowledge ahead of time or any evidence that he was a willing participant in some kind of criminal activity? To be criminally liable as a principal or co-conspirator, the state must prove beyond a reasonable doubt that the defendant, Mr. Bedford, had knowledge and was a willing participant in what happened on this day. And I suggest to you that there is no direct evidence to this whatsoever. So that forces the state to rely on circumstantial evidence. And circumstantial evidence is valid evidence for your consideration, but it needs to eliminate all reasonable explanations of innocence. If it proves their case beyond a reasonable doubt, circumstantial evidence is valid evidence. But I suggest to you that in this case against Mr. Bedford, the circumstantial evidence that's been presented comes nowhere close to proving their case beyond a reasonable doubt. There may be suspicions thrown out. There may be inferences and suggestions. But to prove the case against Mr. Bedford, there's got to be a lot more than suspicion or inferences or theories of prosecution. Now, obviously it did not apply to this case, but in my cross-examination of Detective Celaya, I asked him about criminal conspiracy investigations. That as an example, there are times where criminal conspiracy investigations have wiretaps. Now, obviously, that would not be applicable in this case, but that's just an example of situations where you actually have evidence, not just speculation, but actual evidence that a person had knowledge, that he had an intent, that he became a willing co-conspirator. It's not applicable in this case, obviously, but you can't consider it as lack of evidence because there is no such evidence in this case against Mr. Bedward. The value of statements, either recorded statements such as wiretaps or text messages or conversations to other people, is that many times that gives you evidence to decide what a person's state of mind was at the crucial moment when this offense took place, when the shooting took place. But here I suggest to you, ladies and gentlemen, that does not exist in the case against Mr. Bedward. And that's part of what the argument is that lack of evidence can be a source of reasonable doubt. They may not tell you that, but the state basically, in so many words, is saying, well, you should draw from inferences based on these defendants being together in different vehicles when a fatal shooting took place. I suggest to you that this is not a situation where you can make guess or fill in blanks or speculate. There is no statements or criminal acts by the defendant in this case that shows knowledge, willingness to participate in a criminal conspiracy. Now, the evidence in this case also shows to you, ladies and gentlemen, that the defendant, Mr. Bedward, was totally cooperative with law enforcement. He agreed to speak with Detective Celaya, and certainly having a constitutional right to remain silent, and he didn't, by law, he didn't have to answer any questions, but he answered all the questions. Now, you will be instructed of out-of-court statements that don't happen in court, that you can consider that statements made should be considered with caution and weighed with great care. But nevertheless, he answered all the questions. He identified himself as the driver of his car. He's the registered owner of that car. He was not trying in any way to hide that he was there, that he was actually driving his car. He admitted to possessing a firearm, but that firearm was never fired. The state is not contesting, as obviously they didn't charge him with that count, so they're not contesting the fact that my client never fired discharged a firearm. And the state is not contesting the legality of possessing that firearm. He had the right to possess that firearm, and he denied any involvement in any criminal conduct as he was questioned by the detective. He consented to the search of his residence and his car. There was nothing illegal found. Nothing showing knowledge, nothing showing intent or willingness to engage in criminal conduct. There was ammunition in his apartment. But again, the state didn't charge him with anything. They're not contesting the legality of possessing that firearm. The same thing with a handgun in the car. The defendant is not charged with illegal possession because it was not a crime. So you've seen this evidence, but please understand that that evidence in no way implicates Mr. Bedward with any criminal conduct. So, ladies and gentlemen, I suggest to you that what we have here is that Mr. Jalen Bedward was merely present at the scene of a crime where a beautiful 4-year-old child was tragically and fatally shot. He was driving his car. The evidence, the testimony by one of the detectives is that the car didn't stop, it didn't speed up, it didn't slow down, it just kept going. And there were no shots fired from the driver's side of the vehicle. There is no evidence, ladies and gentlemen, that Jalen Bedward knew a shooting or any type of violence or crime was about to take place or did take place. There is no evidence, ladies and gentlemen, that Jalen Bedward physically or personally committed any illegal act. I suggest to you, ladies and gentlemen, that law enforcement came to the conclusion that the defendants knew each other and therefore conspired to commit a crime, basically guilt by association, that there was some type of coordinated effort as opposed to someone acting independently. Ladies and gentlemen, the two people, I and a friend of mine, could be walking down the street, and I see someone I don't like or even hate. I pull out a gun and shoot that person. My friend who was standing next to me is not guilty of anything unless there is evidence that my friend had knowledge in advance and did something to assist me. We don't have that in this case. There is no evidence that Mr. Bedward had knowledge ahead of time or did something to assist a criminal act. There are no relevant communications between any of the co-defendants before, during, or after the shooting. And as Mr. Gonzalez mentioned, this happened very quickly. This was not something that took a lengthy period of time. And in some cases, as I just mentioned, wiretaps. In some cases, you can have a cell phone analysis. In this case, we have the fact that there was communication or contact between different phone numbers. And you can have contact with each other is not proof, because an association or even a friendship does not equate to a criminal conspiracy. Text messages, which don't exist in this case, might if they are incriminating. Here we have no text messages or any communication, call it whatever communication you want, that Jalen Bedward acknowledged knowledge of an illegal plan, or that he was in any way agreeing to any kind of criminal activity. And again, those are factors that you can consider. You can consider the lack of evidence as a source of reasonable doubt. Someone, ladies and gentlemen, can innocently be at the wrong place at the wrong time. Someone can be merely present at the scene of a crime. Someone can act independently, even if in the company of others. And I know you're tired of me saying it, but I'll say it one more time. As jurors, you cannot speculate about what somebody knew or did. You need proof. You need solid proof. You need identifiable proof beyond a reasonable doubt. And I suggest to you that that does not exist in this case. Now, as we said, we have a joint trial in this case. We have 5 defendants. Each defendant and each charge must be separately evaluated. And the evidence is different. There's some similarities here and there, but the evidence is different as to each defendant. I hope that I have accurately shown you why the state's evidence against Jalen Bedward is sufficient to warrant being found guilty of any of the 4 charges that he's facing. Please take a good look at him separately. These references to they is not enough. Speculation is not part of the equation. And I suggest to you, ladies and gentlemen, that if you carefully consider the evidence in the case, what's been presented, but also lack of evidence, what has not been presented, what does not exist, and a conflict in evidence. If you do that, ladies and gentlemen, I suggest to you, as to Jalen Bedward, there is ample reasonable doubt, and the only just and correct verdicts are verdicts of not guilty. Thank you.
right, ladies and gentlemen, we're going to take a 10-minute recess before we begin with our next hearing.
All rise for the jurors.
He's from St. Pete, please. Yes. So he had this terrible fracture case. He's just standing there and we're waiting for everybody to come out. And he goes, I don't build them, I just farm them. He and I try to live by the churches.
All right, that's funny. Beat gets there and they take a break. you show up, you get there, and they take a break on you. All right, so Beat Killer three ways there. Very cool, very cool. All right, let's go through what we heard. So the state concluded their argument. She was talking about self-defense is not a defense in this case. The defendants made a choice to excitedly get into their cars and leave and gun them down. Car 1 disables the victim's car, then cars 2 and 3 catch up. Shots are fired after Willie gets out and starts running. Count 3 first degree of Willie, and that only includes Zavante and Quandarius, because Willie has escaped the car before cars 2 and 3 get close. So as Willie is running away, car 2 and 3 catch up. Count 4 is conspiracy of Willie, Mary, and Sonny, so all defendants are charged. This is Suni Bell. They hunted her down. The car was driving too slow, was parked for a minute too long. Whatever the reason, the state is saying they hunted that car down. She finishes pretty much with, they treat the Chevron as a bunker. There's no excuse for what happened. Then Brian Gonzalez gets up. He is the representative for Zavante Sampson. He started at 1:45. He ended at 2:42, so about 57 minutes or so. First of all, he apologizes for Zavante. He says it's taken a toll on all of us. It's very emotional. He says, including Zavante. He strongly disagrees with what the state of what's on the videos. He asked the jury to focus on the videos because they show a great deal of speculation. He talks about direct and circumstantial evidence. Then he talks about the principal theory, which he ultimately ends up finishing up on. The state wants you to leap with Zavante, meaning Zavante intended that the killing took place. That's the first leap. The second leap is to infer that he intended for Sonny to be taken out. So he intended it. That just takes place in general, and then specifically Sonny. I don't agree with that. I don't think there was intent to take out a 4-year-old. I don't think that was the intent. Nor do I necessarily think that anybody. But I mean, when you shoot 40 rounds, at least 40 rounds into a car, something bad's going to happen, right? Just something bad's going to happen. So that might not be such a leap. Something doesn't seem right. In Willie's testimony, he didn't know anything about the gravesite balloon release, which is interesting. He didn't have any substantial conversation with Corey Brown or his cousin Squeak, who was Charles Dozier. He bought some smoke from Corey. Says Sonny was screaming as he got out of the car. The shooting stopped. The car kept moving forward as he got out. Those initial shots got him to get out of the car. Mr. Gonzalez says, look at the video and look at the object that's in Willie's hand. So that's what he was talking about before closing started, or state continued their closing. Oh, here, I can take this off. Mr. Hernandez is done. All right. Detective Salea testified he didn't see any muzzle flashes from Willie's car. So Zavante lied about turning, and that doesn't... Lied about turning. Oh, I'm sorry, yeah. So Zavante lied about turning down 43rd Street. He says, but that doesn't make him guilty. He says it might make you not want to be that sort of person you don't want to be. It says, look at Mary's emotional state. It was very understandable. She was going to the gravesite for the balloon release. Willie took her to a field near Chevron, turned off the engine, turned the lights off, and made unsuccessful calls to his cousin Squeak. Mary said after that first set of shots and the car stopped, Willie got out, and then she got into the driver's seat, and that's when she heard Sonny say, "Mommy, Mommy." Law enforcement didn't search for anything pertaining to Willie Brown because no firearm was found doesn't mean there was no firearm. So they didn't search. Yeah, they didn't search the neighborhood for any kind of firearm. Then he gets to the forgotten car 4. Talks about that for a little bit. What in that video tells you Zavante got into that car with the intent to take somebody out. Pay close attention to the principal instruction. If Zavante helped to commit, then he is a principal and he must be treated like he did all the other things. So that's the burden. And then he thanks on behalf of Zavante and he apologizes again. Virtuous says, I don't think they intended to hurt the little baby, but they intended to hurt someone. Yeah, I don't think anybody intended to. I don't see that. I don't see that. But shooting into a car multiple times, something bad was going to happen. If not just directly, something that car could have rolled over, car could have turned into one of these, one of the defendant's cars. Car could have gone across the medium, smashed into some other cars. Could have been people walking on the sidewalk, getting shot randomly. A lot. As bad as it is and was, and it is absolutely terrible that Sonny's no longer with us, you have to say it could have been even that much worse. Again, Willie could have lost control. That car could have smashed into 2 other cars. Could have, smashed into one of the defendant's cars. Any could have definitely been just a complete disaster. So as bad as it was and is, 100% not taking away from Sonny at all. But there could have been just even more people involved, more fatalities. All right, so then Danny Hernandez gets up. That's Jalen Bedward's. He's the car 3 driver, and he started at 2:42, ended at 3:05. So he was about a half an hour. He talks about counts 1, 2, and 4. Jalen is the principal. He says there's plenty of evidence there was a shooting. So he's not denying there was a shooting, but Jalen was totally cooperative with law enforcement. He didn't have to, but he did give statements. There's no evidence Jalen discharged any firearm. So they're going more with like, hey, my guy was just driving. I didn't have any, he didn't have anything to do with it. He was just driving. The state is saying, well, doesn't matter. Somebody's discharging a firearm. You're still guilty. That's the state is saying that. Of course, the defense is saying, my guy didn't know. So, what's the jury going to decide? He consented to search of his home and his car. Yes, there was ammo in his apartment. Yes, there was a gun in his car, and there was ammo in his car. But the state didn't charge him because he had the gun legally. And same with James. James, they all possess, or at least James and Jalen, they possess the firearms legally. They have permits. So that's not debatable, or that's not up for debate. He's saying Jalen was merely present. So, but being merely present at the scene of a crime, you're not just like a bystander, you're actually driving the vehicle that is committing the crime. So, Jay says, why chase if there's no why chase if there was no intent? Well, that's yeah, they don't have to prove motive, but they just have to prove the intent. So yeah, why get in that car in the first place? Now remember, they said that they were, well, in openings they said that they all kept driving, that they didn't turn around. So far we haven't heard anybody say they kept driving. That's interesting because they all said in their openings that they, let me review openings again. Just see if they all kept driving. Bedford was merely at the scene, didn't participate. So Danny's saying pretty much the same thing. Bedford was merely at the scene, didn't participate, didn't conspire. No evidence will show that. He did own a gun, but didn't fire it. He handed over his phone, consented to a home search. He saw trouble, and the only focus was getting the heck out of there. No proof of him firing his gun. So he pretty much said the same thing. And now next up should be Danny Frassetti, who is James Denson's representative. But we'll see if that's the case. All right. Richard, it's not only intent, it also covers all other culpable mental states, those being knowingly, recklessly, and with criminal negligence. Lily Wayne says the deliberations could take multiple days with hung jury and then back in deliberations to try again. Aaron is saying our AC just went off, so that means fall is in the air for us here. Fall is in the air. All right, so next up should be Danny Frassetti based on how their openings went. So we'll see if that holds true. So do you think Cervantes' outburst will help him or hurt him? Or disruption, however you want to say it. Disruption, or I guess, yeah, it was more of he disrupted court. Hurts, not a good look to lose it, 77%. Helps, jury has some doubt now, 23%. All right. Cindy, I've had windows raised today, breathing in country air. Very nice. Ellen, I could not have been on this jury without very clear instructions. I am having flashbacks to the Ollie case, and they had real clear footage. Yeah, that is true. Jenny, what's the temp down there? 81 in upstate New York. Whew, that's toasty. What are we? We're at, I got 85 here. So we're 85. We're a comfortable 85. All right. Waiting for court to come back from a break. '85 in Chicago. Wow, daughter's soccer games were hot this weekend. Mallory says. Trixie, it's 90. 90 for you. That's pretty hot. We haven't had 90 for a while, thank gosh. 69, Janie's saying. That's comfortable. Sherry, do you think the jury will get the case today or in the morning? That's a really great question. 3:30, judge said he did not want to break the closings up. We have 3 more to go and then rebuttal. We still have 3 more to go and then rebuttal. So Janie, you're in Ottawa and it's 90? Or no, wait, no, I'm sorry. 69 in Ottawa. Gotcha. So judge did not want to break up these closings. So we have 3 more to go. We've heard from Zavante and Jalen. We've heard from the 2 drivers. We've heard from the representatives from the 2 drivers. So now we have to hear the representatives from the 3 shooters. So Quandarius, Andrew, and James reps still need to talk. So if each one of those goes a half an hour, that's an hour and a half. So that puts us at 5 o'clock. And then we have rebuttal, which will take us to about 5:30. So to answer your question, will the jury get the case today? If they do, I thought the earliest they would get it would be by 4, but I was not anticipating what happened with Zavante. So that whole thing with Zavante threw him off at least an hour, because it took him like an hour to get the room set up with the TV. So good question. Will they get it? Possibly. The real question is, Sherry, will the judge let them stay and at least pick a 4-person, or will the judge just say, okay, go home and then come back fresh? That's really going to be the question. Uncle Woke is here. Where's Uncle Woke? There you are. It's still hotter than 2 mice in a wool sock here in Central Florida. 80 degrees in Trenton. Very nice. It is 3:23. 3:23, Amanda. So almost 3:30. 3:23. So Mandy, I would say they're going to finish. Yeah, I would say they're going to finish closings. If it depends on these closings, though. If they go for, they still have 3 more to go, and if you go half hour each, that's an hour and a half. So 3:30, 4:30, that puts them at 5 o'clock. And then the state has their rebuttal, and they still have a half an hour. So it really depends on these defense attorneys. If they only do 15 minutes, that's fine. If they do 45 minutes to an hour, I have a feeling this jury's going to stay no matter what. I think this jury is going to. The judge at this point, he didn't want to. He does not want to break up the closings. He said that on Friday, so he may just crash and burn and get them through today. Why is the bailiff messing with Beat? I didn't see that. Did something happen there? I missed that. People are coming in. I didn't see a bailiff messing with anybody. Oh, I see. He's talking to him, yeah, let me see. Huh, yeah, he's just sitting there and he goes over. He's kind of talking to all of them. Interesting. Looks like he's just talking to them. Yeah, looks like he's just talking to them. Maybe, I don't know. Looked like he was just talking to them. Yeah, looking like he was talking. Yeah, I just rewound it and I was just kind of looking at it. Looks like he was just talking to him. Pammy says he was just talking to him as well. Yeah. We'll have to ask him. It didn't look like it was too aggressive, like he was just kind of talking with them.
Prize for the jurors.
Jury's back. Y'all may be seated. Welcome back, ladies and gentlemen. No problem with following the court's instructions. Very good. Mr. Fischetti, whenever you are ready.
Thank you, Your Honor. Please support and counsel. As I have the distinct honor and privilege of representing James Denson throughout this trial, I asked you last week to consider the circumstances of the killing and the conduct of the accused, because we have 3 distinct vehicles that you've heard evidence regarding, and we have multiple different people who may or may not be before you today who were inside of that vehicle. And each individual person, you're going to have to decide what involvement they had based on their own conduct and their own conduct only. And you don't need to take notes on what is written on this that I'm using for display, but because you will be given a copy of all these things. But this is what it talks about when you have multiple defendants, multiple counts. And it says the charges against each defendant and the evidence applicable to him must be considered separately. And why is this important? On multiple occasions during our time here together, the government has used the word they as it pertains to evidence of intent, as evidence of overt action, and as evidence of a common plan. They masked up. They armored up. They went to war. However, because the law instructs us that you must take an individual analysis of each person's culpability as to each specific element of each crime, you'll be able to see that the analysis as it pertains to Mr. Denson fails. Because guilty by association is not a phrase that exists in this courtroom or back in the room when you go to deliberate. An irrational person should question why, whether under the facts of this case, the prosecution has made a blanket over this courtroom with the word they. So let's talk a little bit about jury instruction as it pertains to murder in the first degree. The annotations here are all going to be mine. So you will be charged to prove the crime of first degree premeditated murder, and I'm asking you in your minds when you're discussing it with each other, where I wrote in blue ink, to say, as to James Denson, the state must prove the following 3 elements beyond a reasonable doubt. And the reason that we do it this way is for efficiency. But efficiency and convenience cannot trump my client's constitutional right to a fair trial. And any confusion in this area, even if we're being overly cautious, cannot happen. So when I say to prove the crime of first-degree premeditated murder as to James Denson, the state must prove three things. Number one, that Suni Bell is dead. Okay, that's not going to be in dispute. But what will be in dispute is number two, the death was caused by the criminal act, which I have highlighted, of James Denson, which I also have highlighted. And you see I put X's under here where it says and/or. Because even though we'll talk about principal theory and that's something like that, you cannot hold my client accountable if he did not intend for these crimes to occur. The death was caused by the criminal act of James Denson. If he didn't do it, you cannot hold him accountable for it. Okay? And then there was a premeditated killing of Suni Bell, again, which is an element of the mind. And why, when we're talking about premeditation, has the phrases that I've used throughout this time been most important. Okay? The circumstances of the killing and the conduct of the accused. When discussing the principal theory, okay, again, this is not something where we can just throw a blanket over these proceedings and say, because the government has the principal theory available to them, that we can just say everybody is responsible for the actions of everybody else. Because, as I've highlighted for you in the instructions, it is still crucial that the defendant must intend for the act to occur, and you must be given evidence of that. And that the defendant did an act that was intended to assist somebody in actually committing the crime. And for first-degree murder, the state must prove that the defendant intended for Suni Bell to die. For attempted murder, as it pertains to Mary Harrison, the state must prove that James Denson intended for that crime to occur. Without intent and without action, the principal theory should not apply. And the same applies to the lesser included crimes alleged of murder in the second degree and manslaughter. Again, I ask you to, in your mind, state to prove the crime as to James Denson. We must show that the death was caused by the criminal act of James Denson. To prove manslaughter, that James Denson intentionally committed an act. And so on, whether it's an attempted murder, whether it's a shooting into a vehicle, there has to be an action taken by my client, James Denson. So how do we determine what is in the mind of a person? What is their intent? What's an overt act versus reaction? So let's look to three places. We've got the Jet or the Chevron gas station. We've got the stretch of Hillsborough Avenue between 45th and 42nd Streets. And then we've got Mr. Denson's home. So first I'd like you to go to the Chevron. And I think that to allege that Willie Brown's Infiniti drew the attention of my client at the Chevron when it was parked in an unusual location in a grassy lot with its lights off later at night, to think that James Denson's attention was drawn to that because he was offended somehow that these people were on his turf, I think that is somewhat outrageous and short-sighted. We cannot check our common sense at the door. We cannot forget about our life experiences when we serve as jurors. And I don't think that we can be ignorant of the life experience or circumstances of those who stand before us. I think we should similarly judge others through the way that they view life. And I think it's certainly reasonable in certain parts of town to view actions like that as something that can be a safety concern for you. So investigating the appearance of Willie Brown's Infiniti in an unusual spot is not evidence of a common plan or a scheme or an intent to commit a crime. The court is going to instruct you that a reasonable doubt as to the guilt of my client can come from the evidence, from a conflict in the evidence, or from a lack of evidence. And the evidence from the chevron, from Detective Saleha, from the videos, tells us that Mr. Denson is not present when anyone carries a firearm, anyone displays a firearm, anyone loads a firearm into a car, anyone disguises themselves at all. He is out of the picture for all of those events. And where does he go? Where is he when all of these things are occurring? If you look at the video, you do see him running from the side of the store back off in a different direction. And where did he go? Well, according to Detective Saleha, my client, James Denson, went to his car. His car is not one of the 3 vehicles that exited the Chevron parking lot that night. He goes to his overview. If you look at... If you look at the video from the Chevron, specifically states 56, it's going to be taken as you look at 300. And when you're looking at that, it's going to show you that Mr. Denson is basically off to the side, okay? So small you can barely even see him next to it, but you'll see the reflective Nike insignia on his shirt, okay? And when he goes over there, and he's coming back over there, you're going to see the Chrysler 300 getting ready to leave the parking lot. That's the car that Mr. Denson ended up in the back seat, okay? Why is it important? Why is it the timing and circumstances going to be something that we should key in on? Why didn't he get in his car and why didn't he leave? Well, we know from Sergeant Lippold, the homicide supervisor that went to Mr. Denson's home to speak to him, that in the parking lot of his apartment complex on September 28th, that Mr. Denson tells him that at some point prior to that, he had locked his keys in his car, because Sergeant Lippold looked at his car. He's like, hey, why's your window broken on your car? He's like, hey, man, I locked my keys in the car. I had to break in there to get into the car, okay?
Objection, Your Honor, that's not evidence.
I would just...
what the attorney says is not evidence, and you're not to consider as such.
Thank you. So when relying on your own recollection of what was testified to, I would submit to you that it's a reasonable inference that James Denson didn't leave that night in his car because he couldn't. That as the 300 is backing out, he made a split-second decision to enter into that vehicle to get in and leave the situation at that point, okay? So let's talk to you about place number 2, the stretch of Hillsborough between 45th Street and 42nd Street. So looking at State's Exhibit number 20, which is where we have our measurements on Hillsborough. We've got all the evidence markers here. We've got it zoomed in here right around 43rd and the point of reference where the vehicle struck. And then to the west, we've got additional casings, okay? And then we've got measurements. And so we can tell, based on the information that we get from James Kwong, based on the markings that were taken, that number 43 and number 44 are the 2 shell casings that are attributable to Mr. Denson's firearm, okay? And we can tell from looking at the measurements that number 43 was located almost 100 feet west of the point of contact with the telephone pole, and number 44 was about 129 feet west of the telephone pole. Why are these measurements important? Okay, so James Kwong came from the Department of Law Enforcement, the ballistics expert, and he gave us an education about what happens when a semi-automatic firearm is fired. You have an ejection of the casing, and it's going to go slightly to the right and slightly behind. You're going to know that it's in a tunnel or a vacuum. It's going to go between 0 and 15 feet away from the point that it is fired. And then even though things like people kicking them or vehicle traffic can affect where the casings eventually land, along with the type of terrain that they land on, we can probably take away a reasonable inference that these casings were not run over. As you saw pictures of the ones that got run over, these were not defected or deformed in any way. So we know that the scientific evidence tells us that Mr. Denson shot a handgun anywhere from 100 to 130 feet west of the accident site. Doesn't tell us in which direction he shot. And I would argue that the majority of the damage to Willie Brown's Infiniti was to the rear and to the driver's side of that vehicle. That the critical shots are going to be found and the critical number are going to be found in that direction. You don't have a windshield that's pierced by a bullet, and there, are other things in that area that the police found it noteworthy to document. For example, if you're looking at States Exhibit 1EQ and States Exhibit 1ER, where you have evidence marker number 40, okay? And evidence marker number 40 is what they believe is suspected gunfire damage to a shop that's located at 4172 East Hillsborough. So why are they documenting this damage? It's because we think a bullet may have struck this building, okay? Importantly, when we're looking at where the evidence markers are, you have evidence marker, you have the point of reference right here where this happened. You have the evidence marker 40 up here, and then 43 and 44 as it corresponds to the shell casings as it relates to Mr. Denson are similarly located to the west. So if we're focusing on intent and overt acts, we can't guess, we can't assume. But I would submit to you that all of the evidence in the situation is going to tell you that there is zero way that the state can show that any specific shot from Mr. Denson was inside or at the direction of that Infiniti. So let's go back to place number 3, Mr. Denson's apartment complex. So let's paint the picture a little bit. You have multiple homicide detectives that are coming to your home. This is not a casual conversation, okay? And if you recall, this is the home in which they found a Coach mini backpack and Nike slides because they were trying to say, okay, was Mr. Denson at the Chevron on August 22nd? And he told them that he was, okay? He also, was advised you're not free to leave. But at the same time, we can't, or you are free to leave, excuse me, but at the same time, we can't have you just sitting on your couch while we are cataloging and collecting evidence as part of this homicide investigation. So they're in the parking lot. Detective Saleha tells James Denson, you've got the right to remain silent. You've got the right to the presence of an attorney. You don't have to speak to us at all. You can exercise any of these rights at any time. And knowing these rights, do you still wish to speak to me about the shooting at the Jet? And he says yes. And he was asked, you got a concealed weapons permit, right? He says yes. Do you own any guns? Well, yes, I pawned my 9mm at East Tampa Gun and Pawn. I got a loan, because when you pawn something, you can outright sell it to the pawn shop or you can get a loan on it. Money's tight, but I plan on getting it back when I can. So this is the first time that the police are aware of any firearm that could be involved in this case. And my client gave that information up freely and voluntarily, not by accident, not by trick, And as we discussed before, this is the exact opposite of a guilty conscience. A person who consciously took part in, participated in, or otherwise intended for the murder of one human being to occur or the attempted murder of another person, they're going to get rid of that weapon. They're going to do that so quickly if they're involved in the situation, you wouldn't be able to believe it. You're going to throw it in the river. You're going to give it to somebody else. You're going to sell it on the street. You're going to get money for it. You can ask somebody else to sell it under their name. You don't go to the pawn shop directly next to the jet, the Chevron, where all of these events started, hand over your driver's license, hand over your fingerprint into a database that can be searched by the police, and get a loan and go on your way. And we know Mr. Denson led the police there. Number one, because Detective Celaya, the lead detective, he told us. I know Sergeant Lippold had a little bit different recollection of the order in which these things happened, but we know that Detective Celaya was accurate because looking at State's Exhibit number 33, which is the pawn ticket, see, when you take something into custody, they put an evidence sticker on it. And the date of this one here is September 28th of 21, which is the same date as State's Exhibit 28, which details the search warrant that occurred at Mr. Denson's home. So we can know with confidence that this is actually what happened, okay? He pawned the gun 25 days later, not 28 hours later. He cooperated with the police in this instance. He cooperated with the police in others. He gave his passcode to them when they found his cell phone. And by the way, when they searched his cell phone, you don't have evidence of one web search, one specific text message saying anything about this, one specific group chat saying anything about this, one specific photo connecting him in any way to do this, and all that data was on the phone. It wasn't wiped, it wasn't reset or anything like that. It was there for the taking on September 28th, okay? There's no evidence to hide, all right? So much has happened over the last 4 years to develop this case. And we all know that the standard to make an arrest or initiate a prosecution is much different than the burden that we have here, which is the highest under the law, under our Constitution. So at the time that Detective Celaya did confer with the prosecutors to bring this charge, I asked him if he had Detective Alverson's mapping of the scene and where the shell casings were found available to him. And he said no, he did not have that information available to him. Would it have made a difference then? I don't know. Sometimes you can't put the genie back into the bottle. But I do think that it should make this group think twice about if that information was available, would it matter then? But I definitely think it should matter now. If we're considering where the shell casings from Mr. Denson's gun were found, his cooperation with law enforcement, and the fact that he certainly hasn't had anything to hide. So let's talk a little bit about one final thing. We're going to talk about how you be instructed on the law about reasonable doubt, okay? What the law is going to say that after you carefully compare, after you weigh, after you consider all of the evidence in this case, if you do not have an abiding conviction of guilt, meaning if you have a conviction, but it's one that goes back and forth, it wavers and vacillates, then the doubt is reasonable and you must find the defendant not guilty. If you're going back and forth regarding whether or not you should find him guilty of these charges, that is a reasonable doubt and you must find him not guilty. Because this is the only opportunity that I'll have to speak up for Mr. Denson, I'll ask each of you to think to yourselves, whether it's during the prosecution's rebuttal or whether it's in the jury room itself during your deliberations. And when something is brought up that makes you think about James Denson, I would ask you to say on his behalf, what would Mr. Fischetti say if he was able to speak to me right now? You know, Mr. Terry spoke during jury selection about running yellow lights and how that is an example of premeditation. That was it enough time to make a decision to act? But isn't that really a reaction when you go through the light? And later on, when you have the chance to think about it, when you have the chance to think to yourself, to reflect, maybe you say that it wasn't the best idea that I did that. Because an overt act, what we're talking on here, that's intentional. But a reaction, like when you go through a yellow light in that short time frame, that is unintentional. And because the government hasn't proven otherwise, I would ask you to find my client not guilty. Thank you.
Mr. Sonardi?
Please, the court. City. Good afternoon. As you will recall, my name is Nick Sonardi. I represent Mr. Andrew Thompson, and on behalf of Mr. Thompson, the gentleman sitting on my left is Katie Rain. We want to extend to you our appreciation for your services here. I know it's been very difficult, very imposing on your lives, and I'm sure at points in time you kind of feel like cattle, hurry up and wait, come back, leave, come back. But we do appreciate your time and your effort and your concentration. This is the last opportunity I will have to speak with you. As the other attorneys have indicated, the state has the final word. They will be the last ones to speak. What the judge has indicated, I believe a couple of the attorneys have indicated, what I say, what the state says, other attorneys say is not evidence. What is evidence is what has been introduced by the court or from the witness stand. That is the only evidence. If I indicate something to you that does not coincide with your recollection, use your recollection. It's not my intent in any way to mislead you or misinform you. There's been a lot of testimony, a lot of things going on over the last 6 or 8 days. So if my notes are not reflective of your recollection, use your recollection. Your recollection is what is important. Again, the charging indictment is not evidence. It's simply the means by which to get these gentlemen into court so that a jury of their peers can make a determination as to whether or not the state has proved their case beyond and to the exclusion of every reasonable doubt. Again, my statements are limited only to Andrew Thompson. I do not represent any of the other individuals sitting here, so my statements only apply to Andrew Thompson. As I indicated on our opening statement, which was kind of an outline of where we thought the evidence was going to go or what was going to show, is that this was then and is now, as it applies to Andrew Thompson, a circumstantial case. There is no direct evidence implicating, beyond and to the exclusion of every reasonable doubt, Andrew Thompson in any of the 6 counts that the state has charged. So what is the evidence, or lack of evidence, or the circumstantial evidence? Well, we can start with the witnesses. The state called a number of witnesses, obviously, and I guess the most important ones was Willie Brown and Mary Harrison. What do they add to allow you to believe that Andrew Thompson was somehow involved in the shootings in this incident that occurred. Nothing. They can barely identify the cars, barely identify any shooters, barely identify anything other than they believe they were being shot at. And I believe Mary Harrison identified a black car as one of the individuals, one of the vehicles that was shooting at her. Detective Neitlinger, he confirms that 3 vehicles left the Chevron gas station that evening around 9 o'clock in the evening, and that 1 vehicle returned. I believe he's the one that indicated that the number of minutes that expired from the time the last vehicle left to the time that 1 vehicle returned. However, that vehicle did not include Andrew Thompson. Okay? He was not in that vehicle. Detective Albertson also indicates there were 3 suspect vehicles that left that Chevron. He believes one of them was a black in color vehicle. And of course, the lead detective is Detective Salela with the Tampa Police Department. He obtained a number of the videos. Some of the other individuals obtained other videos. I believe there was 8 videos obtained. Some of the 8 surveillance locations, some of them had multiple videos, but at least 8 surveillance locations that videos were obtained. It's the state of Florida's position that Mr. Andrew Thompson is somehow involved in a conspiracy to commit first-degree murder. What I submit to you is that it's clear on the videos, and you've seen them and will continue to see them, that there are a number of people at that Chevron station, at least 9. We know of at least 9 individuals, but only 5 have been charged with conspiracy. The actions that the state attributes to Andrew Thompson and others that constitutes this conspiracy also applies to the other 4 individuals that were there at the Chevron station. However, they're not charged with any conspiratorial action. For whatever reason, the state chose 5 individuals, but not the 9 that we know that were there, that left in the 3 vehicles. We know there were 2 in one vehicle, allegedly 3 in another vehicle, and 4 in the second. They're calling it the second vehicle. They were all together. Their actions are the same, consistent with the actions, alleged actions of Andrew Thompson that's allegedly constitutes a conspiracy. Why aren't the other 4 individuals charged with a conspiracy? Obviously, and I'm not going to go over it, you all have seen them, you all have heard them. The evidence in this case, as it applies to Andrew Thompson, is predicated solely on the videos. That's it. No other evidence whatsoever. It is the videos, and the videos alone. Now, what's important about that? What's important about that, obviously, is not what the state thinks the videos show, or what I think the videos show, or even what Detective Salela thinks the videos show. What's important is what you can determine those videos show, okay? And I submit to you, you will find that it's very difficult, if not impossible, to identify exactly what is transpiring in the videos other than cars going up and down Hillsborough Avenue, okay? No one can be identified from any of the surveillance videos in any of the cars. And I submit to you, it's difficult, if not impossible, to identify the vehicles themselves. What vehicles are doing what at what time. The state has a theory. Detective Salela has a theory, and they presented that theory, but it's your duty and job to sit and review those videos and try to make a determination as to what is on those videos and what evidence applies to Andrew Thompson. the allegations by the state as they apply to Andrew Thompson is that he was allegedly the occupant of the Chrysler 300. There's a Chrysler 300 that's involved, allegedly involved. And I submit to you there is no evidence whatsoever, because that car was taken into evidence, processed, etc. There's no evidence, physical evidence, that connects Andrew Thompson to that vehicle. No prints. There is the evidence of 40 shell casings that were processed from the scene, that the state did a wonderful job of identifying where they were all along Hillsborough Avenue, did them by color, coordinated them, and everything else. Those shell casings were processed for evidentiary value, including DNA, swabbed. You remember the ID tech that swabbed all those shell casings? There was nothing that came back that implicates Andrew Thompson with the shell casings, nothing whatsoever. Neither were there any fingerprints. There was a lot to do about ballistics. That is, Kwong, the ID tech, or the ballistics expert, opined about the shell casings, etc., went through a big dissertation about the shell casings. He is an expert in ballistics, and there was a lot to be done with, I believe, Detective Alverson and Detective Salela about muzzle flashes. We heard a lot about muzzle flashes, okay? Whether or not you can determine or distinguish between a larger, allegedly a rifle versus a smaller one. Well, Mr. Kwon is an expert in firearms. He was never asked to review the video and make an expert opinion as to what weapons were making what flashes. There were no guns attributable to Andrew Thompson. There was no guns recovered. The only guns in the car that he's alleged to have occupied, and that was Jalen Bedward's car, was the box in the back, but that was not Andrew Thompson's vehicle, was not his box. There's no connection between he and the box that was found in the back of the car, of the silver Mercedes, silver Chrysler. If you'll recall, Detective Salela came in contact with Andrew Thompson at his apartment sometime after the incident in Brandon. There was no evidence, anything of any evidentiary value recovered from Andrew Thompson's residence at the apartment. There were no any kind of incriminating statements. In fact, Andrew Thompson voluntarily identified himself on the video at the Chevron gas station. Okay, voluntarily said, "Yeah, that's me." There are no, other than him identifying himself, there are no statements incriminating by Andrew Thompson in any of the incident involving Suni Bell. I think what's very, very critical as it pertains to Andrew Thompson is the phone data that was introduced by Detective Van Hess and Detective Boers with the Tampa Police Department that did the cell data reports on Mr. Andrew Thompson's phone. And as we know, this is State's Exhibit, Composite Exhibit 45, and this is the phone data, if I have it, for Andrew Thompson. And what does that display? I believe the red and blue dots that you see there obviously are where the incident occurred. That would be here and here. I believe the red is where it allegedly started. The blue is where the incident stopped. The circle that you see is the cell data indications from what Detective Boers was able to obtain. And those are for, so we're clear, that data was from 9 o'clock p.m. to 9:10 p.m., and the first ping was 9:09.55, which is a good distance from where the incident occurred, and there are no pings in the area where the incident occurred. What's interesting is it is right over I-4, which goes where? To Brandon, which is where Detective Salela came in contact where Andrew Thompson lives, in Brandon. So I submit to you the phone data puts Mr. Andrew Thompson at or near I-4 during that 10-minute time frame, because it didn't ping anywhere else around Hillsborough between 43rd and 45th Street. There are 0 calls between Andrew Thompson and any of the other defendants during the time period of this. I believe one of the detectives said, believe there was a not on Andrew Thompson's phone, on someone else's phone that's alleged to have come from Andrew Thompson's phone some 2 hours after the incident. That's the only connection between Andrew Thompson and the other individuals. Based on the circumstantial evidence of Andrew Thompson getting in the vehicle, there is no other evidence implicating Andrew Thompson in the tragic death of Suni Bell. As a result of the charges, and I'm not going to read them all because you've heard them 2 or 3 times, and that is the principal instruction basically says that Andrew Thompson had to have participated that he intended the crime to occur and did some act in furtherance of the crime. The only act that we can establish, that the state can establish beyond a reasonable doubt, is that Andrew Thompson entered the car. That's it. There's no guns attributable to him. There's no evidence attributable to him that he's identified in any time inside the vehicle. And other than entering the vehicle, there is no evidence of any act committed by Andrew Thompson. And what about the criminal conspiracy? Again, I'll reiterate that there were 9 people, allegedly 2 in one vehicle, 4 in another vehicle, and 3 in another vehicle. There were 9 individuals, but the state has elected to charge only the 5 defendants that are here today with conspiracy. And again, their premise is their actions at the time on the video indicates a conspiracy. I submit to you to commit murder. I submit to you that the actions then are the actions of all 9 individuals and not of the 3 individuals. And I submit to you, the 5 individuals, but I submit to you that there is no evidence of a conspiracy. The actions are of a number of people, 9 people at a Chevron gas station that are apparently moving around and talking. You can make your own determination, but there is no agreement. There is no agreement And as it applies to Andrew Thompson, there is clearly no intent that there be a murder, and that there is no agreement between he or anyone else to commit a conspiracy to commit first-degree murder. And again, you will have with you in the jury room all of the instructions, which will include lesser included, which are second-degree murder, attempted second-degree murder, etc. And if you find that the state has failed to prove the primary charges beyond to the exclusion of every reasonable doubt, you have the right to determine whether or not they've established lesser included offenses: second-degree murder, attempted second-degree murder, manslaughter, attempted manslaughter, etc. You have the right to make those determinations. Okay. As I indicated in the original opening statements, however many days ago that was now, this is a circumstantial case. That has not changed. There is no direct evidence, none whatsoever. The only direct evidence in this case as it pertains to Andrew Thompson is that he was at the Chevron gas station. That's it. His phone records contradict that he was anywhere near the scene of this horrible incident. Okay. The only evidence, direct evidence, is Andrew Thompson being present at the Chevron. There's no guns. There's no physical evidence that connects Andrew Thompson to this horrible, horrible episode. I submit to you that because of the lack of evidence, the conflict in the evidence, that you should return a verdict of not guilty as to Andrew Thompson. This should not be based on any sympathy on your part in terms of finding somebody being held responsible for the horrible death of Suni Bell. But the biggest tragedy of all would be to return a verdict of guilty for an innocent defendant. I ask that, based on the lack of evidence, the conflict in the evidence, that you return a verdict of not guilty as to Andrew Thompson. Thank you.
Mr. Bradley.
Good afternoon. Over 30 days before any arrests were made in this case. That's some testimony that you heard from Detective Salea. Way longer than the first 48 hours after the incident involving Suni Bell. You heard his testimony about the media coverage. In fact, Ms. Ismer showed you the photograph of Suni Bell that was used to try to get help from the public to solve this case. As you can imagine, with the death of a 4-year-old, there was tremendous community pressure to make an arrest. That's what led to what you've witnessed these past 2 weeks: assumptions and speculation. You heard about the police responding to the incident scene and how there were no independent eyewitnesses. You saw a still shot of the body cam where there were civilians out there trying to render aid to Suni Bell. But there were no witnesses from the Chevron or from any of the cars driving up and down Hillsborough or any of those individuals that were there that were able to help police identify who was involved in this case. That has continued throughout the investigation. There was no active pursuit of a suspect that evening. There was no car that was being followed. And so they were left to look for video evidence in this case. And they collected that surveillance that you've seen. They also collected evidence from the scene that was pretty much limited to casings that were on the road. Detective Celaya went and spoke to Willie Brown and Mary Harrison, and they were not able to identify who shot at their vehicle that night. And you heard that same testimony when they came into court. They said it might have been a black car, that they heard shots. Remember, police had all of this video surveillance pretty quickly. Detective Neitlinger testified about it. Detective Celaya, the first responding officers testified about the evidence that they collected when they were out there. Yet no charges were made in this case for over a month. When law enforcement started to review the video, they determined that there were 3 cars potentially involved. Now you have the video for you to determine who's involved in this case. As you've heard previously, no one from the second car is charged, and they know who was in that car. They focus their attention on the actions of individuals at Chevron. And Ms. Ismer and Mr. Terry and Ms. Bonte, they presented the individual video of the different people that are here today charged in this case. Pay attention to the video of Mr. Hammond, how he's playing dice when the 3 individuals go into the field and across the street to look and point. Also pay attention to the video surveillance that you saw of who the state alleges is the first car turning south on 43rd Street. That car was not in the area of the other vehicles when Suni Bell was shot. That's undisputed. She was alive when Willie Brown got out of the car and Mary Harrison started to drive. That's been consistent with all of the testimony that you heard. There was testimony that you heard from Mr. Kwong and diagrams that were submitted. He told you that there were several casings and the state made a point of excluding that one casing as being weathered and not part of the case. But even aside from that, he told you that 5 different firearms were discharged. He said 4 9mm and 1 rifle. There were 4 people in that second car and 3 people in that third car, which is a total of 7 individuals. That would be enough for there to be 5 shooters and 2 drivers with those 2 vehicles alone. The state in this case is charging only 3 people as potential shooters: Mr. Hammond, Mr. Denson, and Mr. Thompson. And you already know from the evidence that there's more than 3 shooters involved. And we know who's in that second car. Detective Celaya testified to that. Maxwell Bedward, Kamani Bedward, who's the black male in the white shirt that we pointed out in the video, who's reacting to the vehicle, Cedric Brown, and Devin Sampson, the black male in the red shirt. And I had Detective Celaya point out who those individuals were in that video that you're able to see. And the state wants you to believe that they're not charged simply because they don't identify themselves. Is that how easy it is to avoid getting arrested for first-degree murder? Does that make sense to you? And pay attention to what the video is, because the state wants to try to minimize that second vehicle and say, well, we're being overly cautious. We're only charging the people that we have the most evidence on. But pay attention to the evidence if it's all the same. And as Ms. Ismer argued, that they didn't have beyond a reasonable doubt for the second car, then how do they have beyond a reasonable doubt against Mr. Hammond? You can see that video from the Chevron that looks like Kamani Bedward, the individual with a white shirt who reacts to the vehicle, also looks like he has a gun. Detective Salea testified that muzzle flashes came from that second car, but the state didn't show you that video or go over that with you. And the muzzle flashes are for you to decide when you watch the video. You can watch it and make your own determination from the evidence, because the instruction tells you you can believe any, all, or none of the witnesses and their testimony. And that includes law enforcement and experts. Remember that Detective Salea is the only person that testifies about muzzle flashes from the first car. And why is that? When Detective Alverson came in and testified at great length about muzzle flashes from the third car. Remember when Detective Alverson talked about what can impact what you're able to see in the video, lights reflecting, and pay attention to that video and what you all determine is coming from vehicle 1. Also, pay attention to the positioning of the cars and what was testified to. When Willie Brown came in, he testified that he didn't see a gun, he just heard shots from a car that was supposed to be right next to him. And when the state is showing you the video of what they're determining to be vehicle 1, remember to pay attention, because there's other cars that are also going. Is it possible that Willie heard the shots and that he just noticed a car that was in front of him? Is it possible that those other cars were also involved? Is it reasonable that he did not see a gun or a shooter if the car is that close to him, firing multiple rounds? Mary Harrison testified also, and she did not see a gun or a person shooting either. They both testified to you that someone was chasing Willie Brown down the street. And you didn't see any video verifying that. But you can take all of that into account when determining a witness's credibility. When you watch the video and from the testimony, you know that the first car left the Chevron and returned in less than 2 minutes. That's undisputed. When the casings were located at the scene, they were later swabbed for potential DNA testing, and that was never submitted, so you don't have the results of that. No fingerprints were lifted to connect anyone to that evidence from the scene. You heard about clothing from Mr. Hammond's residence, and there was no testing or any kind of examination done on that. Pay attention, too, to the diagram of the casings. Now, you heard from the state's own argument that their only theory is that Zavante Sampson's car could only be responsible for potentially the first group of casings. And this is the diagram. And as you go through the diagrams, there's individual diagrams for each group, and then there's an overall one. And that's why I went over that with Mr. Kwong, because in the overall one, you cannot really tell the difference between the fuchsia and the red. And why is that important? In this diagram, the red are group 1. And what do you have within group 1? You have casings 10 and 11, and they are fired from a different gun. Why are those mixed in with the casings from Group 1? Doesn't it make more sense that there were 2 guns from one car being fired at the same time, and that's why they overlap? That's for you all to decide, because that would mean that those shots are coming from a different car than Vehicle 1. An uncharged car. Remember that Detective Salea testified that everyone starts running to the vehicles in the Chevron video after Vehicle 2 arrives, which is also an Infiniti. We know that there are only 2 firearms that have been connected to those casings that we've seen. James Denson's firearm that he pawned at the pawn shop and that was recovered and connected to the 2 casings. And then you heard very late about a second firearm that was recovered on Raheem Bryant in November of 2021. That gun is not only connected to the Group 3 casings, but also to the projectile that was found inside of Willie Brown's car. The state wants you to believe that Mr. Bryant was excluded because Detective Salea reviewed the video and he could not have been on there. Watch the video and pay attention to what he said when I simply asked him, okay, what does Mr. Bryant look like? And all he could tell you was black male. And you saw him shuffling. And he said, well, he's a black male. That's who they want you to rely on, excluding that individual. How about evidence? What about any follow-up investigation on Mr. Bryant? What about his cell phone? Did we get his records to determine forensically where he was on that day? No. And why was that not done? Because it doesn't fit their narrative. It makes things messy. If there's not enough evidence against Mr. Bryant or everyone in Vehicle 2 that we've identified, then why is there enough to convict Mr. Hammond? They need you to lump everybody together. That's why we're in trial together. That's the only way to convict Mr. Hammond in this case. But that is not what the law tells you to do. You must consider Mr. Hammond individually, and each count he is charged with separately. That first car, even on their best case, is not there when Suni Bell was shot and killed. They had turned. There's no evidence to support a conspiracy to murder conviction against Mr. Hammond. They're relying on assumptions and speculation. And you agreed to follow the law and base your verdict on evidence and not emotion. And that's what we're asking you to do. To listen, to follow the evidence, and to find Mr. Hammond not guilty. Thank you.
Mr. Terry.
Ladies and gentlemen, I'm in a unique situation, and one that after 33 years as a prosecutor I've never had before, which is that I now have to rebut 5 experienced criminal defense attorneys who have all gotten up here and talked to you. Very rare to have to rebut 2, much less 5. So bear with me. I don't intend to keep you too long because you all have already heard and seen all the evidence, but I think there are some things that they said that do need to be countered. So first of all, one of the things that strikes me, when I was young, and I used to hear this a lot more when I was younger than I do nowadays. I'm not sure what that says about me or the world or whatever it is. But when I was young, I used to remember hearing, my parents or other people say, actions speak louder than words. I'm not sure if you've ever heard that phrase, but that was a common phrase when I was growing up. Actions speak louder than words. A number of these defense attorneys here have told you and talked to you like, well, we don't see any agreement, there's no text messages. Well, of course there's not, they're all standing next to each other. We don't hear a wiretap. Well, of course not. This all happened, this conspiring all took place within that brief period of time while they were in that chevron. Actions speak louder than words. Look at the actions of those individuals. What were they doing at that time? Watch it. It's very clear. The victim's car is driving by, and immediately you see three of them run out to that field to check out what's going on. Including Zavante Sampson goes out there as well to look. And they go out there and they look. James Denson actually goes way across the street to see exactly where it's parking. And their attention is immediately drawn to that car. And then they're going back. James Bedward is so excited running back that he actually trips and falls. And they're all getting animated. You can watch that video. You can sense it. You can feel it. You can see it. They're pointing. They're waving. All of those actions indicate a common purpose. They are all deciding what they're going to do. They are all getting together, and they are all planning to go after that car and shoot and kill whoever is in that car. There is no doubt about it. Watch their actions. Yes, we can't hear what they're saying, but look at Zavante pointing at the car as it's going by. Look at him when he's in the driver's seat going, come on, let's go, let's go, let's go. What is he doing? He's trying to get them to hurry so they can catch up that car and shoot that car. Actions speak louder than words. Those actions, the way they all got there, the way they waited till the second car showed up before they all left together. 3 cars loaded with guns. You saw them all grabbing guns. Actions. They're all getting, what are they getting those guns for, ladies and gentlemen? Just to play around, do a little target practice? They're all arming themselves. They're all watching that car. James Denson, who Mr. Fischetti wanted to say, oh, well, my client, what was his conduct? What did he do? You know what he did? He was the one who went the farthest down there to watch that car. And he came running back to tell him what that car is doing, where it is, where it's going to happen. And if you watch him, he goes behind the dumpster, where they keep all the guns. And he's there right next to Quandarius Hammond, who's holding a gun. They all knew what's up. They all knew the game. They all knew what they were going to do. There's no question about that. Mr. Denson goes back to his car. Why do you think he went back to his car? To get his baby, to get his gun. He grabbed his gun and goes running back and jumps in the car. He was not going to be left out of this. Watch the excitement. Look at the people left behind, cheering him on. Go get him! Woohoo! Watch them. It's incredible. They're all geared up and excited. They're all working in unison. And we say they because it is a they. Yes, you are, under the law, required to consider each one of their guilt or innocence individually. But in this particular case, especially since they're charged with conspiracy, you have to look at their actions in concert and what they're doing together. They were coordinated. They knew what their purpose was. They knew what they were planning to do. They followed they each followed each other out of that chevron, and they went. There were a lot of cars. There were other cars on Hillsborough Avenue. All 3 cars went to one particular car and shot it up. That wasn't a coincidence. They all left from the same spot, loaded with guns, and they all went after the exact same car. Because they had talked about it. They had gotten together. They knew what they were going to do. You see the guns. You see that AR rifle that Jalen Bedward's walking around with. You see the gun that Quandarius Hammond arms himself with. We showed you a picture from his phone the day before with that gun, or with the picture of the gun. They knew exactly what they were doing. And their purpose and their intent was to kill whoever was in that car. And I said to you in opening, and I say to you right now, I don't believe they knew Suni Bell was in that car. I don't believe they were targeting a 4-year-old girl necessarily. But they were targeting whoever was in that car. And sadly, it happened to be Suni Bell. They had a premeditated intent to kill. They thought about it. They went to get their guns. They had plenty of time while they were all sitting there ruminating about the car and what it's doing and everyone watching it. And then when the time came to load up, you can see how quickly they get out of there. And they take off. Zavante Sampson, who's not here, but Zavante Sampson was leading the charge. He was driver of Vehicle 1. Only 2 people were in that car. Zavante Sampson and Quandarius Hammond. Hammond was the passenger. We see them get into the car. We know that Zavante was the driver. He admits to being the driver. We see Quandarius Hammond get in there. He admits that he was the passenger in that car. We watch them take off. We watch them drive off. We watch them as after they make that U-turn and they start to slowly they catch up with the victim. What does Zavante Sampson think is going to happen when he brings a man in his car loaded with a gun and they chase down an individual vehicle? Of course he knew they were going to go there and shoot that car up. Of course he knew that was the intent. Just driving for a little joyride. He comes right back. They clean up and make sure they get rid of pick up all the guns that are left behind the dumpster, and then he drives back over to that little house over there where he meets back up with Quandarius Hammond. His sole purpose was from leaving that Chevron was to track down that car and shoot the occupants of that car. Sole and only purpose that Zavante Sampson had. And Quandarius Hammond was his right-hand man, the shooter. And we know that it was that car that shot. Miss Bradley got up here and tried to make some innuendo or that maybe it was the second car. We know it was that car that shot because we hear the shots on the Power Electric video. You all can watch that Power Electric video and listen to it. You don't even see the second or the third car until after the whole series of shots. So we know that that first grouping in red that was shown to you were the casings fired by Quandarius Hammond, the very first car. And we know that car was shot because we hear the gunshots before the second and third cars ever there. And Willie Brown tells you he gets out of the car. And it was a dark Infiniti similar to his car. And he gets out and he runs. Why is he running? Because the car's getting shot. And that's before the second or third car are even in the picture. There's absolutely no question that Quandarius Hammond left those casings, those very first set of casings that he fired at that car. And they want to make a big issue about Suni Bell still being alive. So, well, he must not have killed her. All we know is that Suni Bell screamed and was saying, "Mommy." Do we know if she was screaming in pain? Do we know if she'd already been hit? We don't know. Was she alive for that brief minute or two or seconds? Yes, because she was making some statement or saying something in the back seat. But either way, whether she was alive or she had already had their fatal wound, the fact of the matter is that Quandarius Hammond with Zavante Sampson were the very first car to shoot at that car and basically disable it for a moment, giving the second and third car time to catch up. And watch that Power Electric video and listen to how fast that second and third car go by. Those engines revving. It's powerful. And then after they go by, you start to hear the other shots. Also, with Zavante Sampson's car, watch as the car's approaching. It's going at a very high rate of speed because it's got to catch up with Willie Brown. But if you watch on that Power Electric video, you'll see the brake lights coming on. Why? Because he's slowing down enough to give his partner time to shoot out the car and make sure he's got time to shoot that car. Those brake lights coming on are an indication clear as day, remember actions speak louder than words, that Zavante Sampson knew what they were about to do. Else, why is he slowing down right as he's approaching the victim's vehicle? Because he knows Quandarius Hammond's got that gun and is ready to go. And when I tell you, ladies and gentlemen, that actions speak louder than words, in this particular case, those actions are shouting. They are shouting at you. I urge you to watch that Chevron video as much as you want. Slow it down. Watch the individual ones. See what they all do individually. But one thing that you cannot, it's impossible to not take away from that, is the excitement, the energy, the building as they were getting ready to get in those cars. They knew what they were about to do. They were about to go on a hunt. Pure and simple. They were going to go hunt down whoever was in that car and shoot them up. And you can see that excitement. Watch it. The people cheering them on as they're leaving. It's crazy. They were about to go take a human life. These people are cheering them on. All for what? Because Willie Brown got lost trying to find a salon for a party? Mr. Gonzalez wanted to make some insinuations that maybe Mr. Brown was up to no good. Maybe he was going to go buy drugs. So what? Does that just mean he deserves to get shot and killed? Because he was going to go to Corey Brown's to buy some drugs? Buy some marijuana? He was going to Corey Brown's for this after party. He couldn't find it. He didn't know where it was, and so he happened to be at the wrong place at the wrong time next to these men. That was all it was. It's as simple as that. And Mr. Gonzalez wants to say, well, I don't know, he didn't even know about the balloon release. Well, he told you, ladies and gentlemen, that he wasn't really very much talking with the family at that particular time, so they probably didn't tell him about it. But they may have told Mary, and maybe Mary thought that's where they were going. Who knows? Who cares? What does that matter at all? Nothing. They just happened to be at the wrong place at the wrong time. And at the time, they were leaving. They were going away. They weren't any threat. They weren't anything. They were just driving away. He was about to drive Mary home. They couldn't find the shop. He'd given up. He tried to reach his cousin, Squeaky. He couldn't get him. And then Mr. Gonzalez wants to say over and over again about, and what's in his hand? That picture in his hand. Look at that picture. First of all, there is no way you can say there was anything in his hand. All right? There's a reflection from something around his hand. And that is why we called Officer Barretto back and introduced the fact that he was wearing an Apple Watch that day. And if you look at the photos that the state introduced with Officer Barretto's body-worn camera, one of them actually catches a reflection from that Apple Watch as he's talking to them. There's nothing in his hand. What you're seeing in that brief, tiny moment is a flash from his Apple Watch reflecting off something. There's no firearm. There's no evidence whatsoever, not even the tiniest bit, that Willie Brown had a gun, that Willie Brown shot a gun, that anyone in Willie Brown's car had anything. There's no casings in that car. There's no casings on the scene that are not identified to Quandarius Hammond at that time when Willie Brown gets out, because Willie Brown gets out right there. And all of those casings were shot by the vehicle that he jumped out of to try and get away from. Not a single other casing from an unknown gun. There was no other gun. Why would Willie Brown be running the way he was running if he had a gun? There's no evidence of that, and Mr. Gonzalez is trying to get you to imagine this. Remember, it's not an imaginary doubt. There's no evidence. If there was, as Ms. Ismer had told you earlier, if there was even a scintilla of evidence that there's possible self-defense, you'd be getting a self-defense instruction. There's not. And remember, what Mr. Sampson was screaming out when he was standing up and all that, that's not evidence. You're not to consider it, and the judge already told you to disregard it. And I would ask you all to please follow that law. Look at the actions of Zavante Sampson, because now I'm going to kind of go through each one individually. Look what he did. And I've already said a number of it, but I'll say it again. Watch that video. Watch how he's paying attention to what's going on, to where James Denson went. Watch how he's paying attention to that. Watch how he gets together. Are they saying he was like willfully blind and didn't see any of the guns around him? There were guns all around him. He didn't see Andrew Thompson masking himself up with a shirt? Come on. You know, the one thing Mr. Fischetti said that I absolutely agree on is that you do not leave your common sense at the doorstep. You take it back there with you. Okay? They all knew what was going on. They all saw the guns. They all saw, Mr. Thompson masking himself. Everyone knew what time of day it was, okay? To suggest that Mr. Sampson was like, oh, I didn't know anyone had a gun. I didn't know what was going on. I was just going to go for a little quick ride. Come on. Use your common sense. That makes no sense. He went out with a targeted plan, and he had his fellow people in the 2 cars behind him coming along with him. And he led the charge, and he took him right there. And you watch those brake lights come on just as he's approaching the victim's vehicle, giving Quandarius Hammond a chance to shoot. There has clearly been some discussion, and rightfully so, about the gun that was later found. Raheem Bryant had the gun. And you've heard that Detective Salea went and interviewed Raheem Bryant, because this gun, which was found months later, I might add, in a whole separate case, who knows how that gun came to be there, who knows how, but Raheem Bryant was not identified in any of the videos from the Chevron. Not one. He was not out there that night. He was not there. He was not a participant. There's no way he could have been charged. Another thing that was a theme from a number of these defense attorneys behind me, and I'm not going to go through each one individually, but a lot of them kept saying, this is a circumstantial evidence case. This is a circumstantial evidence case. Ladies and gentlemen, this is not a circumstantial evidence case. You have direct evidence. Video is direct evidence. That is not circumstantial. What you see these people doing, getting in the cars the way they got in the cars driving, the casings and where they're found, all of that is direct evidence, not circumstantial evidence, as the defense keeps trying to say over and over and over again. You have the videos. You have the phone records. Sergeant Van Heist shows that almost all of them, other than Andrew Thompson's, all of their phones were right there, right at the scene when the shooting takes place, based on those advanced timing records on T-Mobile. Direct evidence. Direct evidence, the casings matching the gun in James Denson's hand. Direct evidence, not circumstantial evidence, direct evidence. Which means he shot out of the car that was being driven by Jalen Bedward. Direct evidence. We see Jalen Bedward get in that car. He admitted, again, an admission from a defendant. Direct evidence. He admitted he drove that car. He drove that car where we see these rifle shots come out and where we see the shots that James Denson fired that are connected to James Denson's gun. Direct evidence. This is not a circumstantial evidence case by any means. Please don't get confused. All of those things I've just mentioned are direct evidence. The fact that they lied, the fact that they all said, oh, we were going straight, we never made the U-turn, and we know that that's true. That's not true. They did make that U-turn. Again, direct evidence. All of this stuff is direct evidence, not circumstantial. Jalen Bedward, holding the AR. If you watch the video, Jalen Bedward he's the one who trips and falls. He's the one who was out there with the group on the field watching Willie Brown's car. He comes running back, and again, in his excitement, trips over a thing and falls, gets up, takes his pistol, puts it back in the car, comes out with an AR. And you can see it. We tried to slow it down for you in the presentation, but not only do you see it, but he admits to Detective Celaya that, yes, that's my AR. When a search is done of his car, there's a box for an AR, no AR. Evidence. We see Jalen Bedward get into the driver's seat. Again, with the AR that's shot from his car. The AR that's shot from the passenger seat, where we know the only person that was sitting there was Andrew Thompson, the one who was masked. So Jalen Bedward not only drove them to do this, he also provided the gun. That's a principle, ladies and gentlemen. He was the third vehicle. He can't possibly say, I didn't know what was going on, because by this point, that car is shot up, it's crashed into a pole. And he still drives by so that his passengers, Andrew Thompson and James Stenson, can continue to shoot up that car, continue to shoot at those occupants, make sure those people are dead. That is first-degree murder. That's attempted first-degree murder. Again, Bedward lied, said he never made the U-turn. Why did he lie? Because he didn't want to admit to Detective Celaya, yeah, I made that U-turn and I drove him right down there so we could shoot up that car, because he was guilty. And he knows it is a guilty conscience. He couldn't tell them the whole truth. Yeah, I got in that car and drove, but I didn't make that U-turn. We know he made the U-turn. We see the muzzle flashes coming out of that passenger seat where Andrew Thompson is sitting. And then James Stenson, Mr. Fischetti gets up here and say to, look at the conduct of the accused. Well, look at his conduct. He's one of the main instigators. He's the one who goes out there and is the one who's really checking out what that car is and who that car is, and he's the one who runs back and tells everyone, and he gets in that back seat and he makes sure he fires off a couple of rounds himself. One of the things Mr. Fischetti, though, I think fails to think about when he talks to you about the location of those casings. Yes, they were west of the vehicle. But use your common sense. Think about how those shots are occurring. He is driving by in a vehicle going very fast, and he's firing out the window. The momentum of that car is going to carry those casings along with the direction of the travel of the vehicle. So yes, those casings are west of the vehicle, and you can see that in the shot, or in the diagram that shows where all the bullets are. But of course it is. Where would you think it'd be if he's firing as he's passing into a car that's just crashed, and the bullet gets ejected, or the casing gets ejected, and as it's ejected, it's going at the same speed as the car. So if that car's going 40 or 50 miles an hour down Hillsborough, that casing's traveling 40 or 50 miles an hour in a westward direction as well. So when it hits the ground, it's also flying that way, because it was with the car and it's thrown out. If you throw something out of a car, it's going to continue that same momentum in the same direction as it's going when it's going with the car. That's why the casings are slightly after. It wasn't like he just had an afterthought and thought, oh, I'm just going to shoot it backwards or shoot in the air. He was shooting at that car as well, just like they all were. And we know he was shooting because we have his gun. And he told those detectives, no one ever takes my gun, that's my baby. I always have it on me. It's mine. And we see him get in that back seat of that car. Again, One of the things Mr. Fischetti said, and a lot of them were saying, was that we keep saying they, we keep saying them. Yes, we do, ladies and gentlemen, because they work together. That is the whole point of a conspiracy. That is the whole point of charging people as principals. To say they are working in concert, they are working together to achieve a common goal or purpose. In this particular case, their common goal or purpose was to shoot up and kill whoever was in those vehicles, or in that vehicle. That was their common goal or purpose. So yes, I am going to continue to refer to them as they in these actions because their actions should be construed together. We were never going to tell you and never plan to tell you exactly who shot the fatal shot because we don't know and we will never know. And that's not something we have to prove. As long as we can prove to you, beyond a reasonable doubt, that these men all work together to achieve that purpose. That is murder in the first degree as a principle. Had Gwandarius Hammond not shot up that car at the initial thing, they wouldn't have been stopped there as long as they were to give cars number 2 and 3 a chance to come up and catch up with them and shoot them. Again, it's a team effort. I talked to you about this in Bordier. When Baker Mayfield throws a pass to Mike Evans for a touchdown, the points don't go to Mike Evans, they don't go to Baker Mayfield, they go to the team as a whole because they were all working together to achieve that purpose. You have the blockers, you have the running backs who take the fake handoff. You have all of them working together for the same purpose. Just like here, these men were all working together to achieve the same goal. And we know that because of what? Their actions. Look at their actions. Mr. Fischetti talked about an act, that you got to prove my client did an act. Remember, the definition of an act is an act includes a series of related actions arising from and performed to a single design or purpose. I can't think of anything more than James Stenson shooting at that car as part of an act, part of a single design or purpose. They're all in the same single design or purpose. Clearly, James Stenson knew what he was doing. Remember, he got in the car where Andrew Thompson is masked. Okay? Let's not forget that, because that is a very strong piece of evidence, direct evidence, I might add, not circumstantial, as to what was in the minds of these individuals. Why are you going to mask yourself? What is the purpose of that? Think about that, ladies and gentlemen. You know what the purpose of that is. Doesn't want it to be identified. Mr. Fischetti wanted to talk about his admitting that he pawned it. Clearly, he had no consciousness of guilt. Look, just because a person is not smart doesn't mean that they're not guilty, okay? Just because James Stenson might not have thought of the fact that a couple of his casings are going to be matched to that gun doesn't mean he's not guilty. It's just as likely that James Stenson thought he had gotten away with it and didn't realize or didn't think or didn't know that a casing can be tied back to a particular gun. Mr. Fischetti talked about a reaction when I was talking about the red light. This is not a reaction, this is an action. He's not reacting to anything. He is acting. He is taking the positive step of taking that gun out and shooting it. That is an action, not a reaction. Please don't get confused on that. He made that choice. He made that choice when he got in that car. He made that choice when he brought along his gun. He made that choice when he pointed his gun out the window, and he made that choice when he fired that gun 2 times at the car. An active choice. An action, not a reaction. With Mr. Thompson, Mr. Sonardi got up and talked a lot about this being a circumstantial case, and I believe I've already talked about that. This is not a circumstantial case by any stretch of the imagination. This is a direct evidence case. You have been given a plethora of direct evidence in this case. Is there some circumstantial evidence? I guess you could potentially say that whether or not there was a conspiracy, maybe some circumstantial, but we have direct evidence in that too, because we have the video from the pawn shop that shows their actions out there beforehand. And if that doesn't show a conspiracy, I don't know what does. These men were clearly acting together. They were clearly communicating with each other, and they clearly went and did an action with the same design or purpose. All of them. There's been a lot of talk about the people not charged in car 2. I hope, ladies and gentlemen, none of you are going to go, well, you know, I believe they did it beyond a reasonable doubt, and I believe they were part of this conspiracy, and I believe they shot at that car intending to kill those people, and I believe all that. But you know what? They didn't catch the other guy, so maybe I'm not going to find them guilty because of that. Please. I beg of you, don't do anything like that, okay? Just because some other individuals may have gotten away with this does not mean that these 5 should as well. There's a big difference between potentially identifying someone and proving it beyond a reasonable doubt. A detective's belief that someone is a certain person is not sufficient. You need more than that. In this particular case, we have admissions from all 5 of them that they are, in fact, that individual that's in those cars. You didn't hear anything that there was ever anyone else who admitted to being in that car, too. We don't even know for sure the driver of that car, because if you watch that video on the Chevron, car 2 pulls up, the driver never gets out. We don't ever see that driver. They're assuming it's Maxwell Bedward because Maxwell Bedward was driving that car earlier in the day, but at that particular time, they don't know. How can I bring a case? How can the state bring a case to prove beyond a reasonable doubt when we don't even know for sure the driver of that vehicle? We also know that a number of people got in that car, but we can't say for sure which one of those shot. In each one of these cases, we can say that each of these passengers shot. We know that. We know it was Quandarius Hammond because we know it wasn't the driver shooting, it was the passenger shooting. There was only one passenger, and that was Quandarius Hammond. Very simple. Easy. Proof beyond a reasonable doubt. In the third vehicle, we know Jalen Bedward was driving. We know the front seat passenger was Mr. Thompson. And we know James Stenson was in the back seat. We have 2 casings that are connected to James Stenson, so we know he fired from that back seat. And we know there was this person shooting from the passenger seat because we see all the muzzle flashes. And they are big muzzle flashes, ladies and gentlemen, which I suggest to you is the AR. And that's where all the rifle casings are too, right where those muzzle flashes are. Because Andrew Thompson was shooting that gun in that passenger seat. He was firing that AR that he got from Jalen Bedward. Also not circumstantial for Mr. Thompson is he's the one who's masking himself. And we see that on video. Another thing Mr. Sonardi brought up was the AT&T phone records. And I submit to you, yes, at 9:09 and 55 seconds, which is about 5 minutes after this shooting, it does appear that his phone is slightly away from the location. Now, again, you heard from Sergeant Van Heist that AT&T is not, their records are not as precise as T-Mobile's. T-Mobile can give you that time in advance where you can know almost to a very general location. That AT&T is more of a, they just give you kind of a circle somewhere. But again, this was 5 minutes after. At the time of the shooting, unlike with all the others, we don't know where his phone was because it's not pinging or hitting off any sort of a tower. At that point in time, 5 minutes after the shooting, Mr. Bedward very well may have been driving him somewhere. But again, the timing of when that comes in is pretty important because it is well after the shooting. We don't know, based on the AT&T records, where his phone was at the time of the shooting. And we also can't say whether that's even accurate because you heard that AT&T is not as accurate as, or precise as T-Mobile. But either way, there's no doubt whatsoever that he is the individual who's masked and who gets into the passenger side of that Chrysler 300, which does not stop. You hear it in that power election driving at a very fast rate of speed. There was no way for anyone to get out of that car. And we know only 3 people get in that car. We know one's driving. We know one is sitting in the passenger seat because we see the muzzle flashes from an AR coming out of that passenger seat. And we know that James Senseless was in the back seat shooting that car. So Andrew Thompson's in that car, regardless of what the phone may say where he was 5 minutes later. We also showed you pictures from that side view mirror where you see there were some scratches on the top of that mirror. Very easily could have been done from a rifle that's sitting out, that's firing and scratching along the top of it. Very consistent. And then Mr. Hammond. What do we know about Mr. Hammond? Well, we know that Mr. Hammond is the one who got in that car, got in the first car, in the car driven by Zavante Sampson in the passenger seat. We know he had a gun. We've seen the gun. We know that the first car is the first car that stops at Lorenzo's, or that catches up with him at Lorenzo's garage and shoots at that car. And we know that, again, because this is very important, and Ms. Ismer pointed this out in her initial closing, and I think you all need to really make sure you remember this. The second and third car haven't even passed Power Electric. They're still way back there when the shots ring out. The only car that is there is Zavante Sampson's car. And the only person in Zavante Sampson's car that could be shooting from the passenger seat is Quandarius Hammond. So we know that he was the first shooter, and those are his casings. We know that Hammond lied about getting dropped off and getting picked up by his girlfriend. We hear the phone where he's on the phone telling his girlfriend, and she's like, "Oh, I already told him I was in St. Pete. I didn't say that." We know that he did a phone search where he was looking for video footage of 4-year-old girl shot in Tampa. That was on his phone, ladies and gentlemen. That was a search. He wants to know what evidence the state had got. He wanted to see whatever video footage there was. Consciousness of guilt. Speaking of consciousness of guilt, don't forget Jalen Bedward, who Mr. Hernandez wanted to tell you was so cooperative. When they finally got his phone, it was completely wiped clean, a factory reset. So we don't know what Jalen Bedward might have looked up or what he had on his phone. Again, Ms. Bradley spent a lot of time on car 2. Knowing who might possibly be in the car is very different than proving it beyond a reasonable doubt. Knowing who fired what weapon in that car is almost impossible. But again, I urge you not to be like, well, they couldn't get all of them, so I'm not going to find any of them guilty. If the state has proven to you beyond a reasonable doubt that these men did what we have alleged they've done, they are guilty, regardless of whether or not there are other people who were helping them, or other people who were involved in it, or other people who were working along with it. It does not matter. What about the other people is not a defense? Look at their actions.
I'm sorry, I couldn't hear you.
Objection, denigrating the defense in improper argument.
Ladies and gentlemen, this was a hunt, an ambush, directed by these men to take out and kill the passengers of a silver Infinity being driven by Willie Brown. Pure and simple ambush. They worked as a team. It was coordinated. One went by and shot, another one went by and shot, another one went by and shot. They were going to make sure that they got these people, whoever they were. It didn't matter to them. They were all going to die in that car. That was their goal. That was their intent. That was their plan. That was what they tried to do. And sadly and tragically, they did do it for one individual, 4-year-old Suni Bell, who happened to be in that back seat, ladies and gentlemen. They worked together, and they are all guilty, as charged, of all of the crimes for which the state has charged them with. And we urge you to return a verdict of guilty as charged on each one of them, on each charge to the highest level proven, which is first-degree murder, attempted first-degree murder, 2 counts, conspiracy to commit first-degree murder, shooting out within or into a vehicle, and discharge of a firearm from a vehicle. Thank you, ladies and gentlemen.
All right, ladies and gentlemen, we're going to recess for the day, and I'd ask you to come back tomorrow at 8:30 in the morning, where I will read you your final instructions, and then you will be able to begin your deliberations. Thank you very much. We'll see you tomorrow morning.
All rise for the jurors.
Please let go and may be seated. Mr. Gonzalez, regarding your client, I'm going to ask that he be kept in that cell tomorrow with the TV so we don't have a potential outburst during the reading of the instructions.
Yes, Judge, I would ask the court to allow me to speak to him in the morning.
I'm not going to, even if he says he's going to do it, I can't trust him not to interrupt it, and I'm not going to let him taint the jury anymore with his statements. Because then there's no other way to address it. He would be the last voice. I'm not going to let that happen.
Yes, sir.
Other than that, there you go, maybe seated. Court will be in recess till tomorrow morning. Thanks.
Court stands in recess till tomorrow. Please exit.
All right, guys. Nope, they still have Hellrider. They still have to do jury instructions. They still have to do jury instructions. So that's going to be tomorrow morning. So they're done for today. No verdict watch. No, tomorrow. They're done for today. We got through closings. And there's our Florida PI Sam sitting right there in the middle with Andrew. If you guys are looking for Florida PI Sam, there she is. Well, she's behind Mr. Gonzalez now, but she's sitting right next to Andrew. There she is. All right, looks like they are going to be done for today. I mean, this stream. They're going to come back tomorrow and do jury instructions, and then it's going to go to the jury. Let's see. Jury instructions tomorrow. Is Vante not allowed back in tomorrow? They'll probably ask him. They'll probably ask him again tomorrow to see what he wants. I think they'll ask him. I mean, I don't think that's a blanket thing. I think they'll ask him if he wants to come back in. You don't think so, Lily Wayne? I think they're going to ask him. I think they'll ask him. He may have changed his mind. I don't think just because he said it today. I think they'll ask him. Well, let's see. We'll find out tomorrow. My position would be I'd ask him again. And if he still says no, then that's fine. And if he says yes, then he comes back in. All right, so we heard rebuttal. We heard closings from all sides. And we're making a determination where we're going next. So we just need a moment. Judge said no, Zavante. He said that He said that when? Just now? Judge said no, he doesn't want him in the courtroom. Okay. All right. You guys heard it more than I do. Judge was very clear he can't be in the court tomorrow. Okay. I totally missed all of that. I was focused on something else. All right, thanks guys. Well, that's why we have chat. That's why we have you guys around. All right, so check it out. We're going to there's there's Florida PI Sam walking out in her black outfit on the way out. So we're going to go check out Jose Soto Escalera. That started today. We're going to jump over to that at 5:30. So we put a redirect on. So while we're going to pick up on that, the morning session, it's about 2 hours. So we're going to go ahead and do that starting at 5:30. So I hope you guys join us over there. We'll put a redirect on, and we'll be in verdict watch tomorrow here, and we'll be covering the Jose Soto Escalera, the unaliving of Tanya Weiss. So we're going to pick up on that in 15 minutes. So I hope you guys. He said that just a couple seconds ago. Lily says, "Yep." Judge said the only Z's in the courtroom would be the bailiff snoozing in the back. Nice. Mike, definitely. Zavante had a disruption, outburst, disturbance, whatever you want to call it. He basically said they were shooting. He shot at me first. They were shooting at us. So that Aaron made a short of it, Mike. Aaron made a short of it. So if you want to just watch the short, Aaron made a short of it. Let me see if I can find it for you. All right. So here's the short. Let me see. Copy link address. All right. Here's the short of Zavante earlier. All right, so there's the short. If you want to watch that, so that's Zavante's earlier. Cool, Mike. Yeah, it's right there. It's a short of Zavante. All right, so we're going to end here. And tomorrow we're going to hear jury instructions, which will probably be, I don't know, maybe an hour. We're not quite sure how long, but then it's going to go to the jury at some point. So we're going to be dual streaming tomorrow. We're going to pick up on Jose Soto Escalera, and we'll be dual streaming. So, cool. Thank you, Mike. And we're going to end here. And so thank you to, let me put us over here. Thank you guys for watching. Thank you to our mods. Thank you to Aaron. And we're going to end our stream here. I'm going to take a quick break, and we're going to go pick up on the trial that just started. So, with all of that, you know I always leave you with, there's one orange baby. Here's the other one. Here's this little boy over there. We got the two oranges. Oh, and there's little Rikers in there. Yep, she's coming out. So, all right, guys. Thank you for watching. Really appreciate you being in our chat. Thank you to our mods. Thank you to Aaron. We have a redirect on. Please join us for Florida versus Jose Soto Escalera. That is starting in about 10 minutes. I'll go ahead and I'll drop the link in here. We're going to cover opening statements in the morning session. So new trial. All right, here's the new trial. Started today. We're going to go pick up on it. So we'll see you guys in about 10 minutes or so. All right. Have a good one, guys. Thanks for joining us. Bye.